Good morning, and thank you for agreeing to participate in this roundtable, whether you're at the table or you're in the back. The whole goal is to try to see if consensus can't be reached on a number of issues. I want to start by saying my name is Mary Beth Peters. I'm Register of Copyrights, which means Director of the Copyright Office. Most of you know the person to my right, who is David Carson, who is our General Counsel. To my left is Bill Roberts, who is Senior Attorney for Compulsory Licenses, and to David's left is Tanya Sandros, who is also Senior Attorney for Compulsory Licenses. Let me start by saying that we did the best we could to accommodate everybody, but obviously with the amount of interest that this subject has generated, we were not able to do that. There were many people from many companies and organizations who wanted to participate, and what we had to recognize is if everybody was at the table or had the opportunity to be at the table, each person could make a 6-minute speech, and that was really not the goal of this exercise. So we hope that everybody feels that the way that we've done this, that they're able to, through somebody who is at the table or through the opportunity to basically at the end of each of the sessions to make a point that hasn't been made, that people will feel that they have had full participation. The purpose of this roundtable is to discuss the proposed rules for notice and record keeping for the statutory licenses under Section 114 and Section 112. I think most people who are here know that 114 provides that the sound recording copyright owner has the exclusive right to perform the sound recording publicly by means of digital audio transmissions. But there are certain exceptions, and there is also a statutory license, and we're focused on that statutory license. Section 112 provides for a statutory license that permits services operating under Section 114 to make so-called ephemeral copies, server copies, that are being transmitted pursuant to the 114 license. What we are not here to discuss, even though we know that it is a topic that's near and dear to many of your hearts, is the proposed royalty fees that were recommended by the Copyright Arbitration Panel that was submitted in its February 20th report. I'm going to tell you that there is no purpose making a comment at this time. It's under the review proceeding that is anticipated by the statute. And what we're here for, and we need all the time that we've allotted to have you educate us on the issues that are related to the notices and the record-keeping regulations that we have to promulgate. I'm going to do a little background. Many of you, but maybe not all of you, know that in 1995 Congress passed the Digital Performance Rights Act for sound recordings, and that was the very first time in the United States that we recognized a public performance right for sound recordings, even though it's a critical right, and even though this right is limited to digital, and it's more limited than even just digital. But it was 1995 that Section 114 was amended to provide the basic right. That provision of Section 114 is a very complicated provision. There is the statutory license. In the very beginning, it was limited to subscription services that basically transmitted performances to their subscribers, but a key piece of it was that you complied with all of the requirements of the statutory license. They're fairly complicated. One of the key pieces has to do with the performance complement, which is a limitation with regard to the number of performances by the same artist or from the same album that can be performed during a 3-hour period. And obviously we're here because in 1998, Section 114 was amended in the Digital Millennium Copyright Act, and it expanded the compulsory license and the liability outside the compulsory license for performances by eligible non-subscription services, i.e. webcasters. Start with the basic. The basic is Section 114 provides that the statutory royalty payments are to be made to copyright owners. Taken literally, that means that each webcaster must pay royalties directly to each copyright owner whose sound recordings that webcaster performs. Even before Section 114 was expanded to cover webcasting, it was recognized that direct payment from each service under the statutory license to each copyright owner would be unbelievably burdensome and, in fact, unworkable. Identifying and locating each copyright owner is a monumental task, and making separate payments would be difficult. And so Sound Exchange was born, and we do have the opportunity of collectives. Before we go to the substance of the first panel, I just want to make two statements. One is, I listened yesterday and I've heard it before, that there's been a lot of concern about listener logs. As you know, that in the reply comments, RIAA took that off the table. We certainly recognize the concerns, and it is off the table. It's over. The second piece before we start is that we basically set out a proposed rulemaking that was almost equal to a notice of inquiry. It was to get comment on how this was to work. So basically, nothing is set, everything is open, and we really want a solution that works for the recording industry and that works for the webcasters. So you should know that what is in the proposed regulation is not necessarily where we will end up. And we're listening to everything you have to say, and hopefully we can come to an accommodation that meets the needs of all. With that, let's start. All of you should have a list of the people who are on the first panel. This is a panel that is dedicated to focusing on the reporting that's to be done in order to determine the allocations of royalties. And since this is not a hearing, each one of us is not going to ask questions. I'm just going to throw out a basic first question, and what we hope is that all of you start jumping in. You can't all jump in together. You have to basically raise your hand and I'll recognize you. Otherwise, we will in fact have chaos. Yeah. Okay. Right now? Okay. Bill just reminded me that we are in fact transcribing this, and that it would be helpful to the transcriber if we went around the room and everybody identified themselves by their name and their association. So let's start with you, Gary.
Gary Greenstein, Recording Industry Association of America.
Barry Kessler, Sound Exchange.
Stephen Marks, RIAA.
Michael Papish, WHRB.
Bruce Joseph, Wiley Ryan and Fielding for the National Association of Broadcasters, the National Religious Broadcasters Music License Committee, Clear Channel Communications, Susquehanna, Cox, basically a lot of radio broadcasters on this panel.
Jennifer Toomey from the Future Music Coalition.
Kevin Shively, Beethoven.com.
Wanda Atkinson, 3WK.
Elliot Mazer, Radio Computing Services.
Barry Knittel, DMX Music.
Cynthia Greer, Shaw Pittman, representing XM Satellite Radio and Sirius Satellite Radio.
Jonathan Potter, Digital Media Association.
Alex McGann, Yahoo.
Patricia Pollack, the firm of Bredhoff and Kaiser, and I'm here today for the American Federation of Musicians, the American Federation of Television and Radio Artists, and the AFM and AFTRA Intellectual Property Rights Distribution Fund, which is the entity that distributes to non-featured vocalists and non-featured musicians.
Fritz Cass from the Intercollegiate Broadcasting System, a 773, 62-year-old organization of college broadcasters.
Glenn Fisher with Web Sound Incorporated.
Okay, thank you. Let me, before we start, mention the problem with the microphones. Because of the audio facilities in this particular room, we were not able to accommodate more than 8 microphones. What it means is that everybody is going to have to share, and we need to work out a way in which it can happen fairly smoothly. So you need to get friendly with your neighbors, and if they don't pass it over, gently take it if you need it. If you need it. Let's start with Section 114 F4A, which basically says the Copyright Office must establish requirements by which copyright owners may receive reasonable notice of the use of their sound recordings under this section. That's one part. And that they also must basically establish requirements under which records of such use shall be kept and made available by entities performing sound recordings. So you heard reasonable before the notice of use, and then the question is, does reasonable also apply to the records of such use that shall be kept and made available? And the question is there authority, or how do you see whether or not the records that have to be kept, that the provisions related to those records must, and our provisions related to them must be reasonable? Anyone want to jump in?
There's a suggestion on the table that there's even a slim possibility that the records requirement can be unreasonable.
There were people who made that argument, not that it's unreasonable, but whether or not the standard is in fact reasonable.
Well, doesn't it...
No, but what's the requirement, whether or not the requirement is reasonable, doesn't implicate whether or not the standard of the requirement is one of reasonableness or unreasonableness. And the suggestion that it might not be reasonable is the idea that it's unlimited, unreasonable, and there's, and I guess if we're focusing on the standard in the law, then let's not go to the application of it yet. Let's talk about whether there's a suggestion that in fact the requirement could be unreasonable. Or if by implication, whether by the words of the statute or by APA or by just standard public policy, we all might agree that in fact a reasonableness requirement is naturally in the law.
All right, well, let's flip it the other way. Let's flip it to, in this context, what does reasonable mean? Yes, Alex?
Yeah, well, I think just for the sake of bringing it to an actual application, my understanding here is that what we're talking about is reporting on the actual use of sound recordings, discrete items that we're going to refer to as sound recordings. If the idea is that each service is responsible for identifying, and only for identifying for the case of, for the sake of royalties and ephemeral copies, the number of times that a sound recording was delivered over a given period of time for each service, then the real key issue here is not the discrete piece of information that indicates the number of times that it was delivered. I think it's understood that that's a goal and that needs to be done. The question is how you identify what a sound recording is. To me, saying whether it's 1,000 times or 10,000 times over a given period of time, I think Yahoo can understand and accept, and I think it makes sense. The question is, how do you identify what a sound recording is? And I think a lot of the discussions about how you get down to that unique item and asset that is a sound recording is what's at issue here. And it's a complicated problem, but I think it needs to be solved universally instead of being done by each service individually.
Let me just ask for some clarification about around the table now. I think what Alex said basically was that, at least from Yahoo's point of view, you accept the notion that it's a goal for each service using this compulsory license to identify each sound recording that is performed and the number of times it's performed, but the question is what information is needed to do that. Is that basically what you said?
Well, just to clarify, when we say identifying the sound recording and the number of times there's no question. But the key is, what does it mean to identify a sound recording? And the difficulty, the expense and onerousness of identifying a sound recording is in fact our issue in the course of this particular panel.
But before someone else jumps in, I just want to see I want to explore that with you for a second, Alex. Are you saying that there's an issue whether you should have to identify each particular sound recording, or is it that you're saying there's an issue with respect to how much information you must provide with respect to each particular sound recording?
I'll put it like this. If we can identify a unique code or ID that establishes that sound recording, and that there's no complexity of data entry and the confusion of multiple pieces of information that will establish uniqueness, then we're comfortable with the idea that, yes, 2 columns of information need to be delivered. One that establishes the unique sound recording and one that establishes the play count. The crux of the matter is that if establishing unique sound recording means providing 4, 8, 11, 75 columns of other information that are, very susceptible to data entry difficulties, etc., that's when we have trouble.
Is there anyone who has a different point of view than that? I know there are many people with lots of point of views, but is there anyone with a different point of view?
Very specifically in response to what Alex said, very significant different point of view, Bruce Joseph, for a variety of radio broadcasters. Let me go back to the question that Mary Beth asked, and in doing that I will comment on what Alex said. Not on his question of how you identify, but on the question of what it is that you need to identify. The standard of reasonableness, I think there's very important guidance in law and practice already. You have exactly the same language with maybe one word different, but a word that's not material to this proposition, appearing in Section 118, for example. The reasonable notice of use and records language appears in Section 118B3 of the Copyright Act and has been there for many, many years. Congress didn't coincidentally take that language and import, and just, like the monkeys at the typewriter with the Ode on a Grecian Urn, didn't come up with exactly the same language in Section 114. The language consciously is the same as the language in Section 118. In Section 118, the practice, well-known, clear in Copyright Office regulations for farther back than I've been a copyright lawyer, has been a sample basis, a sampling of performances to be reported. I believe if you look at the Copyright Office's regulations for that particular, construing that particular statutory language, in Section 253.3, for example, applicable to NPR, you get a period of up to 1 week in each calendar year for performances from up to 50% of the NPR broadcast stations. So it's absolutely clear that the reasonableness standard that Congress was writing, at least to me, contemplates a cost-benefit analysis looking at the relevant industries. More than that, it certainly is understood to contemplate reporting and record keeping of less than a census of each and every performance of a sound recording that is made during the relevant period of time. And I think that's the guidance that you need to look at. And on behalf of broadcasters, I'll say that it's absolutely essential. You will not get census reporting. It's simply not going to be consistent, and we can go into that in greater detail, but I do disagree with Alex on that issue. We can talk about his identification point later.
A lot of people are trying to jump in. Bill was going to say something in response to what Jonathan said, so I'm going to let him go in, and then I think we're all on the same point. I think we just need to identify it. Tricia, you're first after this.
To get started off here, I just want to clarify really what the question is. The statute says reasonable notice, and then it says and records of use. And the question is the word reasonable to be imputed to records of use, or is it just simply records of use? Reasonable notice, one, records of use on the other. Not unreasonable records of use, but just simply no modifier, just records of use. And that is the question that we really are trying to ask.
Let's stick to the point that Alex and Bruce tried to address. That's the fundamental question.
All right, let's go to Patricia.
Well, I wanted to key off something that Alex said, because I think he was right to start with first principles, and the first principle he was talking about is, the real question is, how do we identify the unique sound recordings? What I want to add on to that is that question has to be considered in the light of what the purpose of identifying the sound recordings is and what the purpose of the notice of use is. The purpose of notice of use isn't just abstract or esoteric, or just to make services unhappy, or just to make other groups happy because they're accumulating data. The purpose of the notice of use and the purpose of identifying unique sound recording is to affect the distribution of the income stream to the people who are entitled to get it. And obviously my concern in particular is that 50% of the income stream is to go to artists, 45% to the featured artists, 2.5% to the background singers, and 2.5% to the background musicians. And I think that's got to be the lodestar. What do we need to get to identify unique sound recordings so that we can in fact affect fair and accurate distributions to the to the rights holders and to the performers.
Okay. The order that I had, Bruce, did you already speak on what you were going to say, or because you were next in the list?
Yeah, I mean, at least on this one, obviously, the whole question that Patricia is now raising of what constitutes identification and what the purpose of identification is, I get the impression that David wanted to reserve on, and I've got plenty to say on that.
Okay.
But on the question of reasonable, and what is this reasonableness standard, what guidance can you draw from the law, and are we talking about how, is it each and every report? Yes, I've said my piece on
Michael, did you want to speak on this point?
This is on this point, yes.
Okay.
I'm going to agree with Patricia. The belief that we have to look at the statute as to how it's applied, obviously this works in a real-world situation where we're taking money, distributing it to a large number of people. And so the point I'd like to make is that in many instances it seems sort of ludicrous to spend so much time and so much effort collecting so much information when the amount of money you're distributing could be pennies. In the instance of WHRB, which is a nonprofit educational broadcaster, and I think this point falls for many broadcasters, profit and nonprofit, that have very large catalogs. They play a large amount of material, and they don't pay that much in royalties because in general they're smaller broadcasters. For example, WHRB pays the $500 minimum fee. We play 70,000 to 90,000 unique sound recordings each year. And so if you just divide $500 by something along those numbers, you're basically distributing 0.07 cents on average. I mean, yes, we do play certain songs 20 or 30 times when they first are released, and we'll talk about how that might affect sampling, and I'm sure we're going to get into those points, and I know a lot of people are interested. But my major point is that it seems wrong to apply a standard across the board to certain instances which just don't make any sense. And also for stations such as WHRB, where doing this record keeping, coming up with a way to classify this catalog, which is 750,000 sound recordings. That's how many we have. We have a fraction of those in a database. The rest are just stuck in the library in alphabetical order. To come up with a way to classify those in any sort of digital system, and then a way to come up with reports of use in real time. Because remember, we use actual humans to play these albums on a turntable. We don't use computers. I've actually brought a number of 7 inches, which I can distribute, and I would actually enter into the record an example of some of the things we play, and just the difficulties in trying to figure out the name of the piece, the fact that in many cases these albums were put out, 20 or 30 of them total. Some of these are put up by my roommate. You can try to track him down and give him a check. He'll be extremely happy to get a check. So will I. But I'm just my major point here is that I think we need to look at how this is used in practice, specifically when we go about making these statutes.
Jenny,
Well, I would like to agree with Alex, Patricia, and Michael to a degree, and disagree with Bruce. I think the sampling standard, where you look at what a radio station is playing for 1 week, has reasonableness maybe when you look at radio stations that have a playlist of 50 records that stay on the playlist for a quarter of the year. And we're seeing that happen more and more with the consolidation of radio. That said, when you're looking at stations like Michael's, which actually I've performed on his station before, so it's a place close to my heart, there's a lot more diversity there. And I think sampling was a interim step. It was a substitute way that we dealt with the fact that the data collection would be so onerous that there was absolutely no way to connect it. That said, if I took all of you out to lunch today after this wonderful hearing, and then I went back to my house, I probably could see that charge, that American Express charge, on my computer, which means we're moving to a standard where record keeping is becoming automated in a way that people are getting used to see what's happening a lot quicker than they were before. Waiting for a BMI check a year down the pike from something that was played on his station a year ago, that's a model that we're beginning to move away from. And I think it's frightening how expensive it would be to build an automated system that actually was working around original numbers, as Alex suggested, and people usually just turn their brain off when they think about how difficult that is. But what we've always been saying with Future of Music, considering the fact that we're a think tank and we like to think big, is what is lost when we stay with a system that will balance, which works. It's a square peg for a round hole. It worked with commercial broadcasting for years when we didn't have an automated way to actually collect the data. Now that we have that way, I think just because musicians aren't American Express doesn't mean that we don't deserve clear reporting requirements. And for a final thing, to Michael's point with regards to just the fact that it's only pennies, sometimes the information that someone's playing your song is as valuable as any money you'd get from it. So if I know that Harvard's playing my song, I can go and play a show there. And if people are listening to it in Boston, I can make money from a show. So that information is very, very valuable, and we shouldn't lose it just because it seems like a burden to actually figure out how to collect it. Steve.
Let me try and respond to a few of the points that have been raised. First, with respect to the question that initiated the conversation, I honestly don't have an answer to that because we never really focused on it, although we would be happy to look at it in more detail. But I think from our perspective, our purpose here has really been very simple, and that is to obtain the least amount of information that would enable us to collect and distribute to those recipients who Congress has determined should receive royalties for the performance of their music. It is not in our interest to receive more information than necessary because it would burden our systems. I mean, we have an interest in having it be the least amount of information, and we have laid out those specifically, and I'm sure we'll get into that kind of detail later on in our filings. And we therefore think that our proposal is reasonable, regardless of what the ultimate decision is on the standard of the statute. I do think that Jenny's and Tricia's points were very important, and that is that the context and the purpose is very important in evaluating what is reasonable or what is appropriate under these circumstances. And I think both of them laid out those reasons, some of those reasons, very well. I would point out that 500 divided by 90,000 may not be a lot, but we're not talking just about that. We're talking about the aggregate of information and the aggregate of royalties. So it may be 0.07 cents for Harvard, but the check may ultimately be a lot more than that because there are a lot more stations that are playing that, and therefore having that information from Harvard is important when including it in that check. Also, to respond to Bruce's point about looking at Section 118, I don't believe the fact that the same word reasonable is used in that statute necessarily means that the outcome for that different license for a different copyrighted work in a different context means that the outcome is the same here. I think if Congress really meant for that to happen, they would have just written in that outcome to Section 114. They wouldn't have just used the word reasonable. And I'm sure we'll get to many of the other issues in terms of census versus sample later.
How about Frederick?
When RIA filed their original comments, I thought they really got to the point on page 4 when they said we should follow history instead of hysteria in being our guide. And I think clearly, as Bruce said, history is that in 118, which we've operated on for over 2 decades, sampling is the case, not census. that's certainly very clear for our educational broadcasters in 235.5E, where it says that you can check 10 broadcasters for some period of time. And I think this is even more important because record keeping itself, if it becomes too onerous for student broadcasters with very, very small staffs, all student operated, the record keeping then causes the webcaster to, quote, go off the air. And in reality, the record keeping in itself restricts free speech that these students have. And I'm sure we don't want, you know, the sons and daughters of America to be put off the air by record keeping that they can't comply with. Again, I think the RIA, again, recognizes what are the four main elements that we certainly need to have in order to properly pay Jenny and Patricia, and that's certainly the title, the album, the artist, the labels. That's the kind of information that we need to collect. And then, but we also have to remember, in the case of educational broadcasters, our average station only has, in any given time, 5 listeners. So if you forget the minimums and talk about the small fractions of a cent, maybe a proper fee would be $25 or $50 in an entire year for that. How much cost do you want to give to this college broadcaster to dispense the $25 or $50 out to the very deserving artists? Another question I certainly would love to address to Sound Exchange in particular, there's certainly, in our case with educational broadcasting, we have NPR, which is largely, and you signed a contract with CPB and money got spent or sent to Sound Exchange or RA. How did that get distributed? Or did it get distributed? Are the artists benefited or not? Maybe it didn't get distributed.
We'll find out.
Is that a simple yes or no?
The answer to your specific question is the money has not been distributed yet, but will certainly be distributed.
You're thinking of it.
We're not thinking of it. It's your sarcasm aside, the money will be distributed. There's no question about it. We have been in a process where the rates are not yet finalized, the record-keeping requirements are not yet finalized. Therefore, building a system around distribution doesn't make a lot of economic sense when you have just one very small piece of the puzzle. That would only result in having less or fewer royalties to the people who get it, as opposed to building a system that's going to accommodate everybody and distributing that money. So that's the answer to your specific question.
I realize you're...
Let me just say a couple of other things on the non-commercial. Despite a lot of the things that are said in the filings and even by Michael this morning, I mean, here is a playlist for Harvard that for the next month. So the notion that these things are happening in real time and there aren't people to type in playlists, it obviously doesn't have all of the information we're asking for, but it certainly belies the fact that there aren't people that are available to do some of this, and there are many others that.
If I may be permitted, in preparation of the meeting, and this is Gary Greenstein for the RIAA, what we did was we looked at certain of the non-commercial college stations that either filed comments individually like Harvard or as part of some of the different collegiate groups, or parties that were going to be participating on the panel who did not file comments. And with the Copyright Office's permission, I've got 20 copies for 10 different collegiate broadcasters, which show, for example, KVRX in Austin, Texas, provides a top 39 list for a week of 419 to 426, and they list artist, album, and label.
There is a station, and I've got 20 copies of this, WCPE out of Raleigh-Durham Chapel Hill, which is a non-commercial independent station, provides on their playlist from May 9th, 2002, so this is yesterday, a sheet that lists the program name, the start time, the composer, the title of the work, the performers, the record label, the stock number, which may be a catalog number, and the barcode, which I am assuming is the UPC. This was done yesterday, and it is all here. We've got examples from 10 stations, from KDNE in Crete, Nebraska, from KYSM in San Antonio, Texas, WSIA in Staten Island, KVRX in Austin, KTSW, KTUH, University of Hawaii. And there is an indication that these stations record what they play, not necessarily with all of the identifying information that's needed for distribution purposes, but they will list things such as the top 20 or top 10, and they will do it this week, and they'll compare it with where the song was last week, which means that they keep historical records. There is one non-commercial station which has playlists going back to at least 1996. And you can go back and you can click on a URL and it takes you to a web page for the different DJs, and then you go to the DJ and you see what they played. The information has been kept. These stations are typing it up. They're making it available. There is no need for handwritten logs. And with the office's permission, I can either hand them out now or hand them out later, or at least submit them into the record.
Okay, wait. Yes, you can, but before, there are people whose hands are up. I have on my list Tricia, Alex, Jonathan, Michael, Bruce, Kevin, and Jenny. So we'll go in that order, but here.
I think that the non-commercial stations are, represent kind of an interesting issue or problem here. On the one hand, they admittedly play a very diverse amount of music, and therefore the revenue stream that would be produced as a result of those performances to individuals or small labels that don't necessarily receive royalties otherwise, or wouldn't from like a large commercial simulcast, for example, is obviously very important. And we can talk a lot later about the importance of these revenue streams in the future separately. On the other hand, we do recognize that non-commercial educational stations, for example, have been treated differently in a number of fora and in statutes and elsewhere, regulations, etc. And we have, attempted to sit down with a number of these folks, and I would say I would have to express my disappointment because we reached out to Mr. Cass, and he flat out refused to sit down with us unless we cut a rate deal with him, which we viewed as unfortunate. But we have had some discussions with some of the others who have put in comments, who actually organized, and they included Harvard and others, and I won't go into the detail of those discussions now, but they have been somewhat productive, and our hope would be that we would be able to reach some kind of agreement that balanced those interests. Our deep concern, however, is that any relaxation or any deal that we reached that was predicated upon this difference between non-commercial and commercial would somehow become precedent or be used by the commercial interests and entities that are here. And therefore that is frankly an impediment for us in reaching an agreement with some of these stations. And I'm not sure what the solution is to that, but I'm just, in terms of being frank as to where we are and what we view the issues of.
Thank you. Tricia, I'll add you to the list.
I wanted to go back a couple speakers, I guess, and respond to the intercollegiate broadcasting system. And I see you, Fritz, okay? See your name tag over there is Ron. I think he said really three things, and I want to respond quite specifically to two of them. One was the issue about Sound Exchange, and is Sound Exchange going to distribute the money, and where's the money going, and is it really going to, get out to record companies and to artists? And I think that ought to be cleared up kind of right from the get-go, that there ought to be a clear understanding, at least of Sound Exchange and how Sound Exchange is operating. Money is, the licensing revenue stream is not going to the RIAA, it is going to Sound Exchange. And although I'm sure a lot of people in the room do understand this and are aware of this, there are probably also a lot of people in the room that don't understand this and are not aware of the structure of Sound Exchange and the fact that Sound Exchange is pursuant to an agreement with artist groups and with record companies going to be, and very shortly will be finalized into a separate organization that is jointly controlled by artists and by record companies. So there are going to be, there are now representatives of artists that compose half of the governing board, and those people are certainly not going to stand for money not being distributed, and the copyright owner members of the board would not stand for the money not being distributed. And there's kind of no room in the debate for aspersions on whether the money is going to be distributed or not, I guess, is my point. The second thing he said that I wanted to respond to was about the 4 items. And, I think in all of the comments up to date, there has been a recognition that there are certain fundamental items that have to be reported in order to affect a distribution. And everybody says over and over again, title, album, artist, and label, or various versions of that. And that's good and that's fine, and I think that certainly forms a common basis here. The rub is that there are a lot of situations where that is not enough to identify the unique sound recording and effective proper distribution. And I just want to give 2 examples from our point of view. One is that there are often different background artists and different versions of the recording. For example, the new Sting album is a live album. It contains songs that from previous studio albums, and the session people are not the same. The session people are not the same as the people who accompanied on the live performances, and there are many, many examples of that kind of situation. The other example that I think is important, and one that doesn't get thought about very much, is classical music, where the symphonies and operas are played on the classical stations and get reported as artist Wagner, artist Beethoven, and you have to try to figure out, was it the Cleveland Orchestra? First of all, did they correctly identify a piece? But even if they identify the piece, if you have the piece and the composer, it could be one of many, 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 many different recordings with different artists. And I'm here to tell you that the symphonic musicians out there who play in the Philadelphia Orchestra and the Cleveland Orchestra and all the fine orchestras all around the country really want to see their share of this money. And that's an example where catalog or UPC, the other kinds of data fields, are really the practical way to identify who, which is the orchestra and which is really the sound recording. And I will say just one more short thing and then give other people a chance, and that is, one of the differences here, I think, is that when we're talking about distributing money to the songwriters for the songwriter right, it's so much simpler, because no matter what version of the recording, there is one songwriter that you have to find. But the problem we're facing, and that you folks have to come up with a solution for us, I guess, is that when it comes to a sound recording, there can be many, many versions of a song involving different personnel, and we got to find a way to really be able to collect enough information and a practical way to distribute to those personnel. Alex.
Well, first of all, I'm actually really happy to hear what Patricia said, because I think it does very much drive to the point that I started out talking about. But with the 2 caveats, one that whether or not it is difficult to provide this reporting for a small station or not is not something I'm going to get into, with that caveat, and also with the caveat that what Jenny was talking about before, about the value of knowing how many times a song was played regardless of royalties, is actually, to my understanding, not our responsibility as a service. Regardless of how valuable it might be, I have a feeling at least Yahoo, but certainly other companies, would be thrilled to provide you that information for a small fee. When Jenny takes us all out to lunch after this, and we go to Arnie Morton's, and she puts it all on her credit card. What I want to point out that's really important is that when the waiter punches in the information, he or she is not going to be typing in Arnie Morton's on the corner of 11th and H. You know, the one on the northwest corner, not the one on the southeast corner. And all of that text is not going to go into the system. What's going to happen is that a central organization, let's take American Express, will have actually identified a unique code for that organization, and in fact, for that specific location. The ID will be as specific as it needs to be in order to distribute the funds. What's not going to happen is that Arnie Morton's is not themselves going to say, I'd like my information to be as follows. They are going to receive a code, and that code is the one that they're going to use. In addition, you, as the card holder, are going to receive a code too. You don't get to choose your credit card number, nor do you just use your name and your address each time. Well, I guess what I'm driving at here is this. There is an organization that is responsible for cleaning up this mess. I've been dealing with databases of music information in addition to my desperate attempts to try to figure out classical music for years. We've been dealing with this for a long, long time, and it isn't easy. But what makes it infinitely more difficult is decentralizing it in such a way that every service is responsible for reproducing the same information. The smaller the service, the more onerous the task. It means that each individual organization needs to punch in all of the information that you're describing, hope desperately that we get it right. We find ourselves actually typing text off of the backs of CDs, CDs that frequently use typefaces intentionally difficult to read because they're trying to be cool. And so as a result, we end up trying hard to get it right and getting it wrong. So my proposal is this. We have an entity that exists that was created in order to facilitate this industry, and that's Sound Exchange. They have an opportunity to provide a central database of this information. They have an opportunity to provide unique identifiers that will get down to the level of what it is that you're describing, Patricia, and that is needed in order to properly distribute the funds. If that information is distributed, then companies like ours, and even smaller organizations that don't even do this using computers and software, will be able to generate reports that make sense in a concise fashion and that are not ambiguous. So that's what I'd hope we can try to achieve here.
Thank you. Jonathan?
Alex, thank you for the lead-in. I think that the American Express example is useful because American Express has two sets of clients. Their clients are the consumer who carries their card, and their clients are also the restaurant that needs to get paid. It strikes me that Sound Exchange is sitting between two Recording Industry Association lawyers. And as independent as they may suggest that they're going to be, the Sound Exchange person still hasn't spoken. Sound Exchange officers, or whatever, however they're called, as they're a wholly owned subsidiary of only one side of this table. And their job does not seem to be make this easy for both sides, make this work for both sides. And so that's a striking example of whatever one intends, and whatever one intends the facilitative activity to be, it doesn't seem to be, in reality, in practice, occurring. Second is the interesting distinction between small stations and non-commercial stations, public stations, college stations, and larger stations that has been provided by the recording industry. In one sense, the suggestion is that larger, more popular stations, if you will, many of which are represented by the Radio Broadcasters Council, might play the same number of songs over and over and over again. Well, then sampling might work really well for those folks. But they could also afford to do more. But sampling might work really, really well for those folks. Okay, now let's move aside. Let's move over to the college stations with the very diverse playlist. So revenue streams to individual artists are small, which requires them to track them more closely, but they can't afford it. We've got a real problem here. The guys who are playing the music, which is really diverse, to create, hopefully in the aggregate, modest, reasonable, maybe ever-growing revenue streams for the smaller artists, people who are promoting the small artists, can't afford to build a database, are using volunteer time. And I got to tell you, if I'm a college radio station or a non-com at WCPE or somewhere else, and the volunteer comes in and wants to work for the radio station, he's a volunteer. And saying to the volunteer, here, listen through the headphones and type. 8 hours a day, have a nice day, thank you for volunteering, we'll see you later. That just isn't going to cut it. So we have a real problem. Now, my understanding, and anybody can correct me if I'm wrong, is that in the CPB agreement with Sound Exchange, there's a waiver of reporting requirements for companies that have under 10 employees. My guess is that the Harvard radio station has under 10 employees. My guess is a lot of small webcasters, commercial or non-commercial, community broadcaster or otherwise, have under 10 employees. They might have a lot of volunteers. They got under 10 employees, promise you. Now, how does that permission or waiver of the reporting requirement with their extraordinarily diverse playlist that needs to be aggregated in order to get any revenue streams to the small and medium-sized artists who clearly deserve it, jive with the total waiver? And how does, it's like they're trying to inflict pain on those who can afford it to make up for the waivers of those who can't. So how does this all fit together?
Do you want to respond to that?
First, I'm interested, John, to hear you take up the charge for the non-coms. I didn't think they were any Dean members. I guess so. We've got a very simple response.
Who's we, by the way? Who are you
to the
speaking for again?
NPR. I'm speaking for RAAA right now.
Okay. And it's wholly owned subdivision Sound Exchange.
I think Trish explained very well. If we want to address that, I can address that in a second. But I think the more important issue is, with regard to NPR, if everybody here wants to live with the rest of what's in NPR, let's call it a day and all go home. You want to agree to that right now?
I frankly haven't seen the NPR agreement, except
but
I know
you
that
want to
there's a
use
complete,
the other part.
there's
You want
a
to use the other
waiver
part.
of the record-keeping requirements, which is the subject matter of
Okay.
this roundtable.
If you want to agree to the rest of it, we can all go home. Okay? So,
Agree to the rest of what? Agree to the rest of what?
Given the confidentiality agreements that are part and parcel of most Sound Exchange or RAAA agreements, and given the fact that it's not like you're sending it out, I don't see the handout, Gary. You might have it.
Part of the handout, we'd certainly be interested to see it.
we could certainly discuss what's in there. Okay? The point is that...
Discuss, can you give us a handout? Can you tell us the secret? What are the reporting requirements? We're discussing reporting requirements.
Let me first say that the NPR RIAA agreement is, as are many agreements that you read about in the Wall Street Journal, the terms of which are not disclosed. It was subject to a confidentiality agreement, and NPR has said that they will not, and they were asked by a board member to disclose the agreement. I think the point that Steve was trying to make, and it is a valid one, and it happened in the CARP, and it seems to be happening here, is that people hear a little nugget about an agreement, and then they want to bootstrap onto that agreement without looking at all of the other terms and conditions of the agreement.
Can we get an answer whether there's a waiver of the reporting requirements in your agreement with NPR? And what's the scope of the waiver, and how many stations get covered by the waiver, and how that differs from all the other non-coms?
As I was saying before I was interrupted, what people are trying to do is to bootstrap onto some provisions, thinking that that is all that is required without agreeing to everything else. And I think what Steve was saying was that if you were trying to do the bootstrapping, let's forget about that. But if you were willing to sight unseen, because if you believe that NPR got a better deal...
You guys are specialists in sight unseen and one-sided confidentiality clauses. We've seen that in other contexts. Is the answer yes or no? Is there a waiver of reporting requirements for the public broadcasting stations, and how does that differ from anybody else in this room?
I don't think we need to be responding to those kinds of accusations, John, and I don't think it's helpful. So we've said... Let's let somebody else ask the question. First of all, is RIAA bound by this agreement not to disclose?
Yes, we are. So we are not in a position to reveal anything today without getting a confidentiality waiver.
Is there any reason to think NPR would object to that disclosure?
NPR has, Denise Leary from NPR I've had discussions with, and when she was asked by a board member of NPR, who I'm not sure if they're in the audience, wanted to disclose that deal, NPR's response was that they are not prepared to disclose terms of a confidential agreement because they believe that when they enter an agreement, and if they're then put in the position of making it public, then it calls into question whether or not a deal with them in the future can be confidential. So private parties frequently enter into those types of agreements.
Is anyone from NPR here today? No.
I think to clarify Gary's response is that we really don't know.
Let me take this right off the NPR website.
News for you. The agreement, at least for reporting requirements, is on the internet. I've got a copy right here. I'd be happy to give it to you and you can mark it and enter it.
And that was unfortunately made available on a website that was supposed to be confidential.
Okay, I gather I just heard an acknowledgement that what Fitz is holding in his hand is accurate?
Well, I don't know.
I guess you're legally barred from that.
It's absolutely accurate. It's off of the CTV NPR website.
I got the same
I'd be
page.
happy to give you a copy of it and enter it into the record.
We could even make it a handout.
Right, and I'm sure you'll be happy to know that you're absolutely right, Jonathan. Surprise, surprise. One thing fits all from RIA and under 10 employees. Very limited or no reporting.
Why don't we send that up for Xeroxing distribution and putting in the record?
Gary?
What was disclosed on the NPR agreement was a disclosure, as Steve mentioned, was intended to be for NPR stations alone. But notwithstanding the disclosure, I will comment that is not the entire agreement. It is not all of the provisions. As I mentioned, it is attempting to bootstrap on some provisions without acknowledging all of them. And if everyone wanted to agree to all of those provisions and just go home, that was the proposal. But to just talk about one issue that is in a complex agreement that was negotiated at the insistence or urging of the CARP, we think is inappropriate.
Fair enough.
The issue
For all I
is the
know, you've
subject
got...
of this day.
Stop. For all I know, you got 27 times the value you should have got because you agreed not to have reporting requirements. But don't you agree it's pertinent for us to know if you didn't insist on reporting requirements for the folks who are affiliated with NPR, doesn't that tell us something about how crucial it is to have reporting requirements for the other folks around this table?
First of all, there are very detailed reporting requirements in there. Okay, so I can say that much without and still feel comfortable that we're not disclosing anything confidentially. I can tell you that we will speak to NPR or discuss internally making that available, maybe in an in-camera review to you. Or publicly.
I'm not sure we can do it in camera. We'll think about that. But you can certainly tell NPR that we'd be grateful if they'd waive that.
I do, and we will discuss that with them. I mean, there is a confidentiality agreement, and as much as John wants to make fun of those are typical, and I think virtually every company here that enters into contracts that relate to their business usually have confidentiality clauses.
But we don't usually go to the government and ask them to impose other terms on other parties merely because they didn't get a sweetheart deal.
David, if I may just say that if the Copyright Office is going to be asking two private parties to disclose a confidential agreement that they may feel is relevant, that the Copyright Office consider asking all of the webcasters who filed comments for their confidential agreements with service providers, for Akamai, for streaming service providers, what their deals are, let me finish, what their deals are with companies such as RCS Selector, with Microsoft and Reel, to talk about what they are paying for the technologies to be in this business, what they are paying for access to databases, what they are paying for access to clips, what they are paying to be able to link to Amazon, or what those financial arrangements are. We think that it is a little unfair to put the spotlight solely on the RIAA when there are many other agreements that exist in the marketplace that are confidential, that relate to what companies pay for providing streaming services, and that if companies are investing hundreds of thousands of dollars, DEMA put out that notice yesterday on the Hill about what companies are spending. I think it would be helpful for the Copyright Office to also know what those companies are paying to be in this business, to get at the issue of whether or not this is burdensome.
When the Copyright Office gets in the business of regulating industry in any of those subject areas, the Copyright Office can ask for the relevant documents. When others go to the Copyright Office and ask the Copyright Office to impose regulations on business and suggest what is necessary and required in what is arguably sworn statements, and implicate that or try to impose that on the rest of industry, whether the industry or the rest of the entities, whether they're commercial or non-commercial, public or otherwise, tax-supported or not, and have secret agreements that happen to pop up on websites that other people find, that's an unfortunate circumstance for you. But I think you've got to answer the question, yes or no. Did you waive all reporting requirements for any subset of stations? What's the volume of that stations? And did you also offer a looser set of requirements in another increment for perhaps modestly larger stations, and what's the level of requirement there?
I think we've already said we can't answer that right now. I mean,
What do you have to hide?
I don't know.
Yes
There
or
is
no,
a-
doesn't disclose anything.
We abide by the confidentiality and other provisions of our agreements. And we can get into whether some of those around the table are abiding by, for example, some of the terms of the statutory license. We take our legal requirements very seriously. So we cannot, at this point, do that. But I would like to just respond to the last comment, because I think that there is, the way it was characterized really crystallizes a certain burden-shifting issue, that it's us who are imposing something. For every entity that operates under the statutory license, they do so knowing that they are going to have to give certain records of use. Everybody here knew that. This is not something that is being imposed later or retroactively. Indeed, there were interim regulations that existed at the time that arguably gave very detailed notice of what at least existed at that time with regard to certain services. The entities at this table, despite that obligation, despite being in operation for more than 3.5 years, never made any proposal about what kinds of records of use should be made. So the burden is not on us to impose anything, okay? It is a condition of a statutory license, a condition of law that exists, and it's an issue that needs to be resolved by all of the parties together.
Thank you. Actually, that's a very good point. Statutory licenses typically are more onerous than negotiated licenses, and actually they serve as kind of an incentive to reach negotiated licenses. The list that I have now is Michael, Bruce, Kevin, Jenny, Fritz, Elliot, and Barry. So, Mike.
Okay, so I'm going to go back a bit and then go forward and respond to some comments. I guess I'm going to underline all of this by saying that I think everything we talk about should be looked at in the sense of how this actually operates. I think we speak in theoreticals very often, and in reality this is a specific issue with specific stations, specific songs, and we're sort of looking at it in some cases in a very theoretical light, I think. So to begin with, I'm going to give some background on college radio stations, how they operate, and to respond to some of the comments that the RIAA brought forward about reporting and how much reporting they've been doing. College radio stations in general, and WHRB falls on the end of a larger station with a larger budget and more people. But in general, their programming falls into two kinds of categories. One is pre-programmed shows. These are shows that are thought out ahead of time. College radio stations in general, and WHRB falls on the end of a larger station with a larger budget and more people. But in their programming falls into two kinds of categories. One is pre-programmed shows. These are shows that are thought out ahead of time, programmed, and that's actually what you see in WHRB's playlist that you comment and you actually put in your reply comments and exhibit letter N, which you can find in the record. That only takes up actually in WHRB's case a very small amount of programming, and actually for most stations none at all. And it's actually only WHRB's classical programming. And you can imagine for a college radio station that there are a small number of college students interested in classical music. There are some, but it's a small amount of programming which occurs. The second type of show is a free-flow show. This occurs where a DJ basically picks a large mail crate of records, goes into the studio and plays them in real-time succession with no plan or thought ahead of time, and no record keeping or logging as to what they've played. On WHRB's case, 77% of our programming, or 130 out of the 168 hours every week, are from free-flow shows. So the reporting that you see in our playlist guide is from those remaining 38 hours. So that's all we're reporting. And the reason why we have that information is because we've gone and we've cataloged this on only our classical library. And so out of our 750,000 sound recordings, only 47,000 we have information on. And we've been doing this since the 1960s. We've been trying to enter information about classical music since the 1960s and only have 85% of our classical library cataloged. We began in the 1960s using punch machines, actually, large mainframe computers, and we've been going at it since then. And we still have a small amount of our catalog actually in operation. So that, to begin with, that's two ways that college radio stations broadcast. Another important thing which is brought up is that there are logs of what you call top 30s, top 20s, information that radio stations, college radio stations keep as to the amount of material they're playing most often. This normally comes from a small subset of music, new releases. WHRB in the rock department, we put a group of about 1,000 sound recordings into a heavier rotation for about the first 3 to 4 weeks that it comes out. And we have record keeping on this so that we can report to the College Music Journal every week what we've played, and we report to them as a top 30. So one example, trying to look for a solution here for a real-world situation, is to look at the College Music Journal and the information that they are collecting from college radio stations about how often they're playing songs and what they're playing most often. And they give you a list broken down by different genres from 1 to 100, the number of spins a record has, and where it is on a playlist from week to week. It would seem like this information would be really useful for determining in a sampling way the way to distribute royalties for those artists that are getting a large amount of plays. I still submit that for sampling purposes, the WHRB, the information not in heavy rotation, the things that make up the bulk of our 70 to 90,000 unique sound recordings, really we share very little commonality, I think, with other stations. Those are not being played very often, and I think that even in a census situation, you're going to find that those artists are not going to receive that much money. And again, I think that sampling is going to be the correct way in order to keep the burden down. I've estimated in our comments that we filed with the Copyright Office that the burden for creating a digital service to understand and track all the information that WHRB has is going to cost between $100,000 and $150,000. This is distribute $500 annually. We believe that the burden there is just tremendous, and that there's no way we can really comply with that.
Bruce, yes.
Thank you. I think I'm going to find myself going both backwards and forwards also, and I hope I don't run into myself in the course of that activity. First, actually, I'm going to respond, at least I hope, and it's always at some risk when one responds to an expert, to the Register's comment that it's not uncommon for statutory licenses to be more onerous. That's sort of a chilling thought to me as we sit here with a congressionally mandated obligation to figure out what's reasonable and appropriate. Our job here is not to put the thumb on the scale, and your job here is not to put the thumb on the scale so that people will go off and try to negotiate agreements. Your job here is to figure out what is necessary and reasonable for the function that we're talking about, and that's particularly true in this case, where I think Congress made it very clear that in enacting this particular statutory license, which of course was not a statutory license enacted after the fact where a right had been longstanding and existing in the law, but rather where a statutory license was enacted as part of the overall legislative balance that said this right's going to be created in the first place, that it would be very wrong to do anything other than decide what is reasonable and necessary for the purpose of performing the functions that we're talking about here. Second of all, coming back to reasonable, there are just a couple of points about commercial broadcasters as opposed to non-commercial broadcasters that I'd like to make, because as John said and as Jenny said when she was speaking, for most commercial broadcasters, that's precisely the circumstance where sampling would be most appropriate. And let's put all of this in context for radio broadcasters. We start with the dog. The dog is over-the-air broadcast radio. Then perhaps we get to the tail, although given the relative size of audiences and importance, I would submit it may be more the hair on the tail, and that is streaming. Now we're talking about record-keeping requirements relevant to streaming. And I would submit that if you impose burdens that are large with respect to record-keeping requirements for the hair on the tail on the dog, you're now at the level of even below a flea on the hair of the tail of the dog. And you've got to keep that in context. When you're thinking about what is reasonable, you don't want the record-keeping requirements to drive the radio broadcaster off of streaming on the internet. Remember, its primary business is radio broadcasting, and the internet activity is an ancillary activity at best. That, I think, brings me on the going forward point, and I think given that this panel was supposed to be about the facts that are necessary, Patricia started down this road and some others have picked up. I want to make some comments that sort of first put it in context and then get down to specifics. There are different functions, and Patricia, I thought, did a very interesting job of commenting both, throwing both functions together. One of those functions is the identification function, identification of the performance. The other function is the distribution function. You should not confuse or conflate the two. They are different functions. If you want an example of how they are different functions, you should look at footnote 41 of RIAA's reply comments, where RIAA says, we are not going to give our database to the services. We don't want to give our database to the services. That's proprietary information. But they also go further. They say, we don't need to give our database to the services because the only requirement, and all we're talking about here, is identification. So then you need to look at the question of what is necessary for identification. Distribution is different. Distribution is the responsibility of the designated agent. Identification is what reporting is all about, so that you can tell what sound recording was performed. Now, give an example. It's a little, perhaps I'm not articulating it well, but if you look at, RIAA says, all we're really talking about here is identification, but then you look at their argument for why they need P-line, copyright owner, and you look at Patricia's arguments for why she needs to know who the background artists are. And they say, well, how do we know who to distribute to? The answer there is simple. You know who to distribute to because once you have identified the sound recording that's performed, you have your own database to tell you who to distribute to. You're not going to rely on my listing of the background artist to decide who to distribute to. RIAA and Sound Exchange isn't going to rely on my identification of the copyright owner off of a P-line from an album. That changes over time in any event. They will have their own records, and they've even said in footnote 41 that they have their own database. That's what their database is for. So all you need, and all we should be reporting, is that which is reasonably necessary for identification. Now, what is reasonably necessary for identification? We start with we start with artist, we start with title of the sound recording. We'll give that. Now, what's next? Well, the next most significant point on unique identification is album title. And I would submit that even in Patricia's examples of multiple recordings on different albums, once you have artist, title, and album, you have a unique identification. Now, most of the services before you have said they're prepared, to the extent they have album, and by the way, there's an issue with album, to give album, artist, title, and album. Radio broadcasters have come to you with a specific problem, and that is that they get typically and often get the sound recordings on promotional discs before the album information is available in many cases. And their business traditionally, remember we're talking the hair or the flea on the tail of the dog, has been to not track album information. So then you have to look at the question, and RIAA has brought you no evidence to show why they need more, of how much, what the marginal cost and the marginal benefit of reporting more than artist and title is. How many sound recordings can you properly identify with artist and title alone? And the answer, I submit, is the overwhelming majority of sound recordings. There will be some, yes. Prince will go off and record 1999 a second time with a different copyright owner. But there are ways other than actually reporting album title to figure out how much or how to distribute. You can look at proxies for that. But bottom line, artist and title give you the overwhelming majority of what you need to make the identification. If you've got album, you've locked it. You've got the identification of the sound recording. Distribution, as picking up on what Alex says, it doesn't make sense for thousands of services to be reporting possibly erroneous, possibly accurate information for the purposes of facilitating distribution. That's what the agents database is for. They've got that database. They are the agents of the copyright owners. They are the agents of the principals. Let's have it done once, or if we've got two agents, let's have it done twice, with the principals of the agents who have the information. They know who the band is. They know who the background artists are. They know what the catalog number is. They know what the UPC code is. They know the release year. Let them give the information to the agent, and all we then need for distribution purposes, all we need then is enough to make a reasonable level of identification. And I submit that that's artist and title with album behind that.
Just so we're clear, I just want to make sure I understand what Bruce is saying on behalf of his clients. I am hearing from you that your clients would find it acceptable to be required to give artist and title information for each performance that is played. Is that correct?
On a sample basis.
On a sample
On a sample basis. That
right.
takes me back to the position that I started with. That for radio broadcasters, sampling is enough and should be enough. And others, and if you look at RIAA's comments talking about where sampling falls short, it's not really in the radio broadcast context. So on a sample basis, yes, their position was artist and title. And that, by the way, if you ask the people here who work in radio, is typically what radio stations have traditionally tracked for their primary business, over-the-air radio.
Before we go to Kevin, I'm going to ask over here. Do you want to respond?
Yes, I'd like to say a couple of things. First of all, it is the licensees, it is the services that are in control of what they are performing. The Sound Exchange is not in control of that information. So anything that they are performing would have to be reported to the Sound Exchange, inasmuch as there may be a matching exercise between what is reported and what we have in our database in order to effectuate payment is a different matter. We don't know what you are performing until you tell us what you are performing. The other thing is that the Sound Exchange doesn't have some magical database that can do all of this instantaneously. We need to receive in a standard format the notice of use. We believe that vendors in the marketplace will provide the solutions to the data that we need to effectuate payment. We believe that there are vendors in the marketplace that provide scheduling software, audience measurement, and so on, that can step into this space and provide this service. The Sound Exchange, doesn't want to be in the business of cleaning up your logs. We would like your logs to be reported perfectly. But as you said, Alex, you try your best, but sometimes you don't enter the data perfectly. And for us, we have to expend the resources to differentiate one sound recording from another based on the limited information that we were given in the original determination. We spent an entire year cleaning up historic data. Now, we have some of it cleaned up. 20% of it we could not distribute because we could not differentiate one sound recording from another. That does not mean we will not distribute that money. It means that we need more time to conduct the research to find it. In the meantime, copyright owners and artists who may become dependent on this royalty stream for their income are not receiving their money. Now, it is in an interest-earning bank account, and they will get their money at some point in the future. But just to summarize, the Sound Exchange believes, as we have seen with the pre-existing services, that there are software and data solutions in the marketplace to bring this reporting conundrum to a solution.
The software exists. It's a question of the data that goes into the software, and I am so happy to hear that you guys have a database that's, I don't care whether it's 20% or 80% accurate. If it's 5% there, that means you guys are building something central that is incredibly valuable to facilitating this industry. Let's share that process instead of saying that we're going to lob textual information over a wall, which anyone in the information architecture world would say is a horrible waste of mutual energies.
One thing I would like to say, and Alex, you made a point earlier to Jenny, that for a small fee, you will provide the information. And we're not asking for a fee because we're not in the business. Sound Exchange is not in the business of providing data. Ron Gertz, who is sitting in the audience, has a company and testified in the CARP about his Songdex database with millions of sound recordings. That was in our filing. It was quoted. It's also part of the public record to the CARP. If companies like Yahoo or 3WK or Beethoven.com want access to a database, I propose that the government not be in the position to take property that copyright owners may be paying for, because remember that a database, if one eventually exists, and as Barry said, it does not exist, copyright owners are paying for that because it comes off the top of their royalties. RLI, RCS, Loud Eye, these are commercial enterprises, Muse, AMG. You can go and negotiate with them to get access to data.
But we won't have the same numbers.
Alex, it is commercially available. I propose that when these regs come out, there will be providers. Maybe Mr. Gertz wants to sign up clients today because he does have those millions of sound recordings. But I propose that it is not for you to demand that some other party pay for a database that you may get to use. Leave it to the market, because that is how these solutions will come about.
That's okay. That's fine. Let's do that. Mr. Gertz can get right here in the middle of the table as long as you guys and we and everybody else say that number, a number, not text, that number that is used to identify uniquely a sound recording shall be accepted by everybody as the global identifier. When you go to a store and you buy toilet paper, the thing that is reported, the thing that indicates the price, is a UPC that the industry worked out together in order to avoid confusion. Let's work together to make that happen. It's not an issue of the money and the cost. Maybe you're right. Maybe you guys shouldn't just do all the work and provide it to us. But can we at least arrive at a conclusion here that instead of passing text back and forth, we'll all agree to a number? That's all I'm saying.
Okay, I'm going to basically, Bruce, you've spoken and some people haven't. I'll come back to you. The order now is Kevin, and then Jenny, and then we'll go to Frederick, Elliot, Barry, back to Bruce, and Cynthia. Okay.
Thank you. As a small commercial webcaster whose entire dog is streaming, it may be just a puppy, or maybe freshly born puppy, or maybe even not even born puppy, I don't know. But all we're really asking for at this point is to allow it a chance of being born, a chance of growing up to be a healthy dog. And I think that's in everybody's best interest. But there are a lot of things I'd like to respond to. First of all, in terms of the burden of proving exactly what sound recording royalty should be distributed to whom, you know, the way we look at it on our end is, as a radio broadcaster, when I'm a billing agent, when I'm billing a client, it's my responsibility to install the systems, the billing systems, and to pay for those billing systems, and to set up a system in which I can keep track of what is owed to me. It would be very unreasonable, and I certainly would not have very many clients if I asked my clients to keep track of the information that they owe to me and make sure that they're paying me. So to start off with, I think that's an important distinction right off the bat. In addition, it's also been suggested by our friends over here on the RIAA that there are some stations out there that have varying degrees of auditing systems in place. I would submit that to any degree that any station, large or small, is able to report some information does not suggest that that information is required by the statutory license. That the statutory license itself is not saying that it needs to go that far, that deep, drilled down into the data. Our position as small commercial webcasters, that I've talked with and worked with in getting an opportunity to speak before this panel, all feel that are in agreement with Mr. Cass that it's the ASIL, it's the artist, the song title, the album title, and in some cases the label. That would clear up everything. If we basically provided this information if you look at it basically, this is basically our inventory that we are purchasing the right to use to build our business. We're purchasing it at a wholesale level, obviously. And this inventory that we're purchasing, if I provide in any given reporting period, whatever that reporting period is, these are the pieces of music that I purchased during this time to use. That should be complete enough to be able to take that information, compensate the people who I purchased that information from. Then anything that I do with that information, if I am able to stream that to 100 people or 1,000 people or 10,000 people, that is my business acumen, my marketing ability, my brand name that got me that ability to present that before that number of people. And so I'm simply asking for the opportunity, and I think it's our position that the statutory license provides us this opportunity to purchase this at a fair market price, that we can compensate the artists and the copyright holders for the use of that material as we see in our business model. I would also like to point out, just because I felt compelled to respond as someone obviously streaming classical music with a graduate degree in classical music from a conservatory, if you ask me who the artist is on the Tannhauser Overture, I'm not going to tell you Richard Wagner. I will tell you the symphony or the orchestra that's performing. I could probably even tell you the conductor that is doing it. This is information that all of our DJs, our live DJs, which are taking requests on a live basis, playing music on the fly very often, have and can keep track of this artist, song title, album, and label. And
the precursors in the pre-existing services didn't and couldn't and weren't as sophisticated as you, and a lot of people aren't as sophisticated.
Well, that may be. I'm just saying I can only speak for my company and what my company's ability is to do.
Unfortunately, we're talking about a statutory license, and that means a one-size-fits-all, and that is part of the problem here. I think that if, for example, you were in a position where you thought that, well, gee, the requirements here, I can give, better data at lower cost or something like that, you would have the option to negotiate outside that. But we are collecting data not just from you. Believe me, we wish everybody was like you in terms of being able to get that kind of data, but it's just not the case. And that's just one of the realities of the statutory license. And
well, I would suggest
that
a statutory license does not suggest that it has to be a one-size-fits-all. A statutory license could indeed have different levels for different categories or different opportunities based on whether or not it's more amenable to the broadcasters to provide a sample because it fits more into their business model. And I don't think that the statutory license anywhere suggests that it has to be a blanket approach to anything. And in addition, I also would go so far as to say, to suggest that the government would put us in a position that we would have to go out and spend more money to hire or to contract systems to get the information. I mean, I have to ask these companies where are they getting that information? I can only assume they're getting the information from the information that the copyright holders are providing with their recordings. I mean, the copyright holders are printing that information on the CD or whatever, if you're, as you've pointed out in your exhibits and your comments, and so you obviously have that information at some point. Whether or not you're communicating between the people that are printing the CD and Sound Exchange is another matter, but that information is certainly being provided at some level by the copyright holder and the record label.
But again, you need to know what you're playing. I mean, even if we had a database that had all that information, it wouldn't tell us anything about what you're playing. You still need to provide us enough information where we can,
But
where that
22
matching...
pieces of information?
I don't
That's
think that...
what we don't understand.
I think
That's not
I
correct
think
either.
I just offered to provide him.
Well, I was just going to say, I
offered to provide
heard
you
3 or maybe 4 elements.
3 or maybe 4
I mean,
elements.
we haven't got to what are the absolute critical pieces that you have to have going in that question. But I think that, yes, you did agree that you have to tell him at least what you're playing in sufficient detail, and the question is, what's the sufficient
I mean, if
detail?
I'm purchasing inventory, I have to tell, I have to have a communication with the person I'm purchasing that inventory of what that inventory is, obviously.
Mary Beth, Sound Exchange and the RA does have such a database that was mainly created off of the residential license agreement and mainly created in part by DMX Music. And they have a database that has 12 parts to it, of which they, by their own request and of the kindness of the hearts of DMX, have expanded to by 3 points, by 3 areas. And we can go through that chapter and verse. And I can tell you, I've been contacted personally by someone representing RIA saying that they have such a great database, they're trying to commercialize, they're trying to commoditize it, quote, close quote, and would I be interested in buying it? And I said I would be, but I damn well would consider it my intellectual property, and I better get some money back for developing that database.
We'll come
I know
back.
I'm on, I jumped ahead.
I know, we'll come back. Jenny.
Call it exuberant youth.
We're delighted that you have exuberance. All right, 2 side points. First of all, I'm concerned about the moment where you said, okay, John, if you agree to that, then we can take this thing out of the room, because that's exactly what this roundtable's not about. It's not about 2 people getting together and fixing this. It's about making sure all of these points get taken. So I just hated hearing that, even as a joke. Well, let's go back and read the transcript. Okay. But anyway, the last part, and the second thing is with regards to the flea on the dog, which is too great a metaphor to let pass, we have to remember that the flea carried the plague. And just to assume that the dog is the only dog in the room now doesn't mean it's going to be the only dog in the room future, or even if there's going to be a dog, there might be a whole lot of fleas living in the room, and we might like the fleas. So I just want to emphasize those 2 points, and that's why it's so important that we listen to what the webcasters need. Which goes to my overall point, which is we don't want onerous reporting requirements. We want the broadest diversity of webcasters and actually suggest the creation of 3 and 4 different licenses that would allow that to exist in this testimony, or it's not testimony, but we wrote up some statements that we'll hand out. We have to keep in mind what the ultimate goal is here. And that's the most information collected, most accurately, within reason. And having that information benefits everyone. So the burden can't fall just on the webcasters for creating the database. It can't just fall on Sound Exchange, and I think the whole idea, what Alex is saying, is everybody needs to get together, build the automation database, which really isn't a luxury. And that if there's one thing you come away from today, artists shouldn't be forced to choose between access to an audience and the ability to get paid. Those are not mutually exclusive things. Right now it's food and water. We need to figure out a way to build something where they can get the right amount of both. And I emphasize that the automation would ensure compliance. If you actually look at the kind of people that are volunteers that work at radio stations, a lot of people call them train spotters. They do it because they love the music and they love the artists. I worked at WPRB at Georgetown, or GTB at Georgetown 15 years ago, and that station only played to the cafeteria. I would spend 2 hours programming a station that some people who were eating at 2 in the morning might have heard. And we reported all that stuff. So the point that I'm saying is that if there was a system in place that DJs could trust, that was easy to use, there's no question in my mind that they would rush to put this information. I mean, can I look at those singles for a second? Look at these singles. They've got notes about why these songs are great written on them by the people who are playing them. And every single small radio station that I go to has these notes. So the idea that these people wouldn't type in 3 bits of information into an automated database is wrong. Will they be able to get all 90,000 things in 12 weeks? Yeah, well, all right. No, they won't be able to, but we start with what we can do. We start with the biggest database we have, and then we begin to add to it, and we have some way to authenticate it. The final thing I want to say is who's responsible? Is it just Sound Exchange? I don't think so. It's probably everyone. If they've got the best database, they have a huge incentive of actually building this because they'll actually be using this data and they're asking for all these categories, so they have a real incentive to do it. And I want to say also, disclosure, Future of Music is on the board of Sound Exchange, as is AFTRA, as is the RAC. There are people within the board and the AFM, and we are all working together to try to make it more of a representative organization. That said, this is not a very good showing. And this will only get fixed when the perception is removed that that organization is within the pocket of the industry.
Thank you.
Here.
Fritz.
Well, I'm delighted to hear that Jenny is from college radio, and I think she's in many ways described the 700 to 1,000 college radio stations that are out there with a $9,000 average budget and $500 annually invested totally in webcasting. So at this point in time, the regulation, or lack thereof, and a system that can be purchased and utilized by volunteers, student volunteers like Jenny, for $500 a year, stands between us and our free speech and our educational opportunities of the sons and daughters of America. And it's very, very critical that these things be so simple that a student volunteer can in fact comply. We've been doing it for years. This is the second time the intercollegiate broadcasting system is at the table. We were here with 118. Fortunately, we and the small broadcasters weren't excluded from the rate process in 118. But the bottom of the line is we have the history. It worked. Under 118, we have a sampling. It's set up in 235.5E. It works. It's affordable even by college broadcasters and volunteers that may only be broadcasting to their cafeteria, but also have the educational opportunity to learn how to stream, to learn how to use the internet, to learn how to focus on the different technologies that are involved. It would be a very, very, very bad mistake to put hundreds of college broadcasters off the air and not allow hundreds more to come on the air because the rulemaking and even the rates are just too much for a station that's got $500 a year to spend. I also am very happy to hear about the possibility of RIA sharing the CPB agreement, because the Copyright Office, as you know, is required to consider private agreements when you're setting reasonable rates and reasonable regulation. And so it would be very helpful if those agreements weren't secret, especially when they're involving public funds, which the CPB agreement does.
Going to go there. Elliot.
Hi, I'm Elliot Mazer. I'm also from College Radio. I
All right.
helped found 2 college radio stations in the New York Metro. I also produced records for many years. I'm a copyright owner and holder, and I collect royalties. But I am really with a company called Radio Computing Services, and our goal is to help the radio stations, the webcasters, comply with whatever changes are created by this new law. We're not taking any position about the data. We have over 3,000 clients using our software scheduling product in the U.S., and Selector is a database management program like Access or SQL. It's not we don't supply data, we supply a tool to many of the broadcasters. In fact, in this room, we have representatives from Clear Channel, who's our biggest client in the U.S. We have many other clients on either side that use our software. And we have, our commitment is to help our clients modify the software and make it as easy as possible to comply with new database requirements. We have a product that in fact is used by Barry's company, DMX, called Selector Enterprise, which is an enterprise-wide database product that consolidates the songs from many, many channels. And this is the beginning of a product that can allow an easy reporting system. Our idea is to set up a selector enterprise database with Ron Gertz or with Sound Exchange or with a body that's defined and help create a massive database that radio stations and webcasters can reach through the internet and have that database and our tools do the matching and create the required reports.
Thank you.
Am I hearing this right? Am I hearing that you have these systems that you've worked with DMX to build the database, which worked with the RIA to build the database?
No, sir. No. DMX uses our scheduling software to program their many, many channels. They have another product that runs on top of that consolidates the data within the DMX systems.
Which the DMX systems were built in coordination with the RIAA.
I wouldn't be able to answer that question.
That's not correct. Was built,
I thought that's what
was built as a reporting mechanism under the residential agreement in accordance with the guidelines from the Copyright Office.
Again, it's important to distinguish between the software and the data.
Absolutely.
And the key here is not actually how many wonderful pieces of software are out there that allow you to generate reports. The key is how can we actually make sure that we're all speaking the same fundamental electronic language.
With the fewest words possible.
With the fewest words possible.
You know, it may be possible to see if DMX will make its database available to everyone here.
Would you guys, let me ask you this question. Hold on, let me just ask this question. If I know that DMX has keys, they have database IDs. If there was, and forgive me for not knowing exactly, but if there was in fact an entity in your database that equated to the industry understood sound recording, would you guys be willing to say that if we reported and said whether it was, we'll get to the issue of whether it's sampling or not, whatever, that X number of plays of a given song actually identified by that number, would you guys be willing to say that would be a clever and clean way of providing the information that you need? Because that would be great.
Alex, and Barry can address this, but I think what you're asking for is something that is impossible to create due to the large number of copyrighted works that exist throughout the world and that can be performed.
Yeah, then how can we create them?
So
we should create it 1,000 times over?
Actually, we're not asking you to create a database of all the works in the world. We're asking you simply to report what you play.
We're Yahoo.
Alex, no, there is a big difference. Harvard Radio made the statement that they have 750,000 works. We're not asking for all of that data. They perform 70 to 90,000 in a year. That's what we're asking. They are in possession, Yahoo's in possession, DMX is in possession of what you play. There is no universal database.
So I get a request.
But let's make one.
I get a request.
Retroactive will be played then, is that correct? Well, no, that's going to be another question.
I would ask Elliot his experience. I mean, Selector even today has a number of fields for any given performance, but I'd ask Elliot what, in his experience, radio stations have traditionally and typically track with respect to any given composition. It's title and artist, right?
Yeah, the radio stations, and this is, the tradition of this creates a problem for creating a universal database, because every radio station that adds a new sound recording to their library manually enters two fields, the name of the song and the name of the artist. They do not use the timing supplied by the record company because radio stations adjust the timing for their own purposes, and that's it. Even if the radio stations would like to add an album name, but most of the music that's received at radio today is not associated with an album. There was an electronic distribution of a new release recently by one of the major labels, and I think it's the first time that a lot of metadata was supplied by the radio stations to a broadcaster or to the broadcasters. And I personally see from our relationship with the radio stations and the labels the possibility that the labels will start delivering more data to the radio stations, which is helpful, and our systems will help deal with that. but it certainly doesn't answer the big question of how you deal with every sound recording prior to these new changes.
Elliot, are you saying that right now the entries are limited to artist and title of the song?
Oh, no, there are 26 fields, I think, in Selector, but...
What stations enter?
But the stations
Right, so the
enter...
stations enter artist and song.
That's correct.
Artist and name of song.
That's correct.
And that generates an output.
Yes.
And how accurate is that output?
In terms of what, sir?
Just in terms of the aggregated, for example, if I put in an artist and a song, what's the probability that your output from that, with the other 26 fields or however many are in your system, will be an accurate output of which album, which work, which, what's the probability of accuracy?
It'll be accurate of which audio file the database is associated with. So if they add Neil Young Heart of Gold and connect that to an identifier in a digital database, it will report when it's played that it played that sound recording.
But when I'm hold on.
Elliot software doesn't output other fields because you have to link it to another database. And that database
Our software can output any fields that the client wishes to, but to emphasize the point that the tradition in the broadcasting industry with our 3,000 clients is that the only data that they enter, what data that's related to the requests from the RAA, would be the sound recording, the name of the song, and the name of the artist.
And how many times have they screwed up Puff Daddy and Prince? I mean, for God's sake, the number of artists who seem to be focusing on just how to make my life difficult is incredible. Okay, they change their names every week. I'm of course kidding because I love them all, but the point is that this is an incredibly difficult task. All the more reason why instead of each of us trying to do it individually, it makes sense to do it together.
So I think because it's so difficult, we need to have 18 fields of data instead of 2 so we can have better accuracy.
Well, I believe that was sarcasm, right?
Oh, I'm sorry.
Because yes, that's exactly true. It just makes it all the more difficult. And I guess it's like this. You look at other industries. You look at the people who stock the shelves in a supermarket. I don't know how many product codes there are in the world of supermarket items relative to how many songs have been produced, but I'm guessing it's a big number, and it's really complicated to separate toilet paper out from facial tissue, but somehow or another, because they want to make a lot of money, the entire industry, the suppliers, the consumers, and the retailers have figured out how to arrive at a universal system for achieving this. So I understand that will take time. I understand that there may need to be interim measures to accomplish it, but why are we saying from the outset, you know what, it's too hard. Let's keep doing this thing as confusingly as possible. Let's keep rolling it up on sheets of paper and faxing it to each other, because that's so digital millennium to do it that way.
I mean, Alex, let's let the free market, let's do away with the compulsory license and just let the free market work the way that it does in other contexts.
No, what I'm actually saying is that within the context, I'm saying that within the context of the compulsory license, we still have the wiggle room to allow just what you're saying. I'm not saying that I think it would be great if Sound Exchange, who is in fact responsible for the distribution of the royalties, which is the purpose of this conversation, could be the source of that information, but I'm also okay with the idea that Sound Exchange merely accepts a standard. That's also okay. What I'm not okay with is the idea that we all speak a similar but not identical language, as we will not properly be communicating with each other. Obviously, that's an example that we can see right here, but the problem is that in the world of technology, and more importantly, in the world of money, that's what you need to be striving towards, is incredible clarity in communication. And there are experts in the world who actually focus on doing that all the time, and I'm not sure that those people are all represented very clearly here. So we should work with the people who know how to pass money and information around and work towards a solution that way.
Did you want to add anything?
If everybody in the room wrote down the name of the band Boys to Men, I'd like to see, we at one time counted 46 different ways of writing that out. Manual entry at a record company or a radio station is the same. People make mistakes. I think the good news is that the recording industry, the labels that I know that I see are working towards the inclusion of good numbers and good database structures within the context of the CD itself. And it might be possible in the future for software to go put a CD in a machine and have a data record extracted from that CD that properly spells Boys to Men and gives whatever numbers are required by the copyright owner for reporting. That's something I believe the labels are working on. I know 2 labels that really want to do that.
Right. Thank you.
Elliot, there are many things that are possible in the future, but the situation that exists today is there is no such database. There is not a unique identifier for each and every sound recording that exists in the world. There is no central place to go and get the metadata for that information. The only thing the Sound Exchange can do is receive reports from the users of the music, and then we match it to our information to pay out that information. We don't know what you are performing until you tell us.
You have the same problem that everybody has, basically. That's
right. The Sound Exchange is the Sound Exchange is the agent of the copyright owner. The easiest way to get the information that they need for distribution is from their principals who have that information, the copyright owner, not from the service. May I finish? The services. I agree that the issue that we should be discussing, and the only issue that we should be discussing here, is not what is necessary for distribution and who the copyright owner is and how we figure out who the copyright owner is. It is what is necessary to identify the sound recording that has been performed with reasonable accuracy.
Okay, there are a number of people who are on my list, and we have a couple of questions that we really do have to get through, and it is now 5 after 11. And we need to open it up to the general audience. So, people on my list are basically Barry, Bruce, Cynthia, Patricia, and Wanda. So, let's go.
Okay, great. Thank you very much. Steve and I will tell you, since you made the statement, it really doesn't have to do with today, so I'll do 8 seconds and move on. I would gladly do away with the compulsory license tomorrow because I can feel in the air Mark Cimino of Sony in this room, and I'd rather have him gnaw on me for a few hours a day and get a deal that we both can walk away from and don't like than have a third-party panel give me a deal that I can't live with. That aside, I'm going to go around the room, a little left, a little right, and we'll mix this thing up a little bit. Came out of college, worked at a broadcast place, feel very much your pain. It's a great place for people to learn a lot about music and for people who appreciate music, and I thank you very much for that. I'm going to just talk about DMX because it's not my responsibility to put burdens on other people or to walk in their shoes since I have a pair of shoes that I need to fill for myself. DMX, if I could, is a mixture of 2 companies, merged last year, May 18th, a company called AEI Music Network, Inc. and DMX Music, Inc. AEI Music Network, Inc. was founded 30 years young, first company to walk away from the term background music, create the term foreground music, and with that started to deal with record labels through, I'm going to keep it short. Okay, you looked at your watch? When people look at their watch or fall asleep, I think it's time to move on.
I was just calculating.
Okay. Started by dealing with record companies and was the first company, to the best of my knowledge, in the world who actually secured license agreements directly with the labels, and today has license agreements with nearly 1,500 labels and distributes royalties to those labels every 6 months like clockwork. So I'm going to jump to one side that was mentioned before. If, in fact, we didn't pay royalties at that 6-month period and waited for 5 years, we would get a lot of cease and desist and cancellations. I'm not sure why the record labels, the artists, feel that that kind of float is acceptable. And to that point, move across over here. Sting Live. Tricia, feel a lot of your pain on this one, but Sting Live has an album title of its own. And it's very easy to pick up what that title is versus The Rose or anything else. And so, therefore, I think that shouldn't be a problem. It's interesting that when we look around at all the rights organizations, and God, I look at them throughout the world, that they sell something that they don't really know what they're selling. Now you say, I go in to buy a car or toilet paper, I know what the heck I'm getting. I can get cheaper and falls apart, or I can get a car that runs faster. But I know what I'm buying, and I think it's not much for this group to ask the RA to tell us what we're buying, or other rights organizations, by giving us a database for which we can reply back to, a standard, systemized database that works for everyone that's paying under this compulsory license. Now, let's move to, as we go through the history, DMX started a residential service, and under a CARP proceeding was told to pay royalty fees under that proceeding and to furnish certain information in a field that was agreed to by the Copyright Office. Those fields, I don't think, differ too much from what we're talking about here today, but if you take a few minutes and walk through, we may be able to get through the crux of most of these problems. Name of licensee, doesn't bother me, DMX, Harvard, WHRG, I mean, that seems to be simple enough. Number of channels, in our case we have a number of channels, so we'd say which channels they are. Track and title as it appears on the label, doesn't seem to be too hard, that's the music we're playing. Should be able to be tracked back by both Sound Exchange and anyone else that's paying the royalties. Name of the artist, we used to like to refer to him as formerly known as Prince, that way we knew it was he. Puff Diddy, Puff Daddy, it all works the same for us. Album title, now again, this is very interesting because we work so closely with the record labels. In many cases, such as radio, we get releases far before they're made available to the public. And we've taken that burden upon ourselves because of the way we deal with the labels, both majors and Jenny independents, that where in most cases on the independent side we get CDs, not singles. But where we get singles, we input the single information and then wait for the album to be released and then go back, or if we get the album up front, we put it in. So there is a piece where you go back a little bit later, and that has not been a problem for us. Marketing label is number 6, and that's just, I guess...
David said go ahead.
That's right, I'll tell you.
Here they are. Okay, I forgot that you were talking when we broke, and I just looked at the unchecked list.
We'd like to think about, the song Unforgettable, but I guess we can't in this case. This is.
We'll go back to youthful exuberance.
That's right.
All right, where's your gavel?
I don't have one. Okay. We are starting, and we're back to Barry.
Okay. And I won't go back to the very beginning, but we were talking about a reporting system that is in place already having to do with the residential side. And the last section that I was on was 6, which is what is referred to as the marketing label or the record label. 7, catalog number, which comes from the album. The 8 is the ISRC code, which we don't give. There's software that you need to be able to give that, and the RAs has said that that's not a problem. And I think when you have that kind of information, it addresses all the needs of Sound Exchange as well as all the other people in the room that should receive the royalties from their works being used. And I think that's the point that we want to make, that we seem to have a tendency to bicker or over definitions of things. When I looked at this, the thing that came out to me most importantly is what are we here for? To get a uniformed reporting system. We have a system that's being used in another section. Why shouldn't we keep that as being uniform. It addresses the needs of sound exchange, I believe, I'm speaking again for DMX, addresses the needs of AFTRA and its members, and above all, should get the royalties back to the people who's created the works that should be compensated for it.
Thank you. We're going to do Bruce, Cynthia, Patricia, and Wanda, and then we're going to go to another question.
Thanks. I think what Barry was just saying highlights the fact that what works for DMX does not necessarily work for everybody else. DMX had a particular business model. They were created with that business model in mind. They built their systems around that business model. Others, particularly those that have streaming and record keeping as the flea on the hair and the tail of the dog, don't necessarily have that. So if anything, I think, should come through from the various discussions that we've been having here today, is that one size really doesn't fit all. And that what we should be looking at is the minimum set of information that's necessary to make the identification, not some expanded superset of that information. And the burdens beyond that should be placed where they economically, efficiently, and rationally belong. They should be placed at a single point, the group that is responsible for making the distribution. But beyond that, it's identification, and one size doesn't fit all.
Thank you. Cynthia? Thank you.
Let's spill everything.
Sorry about that. Thank you. I wanted to make the point that, like DMX, XM and Sirius are in somewhat different position. They, in fact, do have systems in place currently that they designed before going into operation, and that they feel adequately provides the notice that is required under the statute. So they did step up to their obligation and created their own systems. And this marketplace solution that Gary mentioned, XM and Sirius have both contracted with companies to provide their own solution. They shouldn't now have to go back out and purchase something else. And in XM's experience, at least, those marketplace solutions are often inaccurate as well. Some of the vendors that Gary mentioned are providing inaccurate data that the companies then have to go back and recode themselves. So having access to an approved database where all the information is accurate would be the most efficient way to handle the reporting.
Okay, thank you. Tricia.
I wanted to say that, first of all, I think one of the common grounds should be, and I think it is, that everybody does want there to be webcasting, and people want there to be simulcasting, and artists want that, and it's good in large measure because it gives some promise to the potential for diversity and more cultural and creative development and more cultural and creative appreciation, and that's good for everybody. It's good for artists, and nobody, I think, really wants to create a system that is burdensome in a harmful way. That is not what this is all about, and we do all want there to be webcasting. And I also want to say that the comments about, I guess, what I would call Alex's visionary system, and Jenny too, what you're talking about in terms of a single number, a technological solution, a new system, it is visionary, and it's always sort of wonderful and also a little scary when you have a visionary in the room. The notion of there being a new and complete data system that's there for everybody to use for all their purposes is a wonderful one and a valuable one. And I would say that not only do all the featured artists, belong in that system, but also all the non-featured artists belong in that identification system. What concerns me, though, is that in between there and where how do we get there? And is this really a proceeding that can make that system, that new thing, come into place? And I don't know that it is, and it seems to me that in the ideal world where we're creating that kind of system, it really almost has to be a cross-industry, multi-interested party effort. It's got to be, the webcasters, and it's got to be the broadcasters, and it's got to be the copyright owners and the artists in the union, and everybody's got to, work together if we're going to build something that is that comprehensive. What concerns me is, not Alex's high level of vision, but the sense that for some people it just could look like an easy way out of saying, well, Sound Exchange has this, or Sound Exchange can make something that's going to make it easy for us. And I want everybody to remember that what in the real world right now, trying to actually get money out as soon as possible and for the artists to receive money as soon as possible, we're sort of dealing with the less than perfect and not the vision. We just have what we have now, and it is artists and copyright owners that are paying for it. Artists are paying 50% of the efforts to put together what we have now. And I think in the interim and in the dirty real world, I just want to make the pitch again for what we need to have. We have to have enough information to identify unique sound recordings. And Bruce, I did mean identify. I didn't mean to distribute. And I was very glad to hear Barry say album title, because not everybody in the comments really acknowledged that album title was crucial. There was a lot of, song title and artist. And it's an advance to say album title, and that's important. And then beyond album title, to the extent that there are more things that are needed to identify unique albums, I think that is important. If it's Brahms' First Symphony, and that's an album title, but it doesn't tell us, which symphony and which recording and which conductor, that is not adequate. Sting, yes, the Sting live album has its own title, but there are going to be a lot of situations where things are not so clear, and we just need enough so that we can do the distribution. And then I think if we're going to really live up to the promise of the diversity of webcasting, it's got to be information that allows us to distribute to all the performers that are contributing. The sample data that is going to leave out the niche artists and the lesser-known people and the up-and-coming people. That really is not what the system is all supposed to be about. So I guess that's my point. It's easy to get sort of trapped in the one industry that doesn't like another industry and all the bitternesses and ill feelings and whatever of the big players. But down underneath it all, there are the artists who are creating the art, and it got to fundamentally be about finding ways to get the money to us.
Because I don't want to scare anybody, and I just want to...
make us wonder.
I just want to, and visionary is one of the most terrifying things to be called when you're in, product and business and technology. I just want to say this. I fully recognize that this is not something that one turns on tomorrow, and that if we want to achieve it, what's incredibly important is there has to be a pathway for getting there. And I also believe that based on what Steve said earlier today, industry-wise, somehow or other, this is going to happen. It's going to happen. It has to, because it's frankly just dumb to do it any other way. But the question is just, is there a way to establish some motivation or goal that goes beyond saying we're going to write down on a piece of paper that you must provide these pieces of information, artist, album, whatever other text, in such a way that it precludes the establishment of a more reasonable and meaningful system. So, would I like it if the Copyright Office actually came back and said that the copyright holders and the royalty payers should in fact put together over a period of time a globally accessible database that is used for the payment of these royalties? Yes, that is what I would like. Does that mean that we don't have an approach that we can't take an approach to an interim solution that is more like some of the things that you're saying? Yeah, absolutely. I just don't want to miss the opportunity to push that forward.
Well, the good news is that you were thinking ahead of where the next question is going, but before we go there, let's go to Wanda.
First of all, I want to thank you for allowing us to attend this. It's an honor to be able to, that you're allowing small commercial webcasters to finally get their voice heard in this process. 3WK is absolutely what the Future of Music Coalition describes as a small commercial webcaster. We are two people. We operate out of the front half of our house. We got our furniture from garage sales. I have pictures of it if you'd like to see it.
And yet, we were the number 7 MeasureCast webcaster in 2001. We have a big audience. We have a huge potential, and we don't want to destroy our chance to gain that potential. I know Kevin said we're like the puppy in the industry. I like to consider myself as Clear Channel when they bought their first radio station. That's where I think we're going to go. So I don't want to lose any opportunities here based on rate or based on reporting requirements. That said, we need a compulsory license. We have to use one. Last week, excuse me for being nervous, last week our station added 50 songs. We added, and that's over 35 labels or self-produced labels. If we have to provide information, you know, however many pieces of information for every single one of these, if we had to go out and negotiate individual contracts with these labels, it would be a very difficult process for 2 people to do. A unique identifier is a great idea. I love the idea. If you tell us we need to start inputting a unique identifier, I'll do it tomorrow. We don't have that system yet. What we have, what most small webcasters have right now in our systems that we can give you tomorrow is ASL, artist, song title, album, label. We have it in our systems. I've had it in my system since 97. We could have been paying artists since 97. Okay? But one other point I want to make is I think the RIA actually agrees with those 4 pieces of information. They have it in writing. In their replies, the reply comments of the Recording Industry Association of America on April 26th, they have Section P, examples of instances where artist's name and sound recording title is insufficient for royalty distribution purposes, and they list a whole bunch of artists with a whole bunch of song titles. As their supporting evidence of the stuff that they actually need, they list artist, sound recording title, album, and label. They agree with us. They agree with us on paper, and I think that's all we need to have.
Thank you very much. Do you want to say anything before we close this out?
Yes.
Okay.
There are a number of issues that have been talked about that I just want to touch on very briefly. First is this concept of the nirvana, the day when there is a single identifying number that can apply to all sound recordings. It just doesn't exist. If Alex is talking about the son of SDMI and recreating a multi-industry standards of multiple corporations around the globe, setting up a standard, meeting around the world, distributing this information, and Yahoo wants to pay for all of that, or Yahoo and some of the broadcasters and other parties, you know, that may be a wonderful idea, but it does not exist. It is not on the horizon. It will not happen. The ISRC number has been an effort for 15 years to get companies to use that. It is principally the major labels that are using it, independent labels, lots of companies that are not part of RIAA. And remember, when people talk about either the recording industry or Sound Exchange, we don't represent everybody. We do not cover the universe of copyright owners. We do not represent all artists. We are, for the purposes of webcasting, distributing to non-members. But those non-members are not part of the RIAA, and they are not part of Sound Exchange. So I just want to make that clear. There is no magic bullet here to be able to do this.
Other industries have them?
Well, there's another issue here in that Yahoo, Clear Channel, big players, and then small players like 3WK and Beethoven, and then XM and Sirius that have raised in the capital markets, you know, maybe hundreds of millions of dollars. The one thing that all of these companies have in common, what they have in common is that they have all chosen to enter into this business. They have all invested. As 3WK pointed out yesterday in the DEMA handout, they've got $9,000 in revenues, but they've spent $74,000 getting into this business. I can't even imagine how much Clear Channel has spent to get into this business. People know how much Yahoo spent to acquire broadcast.com. Whether or not that was wise, you're talking $5.6 billion. This is not radio. This is something very new, very different. It is not musical works. They talk about, Elliot talked about what RCS, what radio stations provide. They list artist and song title. but in the statements that were submitted by the broadcasters, they have screenshots of RCS Selector. And what does it have? It has information to identify musical works. And do we know why? Yes, because musical works copyright owners have been paid and have enjoyed an exclusive right for many years. The sound recording copyright owner and the artist, the performer on the sound recording, this is the first time that they are getting paid. Things are different. This is a new work that is being compensated. It is not a musical work. It is a sound recording. It is a new medium. This is not an analog broadcast. This is a digital audio transmission. It is not the flea on the hair of the dog. Clear Channel has chosen to get into into webcasting. They put their signal on the internet. What did they do? They invested probably millions of dollars to do that, to aggregate all of their stations. They chose to do this, but now what people are asking, they want burden shifting, plain and simple. Everyone out there wants to enjoy the benefits of a statutory license. It is already a burden on copyright owners. We have to license our works. We have no choice. But we don't have to pay for people to webcast. Parties choose to do that. Similarly, we don't have to pay and shouldn't be forced to pay for people to enter data properly. What Alex is asking for is a magic bullet because people at Yahoo don't enter an artist's name properly when it is available on a sound recording. That's what's going on. You want copyright owners and artists to do your work for you. But I submit that you've chosen to get into this business. And Sound Exchange is serving a function that artists and labels have chosen to underwrite. The fees to operate Sound Exchange don't come from you all. They come from the royalties. The royalties are owed to the label and the performer, and that amount is reduced. So let's not forget what's going on here. You're asking copyright owners and performers to subsidize even further your current business, and that's not appropriate. Artists and labels are entitled to be compensated for your exploitation of their works.
Who chose for you to get into the business of Sound Exchange? Ron Gertz could have done that business. RCS could have done that business. ASCAP and BMI could have done that business. Harry Fox would probably say they could have done that business.
Some of them came forward several years ago.
I'm not suggesting that. What the suggestion is you are taking on this enormous burden which you would prefer not to have, and how dare we suggest that you have to build your business. This is a revenue-producing business. The RIAA chose to get into the RIAA.
Sound Exchange is not a revenue-producing business. It's a non-profit.
The RIAA chose to get into a business.
I just was given a gavel just in time. I think what we're going to do is close this part out, and I'm going to go to another question. We'll get to you. There will be time for people to come to the mic. The question that is troubling us and that we've been struggling with amongst ourselves is, what do we do about past performances, the ones that were made in 1998, 1999, 2000? And what happens when people tell us that they don't have the records or the information that ultimately may be part of any regulation? That's one piece. And the second piece, which is related, is what about going forward? And it really goes to what Alex was saying. If we were to put out a regulation tomorrow, most people could not basically accommodate what that regulation required. And you talked about an interim and a pathway. And I guess we're interested in hearing about what people think should be done about past performances, where clearly, from the moment that anyone webcast, there was, in fact, a duty to pay. There is a statutory license, and there is a duty to pay, but how does the record-keeping piece get handled? And then what about the right after period, the period after? So anyone? All right, well, I'm just going to take names. We'll start with Elliot, and I'll put your hands up, and I'll... Oh, my God, all right. All right. I got you guys. A minute.
I think the biggest problem is that you've got two industries that are basically, stuck together and work together really well in most cases. You have the radio industry that is able to expose new music to the masses, and you have the labels that are making recordings that they wish to sell to the masses. And I think we forget that. I think the webcasting, the new technology people, and the business opportunities are different from the basic understanding that musicians, songwriters, singers are making records. Record companies are paying for them. They're paying massive amount of money to manufacture and market them, and other people want to use them. Both those industries are also very different than they were when they were invented. Randy Michaels, a great radio guy, invented the whole J-Core clear channel business. He spawned the idea of mass radio. Clive Davis, Ahmet Ertegun, and Jerry Wexler and those folk created labels, small labels. At 2002, that's all gone, because now both industries are controlled by Wall Street numbers, Wall Street rules. And the idea that either industry has the cash, the funding, the ability to create massive databases, to create infrastructure to allow webcasting to happen, I think is a big stretch. And I would assume that since we believe that with our software, most of this can happen. We have a global identifying number. We have a patented fingerprinting system where we say the sound recording is the fingerprint number. And we have that for 60, 70, 100,000, some number of titles, but not the 700,000 titles. And we don't have the means of connecting that to every recording that Barry has in his system or Wanda has in his system or they have at Harvard. So the pieces, all of us as independent companies, vendors, have pieces of this puzzle that can be put together to achieve this. Achieving this is a bigger problem. And it's really interesting, something we didn't mention earlier, the current state of the radio and the record industry, which I think is much closer and tighter. I know labels that work very tightly with radio all the time. There are sound recordings, singles, that might have 6 or 7 different versions. The same song, the same artist, 6 or 7 different versions, because the way the music industry works today, a label releases a record, goes to radio, it doesn't get a lot of play, doesn't get a lot of reception from the audience. The record company goes back, remixes the record, and puts it out again. Same title, same artist.
Same owner.
Same owner,
Okay.
Well, it gets worse because the ownership could be different because they might be different performers on the new mix as well. But that's a separate issue. Yeah, it's a different sound recording with the same title.
Right.
So the notion of saying Jennifer Lopez, this song, this album, doesn't really necessarily connect to what Barry's playing on his pop channel right now because he's got a different mix than what's on the album that's put out.
Yeah, you're kind of still focusing on identifiers, and we're trying to figure out what do we do about the past and...
No, I apologize,
okay.
and I do
That's
understand
all right.
that,
Okay.
but I think that
Okay.
it speaks to the biggest
Okay.
issue, because if you could go and gain cooperation from the labels to the radio industry, and we'd help make that happen, and get all the information about new recordings into databases at radio stations, that's easy to do. Dealing with the historical information is very difficult, and that's commerce, and I think that various businesses have pieces of those solutions. We don't have that solution in terms of a database.
Okay. I'm going to call on Jenny next, but I have Kevin, Wanda, Bruce, Michael, Steve, Fritz, Glenn. And anyone else before we start? All right, Jenny.
Okay. At the risk of sounding visionary, I'm also going to look to the big picture of this. And first, I want to put it in context, because if you read what we have here, we talk about creating 4 different licenses that have different levels. We have hobbyists, we have non-com licenses, non-commercial licenses, we have incubator licenses, which are small commercial licenses that allow people to get in the business and compete, and then there's commercial licenses. And at the risk of sounding like another musician, Bono, I would say, with regards to the 3 smaller classes of licenses, we should forgive the debt in order to allow for there to be real diversity in the space. And I know in some ways that there are some people who will benefit from this in a knowing way. It was a strategy of theirs to say they were going to pay and then not pay, and and to bring another hero of mine to the fore. We have Steve Martin saying, "I forgot that armed murder was illegal." Clearly these people have signed the statutory licensing agreement. They knew they were supposed to pay. They're not going to pay. The question is, what's the big picture here? Do we want to have a diversity of webcasters out there competing? And I think it's not a complete free forgiving the debt, but it's forgiving the debt as a condition of future compliance and in the face of legitimate and reasonable requests, which hopefully this panel will come forward with.
Okay, heard you. Kevin.
Thank you. First of all, I feel again compelled to respond to something that was said earlier when it was suggested that this streaming webcasting is not radio. What we do at Beethoven.com is radio. The only thing that's different is the medium by which we transmit our signal. That's the only difference. In fact, we take the same on-the-air programming on Beethoven.com and syndicate it to an AM radio station in Hartford. We've gone the other way around. And it's a 490-watt AM station that was able to get a 1.1 share in certain demographics in a mid-sized city market. But it is radio. It has live DJs. It is radio all the way through and through. And I also want to make it clear that music is not the radio business. Music itself is the product by which we have built our business. But it's how we package that product, we produce our programming, how we market that product, how we brand our image and our company that draws people to that product and which exposes those people, not exploits, exposes those consumers to that music. We even go one step further in providing, and most other webcasters, commercial especially, do this as well, some non-commercial as well, provide a legal opportunity for our listeners to purchase that music. We encourage it, we promote it, we drive people to purchase this music legally. Some have even gone so far as to put little things on their things saying, hey, don't steal music, buy it here. Now, having said all that, addressing your direct concern about retroactive reporting, I was trying to look through we have a collection of some of the different press things, and now I want to give fair opportunity to our friends at the RIAA to respond to comments that have been made in the past so that we don't just blindly believe everything we read. But it has been suggested in certain press publications that the RIAA have made overtures to hobbyists and non-profit webcasters suggesting a low flat rate license and forgiving certain, if not all, reporting requirements. I would suggest and propose that any commercial webcaster, going back to 1998, which can show that we have not yet been able to feasibly find a profit in this business, effectively making us non-profit during this period of time, could take part in that proposal and be forgiven those reporting requirements and settle the back issue, and then work together as partners, which we unfortunately naively believed we were up to a point. Work as partners to develop a way together that we can eventually move towards a unified system that makes it work for everyone. It's been suggested with a uniform code or something similar to the ISBN numbers that publishers have for books, something along those lines, whereas if there is one type of identifier for this thing, for this piece of music, this sound recording, any of us, including the pros, the ASCAPs and the VMIs, the artist organizations, the copyright holders, even myself as not only an internet broadcaster, but someone who wants to be able to build into my business model the e-commerce opportunities of promoting and selling their works. can all build our own, use that and build our own databases with the information that we need attached to that number.
Let me ask you a question. Assume that it is not forgiven, this is a statutory license. What kind of records do you have for the previous period? Could you?
I could not, Beethoven.com could not tell you exactly what we played during that period of time. I could provide a sampling, I could provide an overall idea of our programming, which has not changed during that time. I could provide evidence that this programming was in place all along, that we have not changed typically the number of pieces that we play per hour, the types of works that we play. I could provide something like that could be used as a model.
But you really don't know what was played on any given day?
No more than our friends at Sirius at Clear Channel could go back, in one of their smaller stations in some small market and find out what they played in 1999 or 2000.
Have you started collecting that data now, though?
We have.
Okay. What's the magic date when you started?
I don't have that information as far as what's in my database, but it would have been sometime last year.
Okay.
It was definitely before any recommendations had been made either on the royalties or on the reporting requirements. It was something that we've always wanted to do anyway because it makes sense for us in our e-commerce opportunities moving forward. Okay. And quite frankly, it's also, it's part of our service. It's part of our service. We see, especially with Beethoven.com and the classical music, we see ourselves as trying to provide classical music that is not very easily found these days on the AM and FM
I appreciate
signals.
That.
And there are a lot of people that feel the way you do, that are struggling to find it in the traditional medias. And
okay. Okay. Answer the question. Wanda?
I've been informed by Elliot here that RCS, which we use and we love it, has a system whereby you can go back and gather the information. We also have playlists that my husband has kept diligently. When he gives them to me, I have to admit I throw them away. I don't need that stuff on my desk. We can probably come up with a model at least. But the problem is, we've known about this since 98. We've been planning on it since 98, but nobody said we needed 18, 22, 10 pieces of information for every song we played.
We always assumed it would be more like the ASCAP BMI
So
reports.
what did you keep?
We have playlists. We produce weekly playlists that have artists. I think it has artist, song title, album and label on it. I think it has that information. RCS, I'm not sure what's in the system. It might only be artist and song title. I would have to double check with Jim on that one.
We have some handouts of your playlists, and it does
Okay.
have artist and song title, at least on your website for...
Oh, no, that's the printed. We also have a published one that goes out to the labels, too, that has plays on it, too. So we do have that kind of information. But I got to say, we did not have enough... We actually put money away for this, too, until we find out it would have to be, 300% of our revenue, which I'm sorry I brought that up. I apologize.
Thank you for apologizing.
But I can satisfy the retroactive in that I owe my mother-in-law, Gary, $300,000 at this point. I don't have investors except for her. I would rather have it forgiven. Because if I have to go back and say, I need this much more money, I'm probably, if it's based on what it is right now, I'm gone. I will close.
Okay. I don't think you need to tell us anymore that you would like to see it forgiven. I think everybody has gotten that point. Next. Bruce.
There are approximately 13,000 radio stations in the country. They all operate differently. Many of them, at least, I can't say they all, but the great majority operate unlike others. They operate in a relatively unsophisticated way. I don't remember Brian Parsons' exact description, but even his description of typical Clear Channel stations was in the context of Elmer's glue wall and baling wire. And they have records that will vary. My sense, and we obviously have not conducted not obviously, I will tell you we have not conducted either a survey or a census, is that most radio broadcasters do not have specific records of what they streamed when from 1998. We believe the past is necessarily going to be an exercise in estimation. The Copyright Office made very clear when it adopted the interim regulations that it applied to the pre-existing subscription services. I thought Steve's comment earlier of it made no sense to develop a distribution system until we saw what the regulations were applies equally to users. It made no sense to keep records until you knew what those records were going to be obligated to be. In terms of identifying and determining fee, there are ways to perform such estimates. Stations that are streaming probably have ATH information that will give you average numbers of users. They know from their format, on average, how many sound recordings per hour they stream. You can do that math. That's on the fee side. On the distribution side, that doesn't give you a lot of information. And from there, I think it will require looking to see in individual cases what they have. Do they have playlists going back? Some will not. And to the extent that there are fees collected from stations that don't have playlists, you can then look to proxies. You can look to record sales. You can look to other standard industry measures of what was performed when. But that's unfortunately, I think, where the situation is.
Thank you.
I'm sorry, you were also asking about going forward.
Sure.
And on a going forward basis, I think really the question of what's needed will depend on what you do. If what you do is, say, title and artist, there are a great many radio stations that will be able to start complying and start reporting very quickly. If what you do is significantly beyond that, I would venture to say there are a great many radio stations that will stop streaming so that there won't be anything to do on a going forward basis. But those that don't stop streaming, I think, will need time to see whether they can put systems in place to capture the additional information in a economically reasonable way.
Thank you. Michael.
Yep. So WHRB started webcasting on November 18th, 1999, and there are two types of records that we keep, and we keep this for our FM station. And so incidentally, we obviously have it as well for our webcast, since we just simulcast what we have. And again, I'll caution this by saying this is what WHRB as one college station has. Fritz maybe can talk a little bit later about the majority of other stations and where they sit. We have, as was referenced in our comments and in Exhibit N from the RIAA's reply comments, we put out a play guide, a playlist, and that includes all the classical work we're going to play. And so that's 23% of our transmitted songs by time, not necessarily by duration. Now one can see that most classical works are longer than the average rock song, so you're going to see most likely that on volume this is much less than 23% of what we transmitted. These are in analog format, so we can give you a bunch of booklets. It's possible that some of this might be an SQL database which we use to populate our website, but I'm uncertain if that's actually been stored anywhere. That we can look at. Secondly, there are some logs that we keep totally by hand, and this is as a DJ goes about putting together a free flow show. So this is a DJ on the fly writing down, and what we write down in the book are four things: artist, track, and actually I guess three things: artist, track, and a flag. And this flag can either be a P for it's a new release, a playlist item, or a C for a compilation. It comes from a compilation. And you're supposed to then record, if it's a compilation, what album it comes from. This, again, only refers to about 30% of WHRB's total programming time, which is included by the rock department, which is the overnight time that the station broadcasts. This is totally analog format, totally written by hand, including very interesting doodles and pictures. inspired in 3 a.m. playing music over the radio. These actually go back 20 years, and we actually did try to look at how useful this is. We put together an extended piece of programming. We actually played the top 20 pieces on the radio for every week for the last 20 years in one big block of programming, and determined that it was very, very difficult to make much sense of what the doodles were and what the actual writing was in the logs. And again, this is not in digital format in any way. There are some records of the specific top 20s or top 30s that we report to CMJ, and those you could probably get, and we probably have them in digital format somewhere. But again, that's only the top 30 items that was played on the radio station that week. It doesn't include anything else as to when it was played, how many listeners.
How far back does your reporting to CMJ go?
We've been a member of CMJ, I think, for more than 8 years. However, there have been lapses in that, as this is being a volunteer organization. When the staff turnover occurs, there are times when, obviously, that's not kept up. And so those would be the reporting that we have going retroactively. So you can make sense of this, but again, there'd be a lot of burden and a lot of work, I think, on the collective to figure out how to make sense of it. It'd be very difficult for us to put this in a format that's very useful. Going forward, I think I'm going to agree that it probably depends on what kind of interim period you have as to what the regulations are. We estimated that if the proposed rulemaking went through, it would take us 10 years to get there. Obviously, that's one far end of the scale, and we can ratchet that whatever way it goes. But I think it would take a lot of time, and that's not including the cash that it's going to include to make that happen as well. And also, I guess how Jenny opened up the idea also that maybe the interim period, and as the RAAA said in their reply comments, could be based upon different criteria, like they had an extension for stations that were non-automated and affiliated with educational institutions. They were given an extra 3-month period. I like this idea of making it multiple different steps for the webcasters, so that instead of having a one-size-fits-all for everyone, we can have different degrees. I haven't had a chance to look at what Jenny has put around today. Maybe that's a really good first step. But I mean, just looking at it, there's automated versus non-automated stations. There's profit versus non-profit, commercial versus non-commercial. They have both types of those. Small businesses, you can define by number of employees, amount of revenue, etc. There's a lot of different ways to slice and dice it. And it seems like that probably makes the most sense, is to look at specific cases.
Thank you. Do you want to go now or last?
I guess we'll go last.
All right, let's go over in here. Fritz. Oh, wait a minute. Yeah, Fritz and then Glenn.
We'll share the mic here. The good news is that at least in the case of educational radio, the several hundred radio stations, and for the most part their simulcast web signal, that at least with the small artists, perhaps not the big 5 members of RIA, but the hundreds of other members of RIA, there's been a tremendous promotional value of the signal. So in effect, as Congress recognized under Part 18 that there was a promotional value for educational broadcasting in the case of the copyrights, that in fact has been paid. I would say that many sales occurred at these smaller labels because they heard the performance on a college radio station. As to the records, obviously we don't have 13,000 stations, but we certainly have many hundreds, 800,000 stations, and each of them are different. And I think the other thing to remember is they're by and large all volunteer operations. And since the barrier of entry, in other words, what it costs us to put a station on the air, a webcasting station on the air, is approximately $500, not the millions that Gary was referring to. Actually, many of these stations have gone back to 96, 95 in areas like that, and were experimental radio and trying out these new technologies, and Real Audio came along and said, hey, we'll give you software for free, the educational stations, and you can broadcast up to 20 people at a time. And our stations could afford to pay free, and they went on with this. And hundreds went on, and perhaps even more would have gone on, except for the fear of exactly what we're discussing now, and that's possible retroactive payments. We don't have, when you've got these small stations that are only on 6 or 8 hours a day, only on during the times when there's no holidays. Remember, the federal communications system only requires a non-commercial station or a college station to be on during the school year. So if there's spring break, they turn the key off, they turn off the Macintosh computer, and we're not streaming during that period of time. So the stations, by and large, the educational stations, are a different class, they're a different group. They don't have a lot of records, by and large, going back on what they did play, but the reality is they don't have any money at all, or not much money that they've had to put into this. It's an educational experience, and I would certainly hope that we wouldn't put off, we wouldn't limit the artists and the small record labels' opportunity to have that value of the performance by putting whole bunches, hundreds of educational radio stations off the air by saying you owe X amount of dollars retroactively to 1998. I think another thing which I've heard throughout the morning, the reality is the educational and perhaps non-commercial, like in Part 118, is a separate group. And at one point or another, we're going to have to recognize that there's an educational benefit and that there is a benefit of free speech and of the young people of America, America's sons and daughters, to having webcasting available to them and not prohibiting them from webcasting and taking them off the air. So perhaps both in rates and in performance and retroactive and other things, we will have to set them apart as a separate class, essentially what was done in 118. The other thing to particularly remember as far as retroactive payments is there's just not going to be a lot of dollars. It's going to be very...
Interrupt for a second, 'cause
yeah.
You're talking about payments. That's not the topic here. The topic is retroactive reporting. If you could address that, that would be helpful to us.
Absolutely, David. Although they tend to be the same in reality. The retroactive reporting for us is virtually impossible on the average station. There were volunteer stations. They went on the air for $500. They went on and off the air, and they continue to go on and off the air, and there's very little reporting that can be done in the past in our stations.
Glenn, you need to pass the mic. It's the other way.
WebSound is a webcaster, pure and simple. We started streaming audio in November of 2000. We actually signed a license with the RIAA in September of 2000. We have been providing reports to the RIAA since November of 2000. To discuss the issue of backfilling reports, that's really not a problem since we've been reporting on an ongoing basis. I can imagine that it would be a horrendous problem for anyone that hasn't been keeping records. To address the issue of what we do going forward, since we have had to provide these reports monthly, and it has been a challenging process to continue to provide those, we out of necessity developed a system to streamline and automate the process of record keeping and reporting. To that end, we have a system now running that combines a song-specific database that reads a common log format file from the streaming server and combines that with playlist information and automatically submits a universal report of performances directly to Sound Exchange. And the system is up and running now. In fact, we're sending our report in right now as I'm sitting here. And when we developed the system, it was really developed just for our own use, mainly because if we were going to continue to grow as a webcaster and these reporting issues would continue to expand, then we needed a way to provide that data and not have it take up all of our time. After developing the system, we saw in these in the CARP releases and reports that this was a major problem for all of the webcasters, and we looked at our system and thought, well, I wonder if there's some way that we can apply what we've developed to the rest of the industry and make it available. And towards that end, we've developed a web-based user interface that will allow a webcaster to log into the system and enter some very simple information, and from that point on, their reporting would be completely automated.
Okay, thank you. Since you developed this for feeding into RAA, the question we didn't ask, but is it in the format like ASCII, and is it the kind of format that's been proposed?
Yes, it is exactly that. What we do is we take in a common log format file like this, and we spit out a URP that looks like this.
So you do the carrots, the no carrots, the single line?
Yes, exactly as it's specified.
Okay.
I think all of us have some comments, so if you can bear with all of us, just so we can respond to some of these things. On the past performance issue, this is one of those issues, like the non-com issue that we talked about earlier, that obviously is a difficult issue, and we recognize some of the difficulties. I think our initial reaction is one of it being unfortunate that some of these records apparently don't exist, because that means that artists and record labels won't be compensated. Frankly, we keep coming back to the fact that there was an obligation under the statutory license, a very clear one, whenever an entity filled that notice out and sent it into the Copyright Office with their $20 check, they were taking on the obligation to report something that they were using. And at that time, there were interim regs that exist, and while they did not apply to webcasting, they certainly were the only thing that existed as to what kinds of things under this statutory license were appropriate for reporting. Therefore, we do think that there was some obligation and burden for some of the entities at this table and others to have tried to keep some of that information. That being the case, we're realistic. If there's no data, there's no data. And we're kind of left with, you can't get blood from a stone. We do think, however, that to the extent that the data can still be retrieved, maybe in another form, maybe it's not readily available to be spit out today, but it can be retrieved through Selector or something else, there should be some obligation to retrieve whatever is retrievable. And that may vary from company to company, and I'm not sure, sitting here today, how we would express that in a regulation. But as a principle, I think that would be a fair principle. And I think the other thing is that, to the extent there is some relaxation of reporting going back, given these realities, we would, our firm belief, obviously, is that those should not extend to the future. That the future should be different. We can argue, I guess, about who was on notice at what time about things, but I think the one thing that is clear is that we're all here today. We've all been involved in this process for the past several months at least, and on a going forward basis, there should be adequate information, even if that information differs on a going back basis. And I think that Barry and Gary have some additional responses.
I just want to talk a little bit about operationally how we would deal with the historic data issue. What I'm hearing is that there are no records for some records for some. maybe very comprehensive records for others. But what doesn't exist in the past is any kind of standard around that way that that data was stored, and that could be delivered to Sound Exchange. Now, when Bruce said that just like the Sound Exchange didn't develop a system in advance of a standard or regulations, they didn't record the history of their performances. Well, when the Sound Exchange built its system, we knew that webcast administration was coming. And so, of course, we built our system with hooks to the future to anticipate the administration and processing of the information around the license. So while we don't have a completed system to distribute the webcasting royalties, we do have the core of a system that now needs some augmentation to get the distribution out. So we anticipated this and we prepared for it. My belief is that webcasters and the simulcasters knew that regulations would come around reporting of some kind, and they should have been keeping this information for the purpose of paying the royalties to the record companies and to the artists, small, medium, and large, to get the money to those who create the content that they are building their businesses on. So what is our choice? Well, we can do a number of things. We can accept the data that you have and spend time, money, and energy trying to create a standard out of a variety of formats and get the distribution out, but try to approximate what was actually performed. The objective of the Sound Exchange is to be transparent and to pay labels and artists for what was actually performed. And to the extent possible, we would be committed to doing that for the historic period. But we have to balance that with the cost of bringing together disparate forms of information to accomplish that distribution. We could identify a proxy. That proxy may be going forward performances. I do believe that the radio stations do have to report ASCAP and CSAC in a survey, and maybe that is another proxy that I haven't given it a great deal of thought and consideration, but there are options available. And also there are monitoring services out there like BDS, and while I understand that BDS doesn't cover a lot of the stations that are simulcasting over the web, it is another option for us to use that as a substitute data. But again, you know, this shouldn't come out of the royalty stream. We've been waiting for a long time to receive this money and distribute it, and it's 3.5 years worth of information and money, and it shouldn't come out of those streams to address the issues of poor record keeping from the past.
With your permission, I just want to add a few quick points. I think it's right from what we've heard that different types of reports exist for many different types of services, and in the copies of the screenshots that we've prepared from college broadcasters, there is a variety of information, historical data. One station, KFJC, which is it's a community college, and it's part of the college and university radio broadcasters, has playlists that go back, and I referenced this earlier, to 1995, I believe it is. And what you do is they give you a date range, you click on the date range, you go to a calendar which gives you the week of information, and then you can click on the DJ. You click on the DJ's name, and then you get the playlist from that DJ of artist, track, and album. So that is a community college that has this type of information. I think that there is information out there for some and not information that's out there for others. One of the things that I think needs to be clear, though, at least if we're trying to get as much money as possible to the creators of the works and the performers, is the fact that Sound Exchange should not have to digitize reports of use. If Harvard has handwritten logs, or other stations, or even commercial broadcasters, it is not appropriate for copyright owners and artists to incur the expense of typing that information into a database to distribute royalties. It really is something that the user and the beneficiary of the statutory license, who should have been keeping those records of use, as Steve pointed out, they were on notice if they read the statute that they had an affirmative obligation to provide notice of use of the sound recordings. The interim regs were also out there. But we should not have to go back and do the work for them. And then finally, I think an important point is if an accommodation is made for the past, there needs to be an understanding that there is a real cost to this, that artists who had their sound recordings played during that historical period, whether they were new releases that may have been popular, one-hit wonders, they may have been played quite a bit, but are no longer in rotation, those are people who were entitled to share in statutory royalties. And what will happen is if you make an accommodation and don't require data to be provided, those people will not be compensated. That may be because of the lack of data that services failed to keep. That may be something we have to live with. But I think on a going forward basis, people should not have to suffer. Copyright owners and performers should not have to miss out on royalties because services don't provide that data. So I think if you are going to draw a line, there should be a clear delineation between accommodations made for the past, but then efforts made going forward to really get the money into the hands of the people who are entitled to it.
Okay, before we do that, how many people in the audience want to make statements? 1, 2, 3, 4, 5. Okay, 6. The question is 7. Maybe we'll start. You can say one little statement, and then the time is now almost 5:01. We need to break for lunch. We have 2 panels coming up. Actually, the people in the audience are absolutely critical. The rules are that you're adding something that hasn't already been covered. There's a lot that hasn't already been covered. But let's go for a little while, and we do have a cafeteria here. Probably do need to break by 1, shortly after 1, but you can say your few words, and maybe you should a couple of you just line up, and what you need to be prepared to do is tell us who you are and who you represent, and then speak as concisely as possible.
I want to make just a very specific point going back to the way WHRB was thinking of what would happen the day that we had to provide laws. The specific point is just how WHRB was thinking and planning of making blogs when it went forward. We went actually back, before we could go on the air, we had to obviously make sure everything was legit. We went back to the original notice in 1998 that was published June 24th, 1998, and it was based, when we read it, it was based on the recording, on the testimony from 4 groups, the RAA, DMX, MUSAC, and the Digital Cable Radio Association and Music Choice. We weighed this against what we saw from ASCAP and BMI, who are offering digital licenses as well, and the reporting requirements behind those. And we assumed that since, for the sound recordkeeping, there was no one representing FM radio stations, and there's no one representing smaller entities such as ourselves, that it would make sense, and we thought that when the record keeping actually came to pass, it would most likely look the way ASCAP and BMI were, and that's why we went ahead and kept records those ways.
Yeah, that's reasonable. The only thing I would ask is why nobody stepped forward to try and clarify that on that behalf. And I know that answer could take a while, and it's somewhat rhetorical.
The thing is, it's past, it's gone, so let's turn to the audience.
All right, my name is Brian Newkirk. I'm from the Progressive Policy Institute, representing, I suppose, visionaries, but we're also a practical think tank. I'm also representing the digital generation here, I suppose, but not to make that relevant. What I'm seeing here is there is a solution to this. What we need to do is lower the cost of reporting for both the reporters and the people receiving the information. What we have is a tragedy of the commons, though, because obviously Gary is not willing to pay for some sort of central database to establish this information, nor are John or Alex. We also have an institution called the Library of Congress, which has, please, Gary, which has which has a tradition and is charged with cataloging every single book, every single piece of media published in the United States. Granted, they do not have a system of numbering the individual sound recordings by track now, but what we need to do is establish some sort of public initiative to have cooperation between the RIAA and the webcasters, which would enable this type of database to be produced through either maybe a massive intern program or through or through licensing products such as we have represented here and we have represented here. There is the technology to put this in use. What we need is some sort of public body to take the initiative to actually put that in the marketplace and have people be able to access that. Now, that's all I have to say. This database is a public good. That's all I have to say.
Thank you. Next.
My name is Chuck.
Thank you.
Next. My name is Chuck Walker. I'm with MUSAC. Mr. Greenstein, you said that the information to be reported is available. Barry, you and I have had discussions about this also. And you've seen our reports. We report every month volumes of information, some of which data fields are empty. I'm telling you that information is simply not available from the data available from the sound recordings that we get from your members.
And that's why we ask for other fields that augment the information that you are not providing to us. Our only remedy is to come back at you and say, fill all of this out. We don't do that.
I'm sorry, but that information
Instead, we take it upon ourselves to do the research, and these expanded reporting requirements are such that we get more pieces to the puzzle so that we end up paying the correct copyright owner and the correct artist.
And where do we get that information that is accurate? But there's no way to do that, and I think it would be a big mistake to have a regulation codified that told the services to report information that they cannot report. It's absurd.
Chuck, I think one of the things that we showed in our filing, in our initial filing, and then more comprehensively in our reply comments, was the fact that the identifying information that we have requested is available almost universally, well, certainly on commercial releases. On the promotional releases that go to stations, we included a lot of the images of that promotional
product. For major
product.
labels, that is true. For independent and small labels, boutique labels, that is not true.
Well, that is one of the problems in getting money to those people as well, is we need information in order to get that. And once the Copyright Office puts out regulations, just as we think the market will create technology solutions to help companies provide reports of use, we also think that those smaller labels that you're talking about, or the gentleman from Harvard, his roommate who may have put out his own album and who knows how that was identified, there will be an incentive for companies to provide that information on their physical product.
Meanwhile, that may or may not happen, but meanwhile, in the interim, there is no information to report.
Well, when there's no information to report, and I'm not familiar with your logs, the field would be left blank. I can also tell you that I don't believe Sound Exchange has taken any enforcement action or alleged copyright infringement by services, the pre-existing services that are not providing the information. Sound Exchange has undertaken the effort to identify those recordings on its own dime. Actually, it's the dime of the copyright owners and performers to do that work. But if that is why we are requesting fields, because if you cannot provide a certain field, then hopefully some of the other fields will give us enough identifying information. We already showed that sound recording...
So that any field could be deemed, if available, or how would you say it? If feasible.
Well, there's a big difference between feasible and available.
And available, right.
Yes, there's a very big difference.
Well,
It's
inconsistent across all the data that becomes available to MUSAC.
But have you ever been told by Sound Exchange that for a blank field you're doing it wrong, you're in violation of the statute?
You just mentioned enforcement. At what point should the regulations become law? Who would enforce these? And at what point would we be in violation of?
Well, I think that, and I don't want to answer questions of law that may be properly addressed by the Copyright Office, but on the fields of use, on the Uniform Report of Performances that Sound Exchange has put forward for how it would process information. If you notice in the reply comments, it's 10 fields that identify a sound recording. It's not 20, it's not 45 as was mentioned yesterday at the conference that was webcast. It's 10 fields for sound recordings, 4 of which fall into this either or. it's to report either the ISRC or the duration of the sound recording. So that's 2 fields, only one of which has to be reported. UPC or catalog number, 2 fields, only one of which has to be reported. And then there are the other fields. As for enforcement, my understanding is the Copyright Office doesn't go about suing anybody for violation of a statutory license or
regulation.
something.
Well, yeah. We do sue people once in a while, but not in this area.
Right. So the issue of enforcement, whether it's in this right for the cable compulsory license, for the satellite compulsory license, that burden, and it really is a burden, and there is a cost to that, falls upon copyright owners and performers. Because if they take enforcement, it comes off the royalty pool, and they will make a determination as to whether or not it is beneficial to either go after someone, or what is most likely to happen is Barry will pick up the phone, or some of the people who work for Barry at Sound Exchange will call a service and say, you know what, you sent us this log. Unfortunately, we're having a lot of problems with it. There are fields missing. Please give it another go-around.
Well,
I think... I know. Right. Thank you. Why, you can talk to each other. Why don't we do... We've got... Okay, Ron.
My name is Ron Gertz. I'm with a company called Music Reports, which represents the broadcast industry and web services and various others. And also our sister company is one of the designated agents to collect royalties for copyright owners. I think you started this conversation with the question of reasonableness. What is that and what does it apply to? And I think for identifying song recordings, I think it's reasonable to for services to provide the basic core set of data that allows the vast majority of sound recordings to be identified. Certainly, along with visionary and utopian ideas, identifying everything was wonderful, but it's simply not available today, which also speaks to the fact that perhaps what the Copyright Office should be considering is a new set of interim regulations rather than final regulations, because the marketplace will develop solutions over time. And certainly, if the reasonable goal is to identify the vast majority of sound recordings, that can be done by having those services that have intended playlists submitting those intended playlists. And it can be done by those services who don't have intended playlists by using sampling technologies and sampling methodologies. There are lots of statisticians in this world, and they've been around for a long time, and they can tell with a great degrees of confidence how to describe a population. That there is a cost-benefit analysis that has to be gone into here. And finally, with regard to the information necessary to actually pay the proper copyright owner, some of that responsibility has to be borne between the copyright owner and their collective. Frankly, a copyright owner signing up with a collective has to figure out how to let the collective know what catalog that copyright owner represents. And it'd be nice to have the Copyright Office create a complete database, but as many people in this room know, not everything gets registered. I dare say that sadly our data indicates that that of the sound recordings and musical works created after 1978, less than 25% of them have ever been registered. So that is not a good solution. Marketplace solutions are the answer, and those will happen over time.
Thank you. Next.
I'm Deborah Proctor from WCPE Radio, and I'm proud that you guys wanted to mention us earlier on today. With respect to your comment about the burden should not be on you to take our backlogs and key them in, and we should give them to you in a definite format and such so it's easily read by your computer, I'd just like to draw your attention to the parallel of me filling out my taxes in my 1040. The law only says that I need to keep accurate records so that I can accurately give the government my tax information. I am, however, allowed to fill it out by hand, and I am allowed to round to the nearest dollar. I think the parallel should apply. Also, you mentioned WCPE as being a typical public radio station, and I think that does a great disservice to most of the public radio stations. You're holding up what we do as a standard that the average community radio station can easily meet, because here's one that's already doing it. We're almost 30 years old. We're looking at the web as a future, the future of broadcasting. We started working on our music library database 20 years ago. It went from card catalog, scanned at the computer, over the past 5 years. We have tens of thousands of paid staff hours and possibly 100,000 volunteer staff hours going into that website that you're holding up to everyone and saying this is very easily done. We're a member of the National Federation of Community Broadcasters. Our station is the only one that NFCB could not include in their comments because we're very fortunate enough to outrank all of their members. We broadcast, it takes more electricity to light up the tubes in our transmitter than the average commercial station broadcasts with. Please don't use us as an example of what community radio can do and how community radio can report. I like that you like looking at our website. I also understand, though, that you made some copies from our website to distribute to this committee. You being a lawyer should have noticed that our website is copyrighted. And I don't remember giving you authorization to copy our material.
Thank you.
Good morning. I'm John Middleton, and I'm here on behalf of the First Baptist Church of Dallas, and its wholly owned subsidiary, which runs a college and seminary, and an FM radio station in Dallas that is Dallas-Fort Worth's most powerful. Now, you have not considered a constituency here to date, and that is churches and religious schools that operate radio stations and webcast. First Baptist and its affiliate, Criswell Center for Biblical Studies, does both. I filed reply comments, and I would urge you to read them, but my purpose in being here is to call to your attention the fact that as churches and religious schools, there's another statute on the books that protects us. And it protects us insofar as how far you may go in regulating what we do as the exercise of our religion. And that is the Religious Freedom Restoration Act, which I set out in the reply comments, which apply wherever it is proposed that the government would place a substantial burden on the observation of a central religious belief or practice. And I set out in the reply comments how webcasting and broadcasting is such a thing. And where it is applicable, it prohibits any branch, department, agency, instrumentality, or official of a state or federal government from substantially burdening a person's exercise of religion unless the government demonstrated that the burden is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that interest. I would submit to you that we as churches represent probably the lowest common denominator, and that in regulating, if you go beyond what you can do to us, you will be on the losing end on appeal. Thank you.
Thank you.
My name is Barry Masarski. I'm an economist and consultant for the RIAA, and I've been around the area of sample surveys for PROs for some 21 years. I would caution anyone to consider the variabilities of music use within drawing a fair and proper sample. Certainly, that is the concern of most webcasts whose raison d'etre is the diversity of their programming. Drawing a sample to be a proper representative of a larger pool of data really kind of hopefully estimates that sample correctly. The variability issue sort of complicates that in great detail. And that variability issue does extend to commercial radio broadcasters too. I've had a large amount of time to study certain formats such as country and Latin and so forth, and I'm concerned also that samples in those areas too could tend to either overestimate performances that are occurring once or twice and brought up in the sample, or the error of omission not be included at all. Yes, there are some formats that are more appropriate for sample, such as Top 40 and Rock, but one has to be very specific and look at the individual formats to take good care of how samples should be drawn. Thank you.
Thank you.
I'm John Simpson, the Executive Director of Sound Exchange, and there was one point that didn't come up this morning that I thought was important to address. But first, Fritz, I need to tell you I am the father of the sons and daughters of America who are paying tuition to many of your colleges, and I think you can afford these rates. Thank you. No, I was on the air at Cornell University, carrier current myself. I don't want to tell you when. In any event, one of the unique things about Sound Exchange, unlike ASCAP, unlike BMI, unlike PPL in the United Kingdom, is we pay everyone in the industry. We don't just pay our members. It's very easy if you're just paying your members. You know who they are. It's very simple. We've been asked to pay everyone. That's a much more difficult task. So what happens is our members are actually subsidizing the finding of the non-members. And I think we need to not burden our members with more expense. And I think you have to keep that in mind. And again, these are the people that are harder to find. And you're the best people to help us find them because you're the ones playing the recordings. When we get reports that come in and the artist is listed as various artists, I'm really annoyed. I wish there was an enforcement provision so that we could get some fees or penalties for the work we have to do. You know who the artist was when you played the track. You didn't have to put various artists in there. It was off a soundtrack. Yes, we can figure it out if we look at the title and we look at the soundtrack, if we get the soundtrack title. But please, be complete, give us information. We're just trying to pay the right people the right amount of money. Thank you.
Thank you.
I am not here to make a comment. I'm actually going to ask a question. I'm an attorney, not a tech person. Unfortunately, I wasn't smart enough to be a tech person, so I had to go to law school. It's actually for the gentleman from WebSound. I'm interested in, you were speaking about how you designed your program by which to report to them. And what I was trying to figure out is, in having done that, was that something where you all had to write your own specific code for your own specific systems? Or is that the kind of thing that would be able to be utilized in a top shelf type of technology that could be made available for?
No, we developed this system from scratch. We wrote our own code. It's completely proprietary, and in fact, we've submitted a patent on the process.
Maybe I can try and help you set that up then. I probably should have...
But that said, it is designed to be scalable in several directions. We can access several different types of databases. We've been doing research to try and answer the question on, is there a single database that contains all of the song-specific data? And in doing that research, we've been supplied with samples of these databases in various formats and have built our system to work with a variety of different song-specific databases.
You said that you've applied for patents, so I would assume that you all have a cost assessment of, what this would be if it were made available as top-shelf technology where people could go and buy this.
Yes, we do.
Do you have any of that information pulled together?
Yes, we do. As a matter of fact, we've done some very detailed research in what it would cost the typical webcaster, and we are estimating that it would cost approximately $100 a month for them to use our service and provide the reporting. And that said, that covers the majority of webcasters. There are webcasters on either end of this bell curve, some that would be so large, like perhaps Yahoo, where the reporting would be...
Might be a little bit more difficult than $100 a month.
Exactly, and we can work with you on that. And then on the other side, there's some webcasters that are perhaps so small that they couldn't even afford $100 a month. And
you'd give us a break.
Well...
Does this software apply to analog? I mean, where you're not actually storing these song files in digital format, you're actually playing them in real time in analog format? How would you identify the works with this?
Well, we've made some phone calls to the NAB and to try to understand how radio stations around the country record what they play. And it's a nightmare. There's a lot of different formats. Some people are just writing down on a scrap of paper what they happen to play that evening. That would have to change if you're webcasting. You would have to be able to supply that information in some format that would be entered into our system. I'm not saying that it's extremely difficult. It would be a matter of probably the same things that you're writing down now, but it would be typed in instead.
Right. So the system is not automated in the sense that if you're not doing automated broadcasting, this would be a burden on the broadcaster to enter information in some state.
The system is designed, the automation is in that it will, at a scheduled time, go out and read your playlist information as well as your streaming log and compile that with the song-specific data to generate the reported performances.
How does that work if it's a live broadcast? I mean, they're not...
Actually, I'd like to say that just because you're doing on the fly does not mean you don't have an obligation to report what you're performing. So if you are making transmissions in that way and web sound isn't the solution, then I submit you have to find a solution.
I just like to make that point that I don't think it's the
Well, just, I mean, Gary, the whole question that we're debating here is what is a reasonable reporting obligation? So your answer is sort of circular in that regard.
Well, actually, guys, I was just trying to ask a question about the technology, so we could all go to lunch. So, anyway, no, but really, I didn't want to know that question, or for example, if you were a person, you're at your computer, you've got an uplink only going, you know, is it feasible to utilize that type of a program, and if it is, what is the cost, feasibility, etc. But I think you've answered my question, so Mary Beth.
Let me just ask, if you have an uplink on the East Coast and Real Audio in Seattle is getting an analog feed from a uplink in central United States, can your program interface with a standalone computer that's not networked?
Wow, that would be cool. If you're streaming audio, at some point you're on the network, and at some point there is a log being kept. And
Real Audio is doing your streaming.
we use Real Audio for our streaming also. And
It's a simple fact that the software can do whatever you want the software to do.
exactly.
But is it necessary?
Well, is it necessary?
It's necessary. We're already collecting the amount of information necessary to identify 99% of the artist songs out there. ASL, artist, song, album, title.
What is the
That'll,
basis, though, for that 99%?
if you've got those four pieces of information, you can identify
But
most.
have you ever attempted to distribute? Have you run a collective, and have you tried to do that on that information? I further submit that these proposals for surveys, that if the Copyright Office were to look at doing that, it would need to test the statistical validity by first doing a census in order to make a reasoned decision. So you can't just throw out 99%.
All right, guys. Barry, all right, yes? Sorry.
I have not, I don't look at ADI, the former ADI reports, DMX today, to be a collective. But the fact of the matter is, we know every song that we use, and we pay royalties back on all of those songs to the record labels, whether there's 1,300 or nearly 1,500 of those labels, majors and independents, from 8th Avenue Lounge to Columbia. And we do it every 6 months like clockwork, and you know what? Once you have the system in, it's not a problem.
I'm going to cut this right now because it is now 1:20. We are significantly late. I'm going to suggest that if you go out of the building, you do it at your peril because you have to come back in through security. There is a cafeteria that is in the back corner. There is a little restaurant that is down on the, it's called ground floor G, but we're going to start at 2. Yes? Starting the second panel, we see some familiar faces and some new faces, so for the record, we're going to go around and have everybody introduce themselves.
I'm Steve England from Arnold & Porter, representing Sound Exchange.
Linda Boki from Sound Exchange.
Barry Kessler, Sound Exchange.
My name is Cara Nabel, and I'm here on behalf of the National Association of Broadcasters, the National Religious Broadcasters Music License Committee, Clear Channel Communications, and a lot of other radio broadcasters.
Does that work? Okay, all right. So it was hard to hear. Okay.
It appears to.
Oh, yes, we can hear you. All right.
We're supposed to cut it off when Bruce comes to the mic.
That's right. You failed this time. I've noticed that. My name is Bruce Joseph. I am putting on a different hat for the second panel here on behalf, from Wiley Ryan and Fielding still, but here on behalf of Sirius Satellite Radio and XM Satellite Radio, the two satellite digital audio radio services.
David Landis from Ultimate 80s.
Mary McCann from IM Networks.
Amy Bushhager from Mint 11 representing Music Choice.
Chuck Walker from Muzak.
Okay. Oh,
Barry Middle with the same hat, DMX Music.
Mike Hayes, I'm here today representing Twangcast, but I'm also a recording artist, a songwriter, and a copyright holder.
Okay.
John Potter, Digital Media Association.
Alex McGann, Yahoo.
Brad Pumphrey, representing the International Webcasting Association.
Joe Basinski, I'm also known as Lou Josephs in the webcasting community, and I represent independent consultants.
Okay.
Patricia Polak will be joining us. He's
Yes.
supposed to be on this panel, but must still be at lunch.
Okay. Focus on this panel is reporting to monitor compliance with terms of the license. And specifically, what we're looking at is there a requirement that information must be gathered in order for copyright owners to monitor compliance with the license? How important is that information? And if you compare the information that you would need in order to comply with the information that you need to identify, which is more important, or are they both the same? How do you break it out in the hierarchy of identification versus compliance? So let's just start with that and see who wants. Jonathan's holding up his hand. You want to have the microphone first?
I just want to put this in the record as we discussed, mentioned briefly, to, and we'll move on because this is from the last panel, really. This is a web print-off from one of the Warren Communications publications, a magazine of general distribution in the trades of communications, which describes the RIAA license with the Corporation for Public Broadcasting and specifically notes that there's no reporting requirements for folks under 10 people. So given that it's not confidential in nature, I thought I'd pass it along and get it in the record.
Okay. All right, let me, those who want to jump in, why don't we, oh, you haven't really been part of the panel, so let me start with you, Chuck. And those who want to talk, just raise your hand and I'll get your names. Okay.
The proposed regulations introduce additional reporting requirements in effect to the sound recording performance complement. MUSAC maintains standing as an exempt transmission
Right.
service through adherence to this so-called sound recording performance complement, and also MUSAC's status as a non-interactive transmission to business establishments. There's two parts to that. Reporting would provide, in our opinion, no additional benefit beyond a notice to the copyright owners. MUSAC also provides, we wear two hats here, non-interactive digital transmissions as subscription services, where MUSAC maintains a standing as a non-exempt transmission service subject to statutory license, in this case residential music service. A substitution of the intended playlist, the interim regulations, reporting by some sort of post-transmission playlist reporting, which has been suggested, would require the construction of some method of capturing more data than we're currently providing, transmission and management of that data, and the purchase of additional bandwidth necessary to accomplish the report, and the multiple redundant monitoring of the transmission to assure compliance. This, I think, wraps into the whole issue, which is difficult for MUSAC to separate, of both the regulations as for distribution of revenues and to this issue here. The reporting would require additional staffing, software systems development beyond any reasonable benefit of reporting. The intended playlists, the requirements there are that, and we've said this before during this proceeding, requires to provide the name of the service or entity, right, easily, the channel, easily, the sound recording title, easily, the featured recording artist group or orchestra, okay, that's easy to do. The retail album, or in the case of compilation albums created for commercial purposes, the name of the retail album identified by the service for purchase of sound recording, okay. Then the recording label. That is not always available to us. And neither is the catalog number for that particular recording, which is a copyright in a phonogram. It's provided by copyright law. That is not always provided. Should we be required to unequivocally provide that information, in order to comply with the regulations, MUSAC would be required to reduce its playlists to sound recordings to which all the reporting data is available, primarily only major label releases. This would leave out significant independent and tertiary labels important to our clients, mostly impact Latino repertoire, but our unique program styles developed over time would also suffer. Things like world, new age, piano and guitar, which is a program style. This would put MUSAC at a serious competitive disadvantage as our clients would seek other services with the repertoire resulting in a loss of revenue. I think it would be a mistake to ask the services to provide a report that no benefit beyond a notice to the copyright owners would be provided.
Okay.
Well, Yahoo operates two different kinds of service. They operate a service which actually programs a very, very large number of music stations, and it does that through automated technology backends, and it rebroadcasts radio stations. I guess it's important to discuss these separately. With regard to the first part, many stations that are developed and programmed by software I guess under those circumstances, I'm confused as to why in a licensing relationship it's important for us to continually identify on an ongoing basis through proof that we are satisfying the license agreement when in fact we're approaching this in good faith from both sides at the beginning. Why can't we use a sort of more established methodology, which is that if for some reason the licensor determines that there's a reason to believe that we are not adhering to the performance complement, that there be a mechanism at that point for identifying whether in fact there has been some kind of non-compliance, as opposed to the, again, onerous and incredibly complicated task on, by the way, both parties' sides of generating millions and millions of rows of data about every song that was played and each listener who has heard it, so that maybe somebody can come along and write some database software that will be able to go back retroactively and at any given moment determine whether or not we have, broken with the performance complement. So I guess what I'm saying on that side is that it seems first off that certification on our part that we will and that we do on an ongoing basis adhere to the performance complement should be the right start, considering that it does not benefit us as a licensee in any way to break with that complement. And second, that we provide a mechanism that is much more meaningful, at least for those webcasters that use software for programming, for determining under those circumstances that the licensor thinks that there's a problem, whether or not our systems are capable of programming music that is, that is in some way breaking with the performance complement in the form of providing a third-party software audit or something like that. Again, as opposed to the idea of, on an ongoing basis, delivering an absurd amount of data that isn't really particularly useful to either side.
Alex, let me follow up on that. You were talking about an alternative, which is assume you're going to comply, but if there's any reason to think you haven't, have some kind of way to verify retroactively, I gather. How does that happen if you're not keeping the records? If Sound Exchange or a copyright owner thinks you've been violating the complement, they go to you and they say, we think you have. Mm-hmm. How do you prove what happened if you don't have the records?
Okay, so one way that you can do that, and again, we're still sticking with the example of a webcaster that uses software to program its streams, although some of the same stuff can apply under other circumstances. Yes, one way is to have us actually recording all of this data of what we're playing retroactively, which, by the way, is not the same as delivering it on an ongoing basis. So the first issue is whether or not it needs to be provided on an ongoing basis in order to determine compliance. And the second is whether or not it's provided after the fact. But another approach to take, and this is specifically in the case when we're talking about software that generates playlists, is allow a third party to come in to get complete unfettered access to our software, to our databases, education from the people who work in our organization, to in fact indicate this is the way our systems program our music. Now I will tell you that software is frequently very complicated. That's true. I would argue far, far less complicated than the retroactive reviewing of millions and millions of rows of data. But nevertheless, it can be done. There are isolated portions of software that do isolated things. It's a kind of a methodology for establishing that certain rules are affected in certain places. So, in our case, for example, there are actual components of our software which review the playlist as it's being generated for the listener and throw music out that isn't allowed to be there because it would break with the performance complement. Does everybody have that? No. And so there may need to be other ways of handling that for other programmers. But for those who do use software in order to generate these playlists, there are mechanisms that I would argue are far better if there's a determination or reason to believe that we are not adhering to the performance complement for determining how our systems work and what they program.
Okay. I'm going to go with the list that I have, which is, it was Linda, and then it was Bruce, and it was Amy, and anyway, okay, Jonathan, keep your hand up. No, you start. Okay, I got them.
Well, good afternoon, and 6 years ago, I had the pleasure of going through something very similar before you, which had to do with the subscription service notice of record keeping. And I feel like deja vu all over again, because 6 years ago, the subscription services made the very same arguments that the webcasters are making. Not one round, but 2 rounds. They argued that there was no right under the law. They argued that it was beyond a very limited and defined definition of what notice of use should be. And the Copyright Office determined not only once but twice that the fact that Congress put into that law a very specific and defined right, which I dare say is as important to our industry as the royalty that's being paid, is the ability to, in some way, minimize the effect to the displacement of sales, which is what all of this has to do with. So the minimal royalty that we get is just one part of the equation. The Copyright Office recognized this. They recognized that this was a very important right, and without an ability for us to test whether it was being complied with, we had no right. And then you very graciously reconsidered that when you put out the original determination. Now, this proceeding, although maybe fewer people were involved, went on for over 2 years. Right. This was not a simple proceeding. These were not arguments that you considered off the cuff. This was something that was very, very carefully considered 6 years ago. And you recognize that this is a very important right that we have, and without data to test for it, we have no right. So I guess I'm just a little confused right now, because I don't see what new arguments are being proposed. I don't see why it is that not only do the copyright owners have to expend more resources re-arguing this, but the office has to expend more resources re-arguing whether or not we have a right to something that is so very clearly in the law.
Could I ask for a question? Do you mean to say that the transmissions do displace music sales of themselves?
Well, the whole basis of whether it's home taping, whether it's this, is what effect this has on our industry's business. And one of the ways to counteract that is to have some control over what it is that you can perform. And that's where the sound recording complement comes in.
What Linda's probably going back to is in 1995, when the right was actually created. It was created for digital only, and it was very limited in what it applied to. It was subscription services. But it was, in part, the argument was that we were migrating away from just earning money from the sale of records to having these types of subscription services and on-demand streams, as it later turns out, is basically taking the place of purchasing records. So that's just where the congressional intent was, and that was what was argued at the time. We have Bruce, Amy, Jonathan, and Steve.
With all due respect to it works. Prior determination, none of the clients for which any of the hats that I have on participated in that prior determination, had an opportunity to make any arguments in that prior determination, and moreover, we were looking at a different statute in that, or you were looking at a different statute in that prior determination. Right now, you have an act that has 9 conditions on the statutory performance license. The first one, to be sure, is the sound recording performance complement. But then we see that the transmitting entity shall not cause to be published or induce the publication of an advanced program notice. And then we have no prior announcements. Actually, if you count, that's subheading of number 2. I mean, when you look at the specific obligations, there are many more than 9. Then we have something about archived and continuous programs. Then we have a prohibition on offering visual images simultaneously in a manner that is likely to cause confusion as to the origin or sponsorship. We have cooperating to prevent scanning, and the list goes on and on and on. These are all, at least apparently, given equal weight as conditions with respect to the statutory license. I have not heard anyone, and I have certainly not heard RIAA ask for information that pertains to anything other than the complement. But let's not, the question isn't what people are asking for. The question is, as a matter of statutory construction, what is a reasonable construction? It is reasonable to read the complement in pari materia with the other conditions. And those other conditions have nothing to do with reports of use in many cases. In some cases, perhaps you could stretch a little bit and say that a report of use might sweep up what's involved in that other condition. But to the extent that this rulemaking concerns a report of use and notice and keeping of records with respect to use, really doesn't have much to do with those conditions. And you would have thought that if Congress wanted us to be talking about conditions, there would have been reports demonstrating compliance. Last comment, although I have many others, with respect to Linda's question of what are we to do, the same thing that licensors generally do with respect to the satellite digital audio radio services. If you suspect there are violations of the complement, you listen. You tape, and you see whether there's a violation of the complement. We're not in a position, you should certainly not be in a position where the reporting obligation and the record-keeping obligation that we're talking about here is driven by compliance. That's not a notice to the copyright owner that their work has been used, and it's not a record with respect to how that work was used.
I'm seeing people shaking heads, so I take it a number of you are supporting Bruce. We're going to go Amy, Jonathan, Steve, Linda. Amy.
It's just really to underscore, and I don't know if this is on, I guess it is. It's really to underscore something that Bruce just said. In the 1998 determination, which my client Music Choice was a part of, the Copyright Office, I think in its order, stated that because the performance complement is so specific, Congress intended that there be some measurement tool, there be some way to monitor compliance with the performance complement. I think that was part of the rationale that the Copyright Office had gave for its conclusion that monitoring compliance is a permissible purpose or a permissible act under the then DPRSRA, and I always forget the acronyms for these different statutes. My argument would be if Congress had meant that, it would have said so with specificity, as it outlined the complement in specificity. As in 1998, it amended that act to add the additional requirements that Bruce talked about. These are very granular. They detail every act that a webcaster makes, and had monitoring compliance and the requirement to issue reports for compliance monitoring been congressional intent, my argument is they would have specified it.
Okay, thank you. Jonathan.
I appreciate Linda's whimsy and her deja vu. It's a shame that you have to churn out the same papers again. Maybe your lawyers won't charge you this time. I think that those of us who are parties today that were not parties back then plan on making probably many of the same arguments, but since we weren't parties back then, we didn't have the opportunity to make them in perhaps the same way, or frankly to go up on appeal if we lose the same argument. And we have this strange rule in this country that you're presumed innocent until proven guilty. And when we file our taxes, we don't file all the supporting documentation with our taxes. We sign that we're telling the truth. And when we take a traditional license, copyright license from ASCAP or BMI, or frankly from most of the record companies, all of the record companies that I've been representing in my past life clients who are doing deals, it typically has an audit function in there. And they have the right to come in and audit, and if you're off by 5% or more than 5%, then in fact what it flips is the burden of costs on the audit. And there's all sorts of ways to manage that. I am, on behalf of an association, not willing to endorse Alex's proposal about software audits because, frankly, I'm just not sure what the costs of that are and the intrusiveness of it are. I think that in a situation where we have services that have hundreds of channels, some have posed that they have thousands of channels. There is an ongoing dispute in court about things like skip buttons. One is not always in charge of what one is specifically performing. We also have a group over at the Recording Industry Association that has proven itself very effective at policing infringement, typically through large-scale litigation, but occasional phone calls such as one which one of our members told us about, where he got a phone call that said, gee, when I push the skip button 276 times in a minute and a half, I can hear the same artist 4 times in a row, damn it. And you're violating the complement. So those sorts of enforcement mechanisms are already underway where they're utilizing the functionality of the service to listen, to make sure that even under atypical circumstances, the complement isn't being violated. And they do have ears. They can listen. ASCAP listens and writes things down. Other people come in and write things down. I frankly think it's offensive for the heavy-handed government just to be telling us we have this extraordinary reporting burden merely for taking this license, which Congress has granted us. I don't see anything in that license in the statute about police power, and I don't see anything in that license which says with great specificity that this is required.
Okay, we're going back to Sound Exchange.
I
Steve
think-
and then Linda.
I think it's important to recognize here that without data to test compliance, there can be no enforcement of several of the conditions on the statutory license. Several reasons for that. One is that many of the webcasters create their channels on the fly, so no assurance that what any particular RIAA or Sound Exchange person who might try to listen to a service is listening to is the same as what other people are listening to. And maybe if you had confidence that the software is consistently applied across all the channels, you might infer that, but the channels are all different. So you can never hear a particular set of programming that is being sent to any particular listener on one of these channels through monitoring. Even where that is not the case, and there are channels that are multicast to multiple listeners, there are an awful lot of webcasters out there, an awful lot of broadcasters pushing the envelope with new different kinds of service offerings. And it would be easy for copyright owners and performers to devote all of their royalty income to trying to track down all the different webcasters and listen to all the different channels. And that's not the right answer here. It's just not economically reasonable for copyright owners and performers to be able to monitor even the subset of channels that they could monitor. But beyond all that, I think, David, you kind of hit on this a few minutes ago. I think our morning's discussion demonstrates that if the Copyright Office does not require, in the words of the statute, that records be kept, webcasters will not keep them. And that means that even if a copyright owner had reason to believe that the complement was being violated, and it sued the webcaster, and it subpoenaed the webcaster, there wouldn't be records. And so unless the office requires that records be kept, that demonstrate compliance and that they be made available to the copyright owners, there can be no enforcement. Alex's suggestion of software audits, I think, is not a sufficient substitute because it's very hard for any third-party auditor to get into the software. You'd said, well, we've got a discrete component of our software that does our compliance checking. But then how do you demonstrate that that's the software that has been called from elsewhere in your software every time that you use it? That's what a software audit is. And how do you demonstrate that that software has been used continuously since 1998?
So let me see if I understand. Your proposal is that because you don't want to spend all of your copyright holders' money on sitting and listening to stations to determine whether or not there has been a violation, you are going to spend the hundreds of thousands of dollars per technologist that it's going to take you to hire all these people to process all of these reports on an ongoing basis, where a bell will go off when one of the companies, of which you just said there are so many around the world, is in some way in violation of the performance complement.
No, that's not what we're saying.
Okay.
What we're saying is that your companies are choosing to take a statutory license, okay? A requirement of which is, in addition to paying royalties, certain other requirements, a very important one of which is the sound recording complement. In order to make your use a permitted use under the law, you not only pay royalties, but you also abide by these other requirements, okay? This is what the Copyright Office said 6 years ago, so I'm just using your words. So when we say we want a notice of, when the statute says that we need a notice of use, it's a notice of permitted uses, which means that we have to be able to ascertain whether not only you paid your royalties, but also whether you have satisfied these other requirements. And 6 years ago, the Copyright Office found, after listening to all these arguments, that the subscription services with something between 30 to 90 channels, that it was impossible, okay, for us to be able to monitor 3 services with 30 to 90 channels. Right. But you would now have us believe that it is more possible for us to monitor how many thousands of webcasters with how many thousands of on-the-fly channels and et cetera, et cetera.
But now it's my turn to say no, that's in fact not what I'm suggesting, and I would never expect that you'd be able to do that either. What I'm saying is that this is a new business, it's a new medium, and as a result, you guys, as well as we, face a lot of new challenges. And one of those new challenges, yes, is that there are thousands and thousands of stations that cross many different company boundaries, many different licensees. But what I'm not hearing from your description is how this new situation with a much larger body of licensees should actually dictate that you need to receive the incredible volume of data that we're talking about, because it is in some way going to assist you in achieving your goals. It is not.
Let me interject. I've got a question for Linda and Steve, and then a question for the people on the user side. For Linda and Steve, since 1998 you've had this requirement, and I'd like to have some sense of what you've done with it. What have you been doing up till now with the information you've received that is there to assist you in monitoring compliance?
I think I'll have to pass this to Barry.
Okay, great.
I think I'd like to address this from what our system does with regard to the sound recording complement and how we test for compliance. We've received logs from the pre-existing services, and they are date time stamped by channel. The reason for that is specifically to test for the sound recording complement. We have written a software program that is part of the loading of the logs and part of our data cleanup exercises around those logs to verify that the information that has been reporting is in fact identified the copyright owner, the artist, the album, and the title correctly. We don't test for the complement until after we have gone through that data quality cleanup exercise. The reason for that is it's possible that by virtue of misreporting that there is a violation inadvertently in the log that isn't a true violation. So we go through this data cleanup exercise. Then once that data cleanup exercise is complete, we do what we call finalize the log. And part of finalizing the log is running our sound recording complement algorithm on the data. This does not require human intervention. This is a software program that analyzes the data and checks for the various components of the sound recording complement in a 3-hour period across the log. When there is an apparent violation in the log, the system extracts the portion of the log that is the apparent violation. At that point, there are some additional tests that are done to verify that it wasn't a violation that was introduced by virtue of our cleaning up the data. So, and when a violation is identified, it could be because the services are unable to or did not provide the album. Instead, they put the word CD single on the album. And we would get thousands of violations based on the entry of a CD single. So, of course, there are certain key words that we exclude from our test of the complement so as not to have the voluminous violations that are spurious. When a violation is identified, it is the policy of the Sound Exchange that we would discuss the situation with the licensee, alert them that do you know that you are not complying with the complement? Here is the period, here is the log where you are non-compliant, and we give the licensee the opportunity to address the violation. We don't want to shut you down, we don't want to sue you, we want you to be compliant. And it's the only recourse that we have, correct me if I'm wrong, Linda, around a violation is to sue. So it's in our interest to get the logs compliant.
Do you do this on every single log that you guys have received?
We do this on the detail logs that we load and finalize.
Okay. Have these guys all gotten phone calls about violations?
I just want to make sure it's all of them. I mean, like, so it's not sampling.
No.
I mean, we've got the 3 pre-existing services here. I'd be interested in sort of the practical, I mean, you guys give this huge data dump every month. You assume that they go through this wonderful data thing exercise. How many phone calls do you get about violating a compliment? I mean, you don't have to, you can say I pass, but, you know, I mean, is there a practical issue here that
I've received no phone call about that particular issue.
anybody?
No one's contacted me to say that we received this.
So you've gone through this massive data exercise of writing code and putting together terabytes and computers strung together to make no phone calls to anybody. I mean, it just seems to me if we're worried about violating the compliment, we're worried about sales displacement. That's the basis of the compliment. And I recall this exquisitely.
Deja vu all over again, right?
But if we're worried about a sales displacement, we're worried about making sure that traditional revenue streams aren't undermined by the new media, and that this is complementary and incremental benefit to the recording artists and to the recording companies. Accidental violations or even ministerial violations, just the amount of resources put in there. I mean, if somebody's playing a Bruce Springsteen channel, you're going to know it in a matter of minutes, if not days, at worst case. And you're going to be able to go, I mean, it's just going to be so obvious. When Napster went up, you guys knew it. When Kazaa went up, you guys knew it. If somebody is intentionally doing this in order to, in ways that are harmful, you're going to find out. Because the artist's going to find out, or the manager's going to find out, or the label's going to find out. It's not like you're worried about some little tiny webcaster who might be playing a Bruce Springsteen channel to his 9 friends, and damn it, those 9 people have stopped buying Springsteen albums. You're talking about large-scale commercial piracy or commercial violations that undermine the traditional revenue streams of your clients. It just seems ludicrous that you're talking about legitimate companies who are in business to do the right thing. I mean, you're tarnishing us all as criminals for this.
Well, no,
If I'm a record label or an artist, I'd be perplexed over the fact that you're spending any money to do this. The fact of the matter is that these rights or these services are reporting and paying royalties and furnishing information for distribution. And what you're looking for is to find someone, they're guilty, and then we have to prove ourselves innocent.
And if you're really lucky, you can screw us out of the compulsory license and bring us to court.
Excuse me. The fact that someone would run a Bruce Springsteen channel, or by mistake, the software would trigger 2 tracks in a row, that's Sony's problem to come and sue for it, not yours. It's there they hold the copyrights. You only administer on their behalf. And I'm telling you, if I wrote music, I'd be out of my, and it was a record label, I'd be out of my mind that you're wasting that kind of money.
well, first of all, as I said earlier, that is one of the requirements for the statutory license. That is one of the things that this industry fought for, is the sound recording complement and some of the other ones. But obviously, sound recording complement is nearest to my heart. So that is one of the things that we found important. So to have someone on the other side who is supposed to be providing this information tell us that it's not important, maybe that argument should have been made on the Hill before it was passed.
That was before my time, so
well, but,
don't tar me with that.
Right. But the bottom line...
I don't want to go back to deja vu anymore. I don't want to go back to 6 years. I want to talk about today and going forward. And I'd like to talk about today and going forward in a business fashion that's cost effective, so that the authors, so that the record labels and the artists secure the royalties that are being paid, and they do it in an efficient fashion.
Okay. And today and going forward in the law, there is a restriction with regard to the sound recording complement. And therefore, there is a right.
When the Food and Drug Administration which I would argue is a more important agency in terms of regulating than Sound Exchange, and probably even more important than the U.S. Copyright Office to the health and welfare of Americans. When the Food and Drug Administration imposes on manufacturers of pharmaceuticals good manufacturing practices, or GMPs, it doesn't require that every single pill that comes off the assembly line has a certification with it that goes to the consumer, that goes to the regulatory agency that says this pill is good. And they don't require manufacturing runs to spit out data that says, yep, another good day. We didn't have any mistakes today. But instead, every year, typically actually the truth is every 2 or 3 or 4 years, given the limitations of the regulatory agency, they go in and they check. They go in and they check. And we're talking about drugs here. We're talking about things that can kill you. But here we're talking about massive amounts of self-reporting every single day, every single hour, every single moment. That is, it's ludicrous to try to catch somebody for a meaningless violation. If a violation is going to be meaningful, you'll know it.
Can I follow up on something that Alex said, and I'm probably going to overstate what he said, but I'd like to get the reactions of the other people who are on the user's side to this. And that is the difference between maintaining the records and reporting the records. I'm wondering how significant that is. And what I'm really getting at is how many of you are comfortable with keeping the records that, if asked, you could produce so that compliance could be verified? And is that a significantly lower burden than the burden of producing the records on a regular basis? And is it a burden you could sustain?
Well, so it's two things. Number one...
I'm sorry. I'm primarily interested in other people's reaction because I've sort of got yours, although yours is of interest as well, but I'd like to hear the others.
Maybe Mary has been trying to jump in.
Yeah, my comment is directly to that kind of record keeping. Just as my background comes from commercial radio. I was in commercial radio my entire life until getting into IM Networks and Sonic Box in the last 2.5 years. I was brought on board there because I'm a radio expert, and one of the things in radio is if your ratings go down, who's the first person that gets fired? Anybody know the answer to that? The program director. Okay, programming is the business of radio. When we report a log that says what we played, in what order we played it, we are giving away our business plan. I have no objection to keeping the records, maintaining the records, but I have a massive objection to reporting the records all of the time of what we're playing. If we're suspected of being in violation, come on down and audit me. Come on down and look at my logs. We'll keep the logs. We'll pay the fees. We're not objecting to that. But to give away my programming, to give away my business plan it just seems like a most unreasonable thing for the government to require of me, because just as it's been mentioned that radio is not the music business. The music business is not radio. And while as much as we are cited for paying our bills for our bandwidth, for our business expenses and such. And I do believe that artists deserve their rights, deserve their royalties. As much as we're cited for that, licensing the music is another business expense for us. It is not our business. And to report our business, the nature of our business, the nature of our programming is objectionable, completely objectionable. Yeah, because...
Okay, I'll restate it. Yes, the question was, I'm drawing a distinction which I think I first heard Alex make between maintaining records, which if someone came and looked at them, one would be able to determine whether you have violated the complement. It's essentially you're maintaining a log of your playlist, what you've actually played, but not turning them over, just maintaining them. And there'd be a requirement that you keep them for some period of time, so that if there is any question, you produce them, or you let someone come in and look at them so they can confirm that. That as distinguished from actually turning over on a regular basis your records of everything you're playing.
May I illustrate how that is that we would turn over a log of what artists we played, the number of spins, much like Coca-Cola lists the ingredients in their product. But to give away the formula for Coca-Cola, one of the most biggest corporations in the United States, is to give away their programming.
David, are you suggesting...
Regulations.
What Alex suggested, it may not fly, and I may be told by a number of people it doesn't work, but what he inspired in my mind was a notion, well, fine, we don't have a regulation that requires you to turn this information over, every bit of it, to Sound Exchange, but we might have a regulation that says you will maintain those records, and copyright owners may demand the right to inspect them on a limited basis, and you will have them available so copyright owners may inspect them in order to verify compliance.
I would think on that, we could probably, I wouldn't like it because I think that you'd be sort of pounded to death on it, but the fact that you sort of like, you're not turning it over every month, but you just stand there and take a whipping every other month when somebody asks for the information. I think one of the points that you made to me is most important. When you say the copyright owners, the fact of the matter is that Sound Exchange is not the copyright owner. So if Sony or 7th Street Lounge wants to see what we're doing and they call up, then that may be very different. We send those reports out to the labels anyways when we pay their royalties. So I wouldn't mind keeping it with that, but the fact is Sound Exchange is not the copyright holder.
But what I'm getting at largely, although not completely, is the burden. I'm hearing there's a big burden in producing this stuff, and my question is there, what kind of burden are we talking about in terms of maintaining the records and having
It's a massive
It's massive
burden.
because you're producing it, it's going to cost you a
It's
lot.
the terabytes of storage that would accumulate over time, because one could imagine what the requirement is going to be. It's going to be, you have to maintain it for 3 years on an ongoing basis, and they can come in for an annual check once a year, and maybe there's 5 major labels and 5 or 10 other indies who come in once a year. It is a massive storage problem. You're producing, if you're talking about a music match with hundreds, if not, in fact, thousands of channels, a Yahoo broadcast with launch, with personalized or consumer influence channels combined with band-oriented channels, all sorts of channels that are created with software. You go on one of these stations, you say, these are the 5 bands I like, they produce a channel for you. All of a sudden, they've got to have an automatic storage facility which lists the playlist for that channel forever. It's a massive storage problem.
David, I have problems now getting my programmers to keep historical data. They don't like to do it. It takes up a lot of storage space.
It sounds like turning it over is a better solution then.
Wait a minute.
Well, it depends. It depends
You have
on.
to keep it too.
No,
Wait a minute.
One idea that might actually cut the burden as well as allow the copyright owners to police compliance is to set up a system whereby you sample. It's a rolling basis. It's periodic. It's every 8 weeks. It's every 12 weeks. You turn over a day. And then they have a way to survey a universe of data to see if these, and I also want to just kind of refocus on something else. Mistaken excesses of the complement are not covered by the statute. That's not a violation. It's willful and repeated or something. I don't know the words, but it's willful. And so by setting up a survey whereby you have people reporting periodically, they don't have to maintain the records, they're not going to be asked for them every other month, but yet you do empower the copyright owner to have the ability to police and make sure that people are, by and large, complying with the complement as is required.
Excuse me, could I respond, please? Wait a minute, okay. You haven't spoken at all, Dave hasn't, Bruce hasn't. The question is, do you want to hear from everybody and then respond, or do you want to jump in now? What I thought was maybe helpful was to let everybody who's on the side of providing data to have their piece, and then for you to respond to everybody. And I know that Dave is waiting to come in and Bruce is waiting to come in. And it's 5 minutes of 3, yes. Okay.
I think it really depends, David, on your question. I think it really depends, and correct me if I'm wrong. What is easier? You said, is it to just hold the records and turn them over if required, correct? Okay.
Not necessarily turn them over, make them available.
Make them available. Okay. I think that really goes to the heart of it depends on what's being asked to report. If you're keeping the very simplistic, what was mentioned so many times back in the first panel, which Patricia really didn't answer very well, and the RIA just completely disregarded in terms of answering, was the song title, the artist, the album, and the recording label. Those 4 requirements are very easy to keep on an updated basis all the time. If it gets to those 18 pieces, because we disregarded the other 7 for listener logs, it gets extremely difficult. extremely burdensome, extremely onerous. But those 4 pieces, those 4 essential pieces, that's all they need. If I'm playing Stop Making Sense by Burning Down the House by Talking Heads, it's on 2 albums within 2 years. It's on Speaking in Tongues, which is a studio release, and then it was followed up the next year on Stop Making Sense, which was a live soundtrack to their concert film by the same title. If I tell Sound Exchange, the RIA, or Warner Brothers, who released both records, I'm playing Burning Down the House by Talking Heads and I'm playing on Speaking in Tongues, they should know what backup musicians were on the Speaking in Tongues record, and they should know what backup singers were on the Speaking in Tongues record. However, if I tell them I played on Stop Making Sense, they should know, ooh, red flag, live record. They should know that Edna Holt and all these other people were involved in that. That should be there. We can keep that information. It's very simplistic. But those other 18 pieces, those other 16 pieces, whatever it is, no. To answer your question, it becomes very, very difficult.
Okay, Bruce, and then the record industry, Sound Exchange, combination, whatever. And then we've got to go to the next question because we've got a panel after this. Bruce.
My sense is that the burden difference between reporting and maintaining is some, and there's also the question of the nature of the proprietary information, the extent to which that information should be turned over. But frankly, the bigger question is the reasonableness and the burden imposed or potentially imposed by keeping the data. For example, with the satellite digital audio radio services, I believe if you look at their comments, you will see that they, because of the nature of their systems that they have put in place, have agreed to provide information from which, for example, compliance with the complement could be determined, because they have that with respect to the channels that they're programming. They do not have that with respect to the channels that third parties are programming. So the underlying question of the burden of gathering the information is the same and needs to be looked at in the same light, whether you're saying keep it yourself or turn it over. And I would submit that it's equally inappropriate under the statute. And first of all, we're sort of singling out the complement. Are we sitting here now saying that's all, that's the universe? Is that what compliance is all about or not? Your question seems to imply that we're talking about the complement, that you've got to make the judgment as to whether, based on what you've seen, the data gathering and data maintaining burden is even reasonable, even after you get, first question is, does the statute authorize it? I submit no. Second question, once you've concluded, or while you're evaluating that, you look at the question of burden. The burden is roughly the same. The data gathering burden is roughly the same whether you turn the data over or whether you maintain it. In addition, there are additional factors that have been pointed out by others on the panel and at the table with respect to turning it over as opposed to keeping it. So there are burdens and problems at each step of that process.
Karen, did you want to?
Yes, actually, with respect to radio stations specifically, you're going to hear from, I know, at least one on the next panel that doesn't even keep playlists. That's just not how their business over the air operates, which is, the records that you keep is a different question than, whether their actual programming practices comply or not. And, the reporting requirements here, the dog, is to use the tail wagging the dog analogy, really is it should be the use of the music, and rather than, this extra, police, should RIAA or the Sound Exchange be a police cop to enforce everything? And if the burden, is multiplied exponentially, to keep census data that some stations can't even report, some stations currently don't report, with storehouses of records just to check compliance with the complement, that's really a question of kind of the tail wagging the dog and getting out of hand.
Okay, 30 seconds.
Yeah, for Yahoo, I think it's important to note that while proprietary issues of data passing would be saved by not having to deliver the information on an ongoing basis, specifically with regard to the way our system works, we are talking about millions of rows of data. We're talking about tremendous storage on a daily, weekly basis. This costs us hundreds of thousands of dollars per year if that's what we're talking about storing. This is not a small undertaking, and I think it's unduly burdensome for the end goal.
And once again, the public broadcasters have an exemption from all record-keeping requirements.
All right, over here.
So many issues. I will try to tackle a few of them, and Linda can pick up the ones that I forget about. I think most important, it's extremely important to recognize that the performance complement is a very key piece of the DPRA and the DMCA. And also important to recognize. Hello?
Is it good? Can I use mine? Can't find mine.
Well, important to recognize that the performance complement was a key piece of the original Performance Rights Act in 1995, heavily negotiated among all of the affected industries. We then went through an extensive rulemaking proceeding here in the Copyright Office, during which the office a couple of times answered this question and determined that copyright owners and performers were entitled to information to determine compliance with the complement, which we viewed as very fundamental to the Performance Rights Act. And only then did we go through the DMCA process, where we once again agreed to extension of a statutory license, which I think it's fair to say the record companies would only have accepted, knowing that they had the complement and they had the ability to enforce the complement, bolstered by the Copyright Office's previous decision. So enforcing the complement is a very serious point for copyright owners and performers, and we think that any decision that would undermine the ability, in fact, effectively make it impossible to enforce the complement and some of the other conditions would be a very serious derogation of the rights of copyright owners and performers. Second, there's been a lot of talk about the volume of data. Incredible volume of data will have to be produced. I think we should think no small thoughts here. In order to effectively report use of sound recordings, a lot of data is going to have to get delivered. Barry has been very busy developing systems, big databases, big computers to process lots of data. And I think the data that will get reported as a result of your decision based on the conversation this morning will be a lot of data. I think we are not talking about orders of magnitude more data for enforcement purposes, but if we can process it, you can find some way to deliver it. Third, David raised a question about inspection of data, and I think in assessing the burden of delivery versus inspection or access, it's important to recognize that there's a lot of data here. And so inspection isn't a matter of sending an auditor over to read the books. It is necessary that this analysis be done by computer to process the large volumes of data, which means that the data has to be formatted. And so we think that delivery of the data to record companies in a formatted way, as we've proposed in our comments, is an appropriate way to allow copyright owners and performers to assess compliance. If the Copyright Office were to allow webcasters to withhold that data, it would nonetheless have to be formatted and the records kept in a way that would be capable of being processed at some point in an audit. And once they do that, I don't think it's so hard to physically deliver it to us. Which leads to the next point, which is that the existing regulations contain confidentiality provisions. The regulations that were proposed by the office contain confidentiality provisions. I hope our friends in the pre-existing services would tell you that Sound Exchange has never disclosed their playlists to their competitors. And so I think the office should not be worried here that Sound Exchange is going to take radio stations' playlists and start passing them around the industry. Finally, Bruce raised a question about the office's authority in this area. which I think relates to his earlier question as to whether compliance is a record of use issue. And I think it is. Bruce is certainly right that there are a lot of conditions. They're each different from the other. We would say they're all important. Some are more easily verified through records of use. The complement naturally relates to records of use because once we know that a particular song has been used in a certain way, we can test for compliance, and we're very interested in that. Cooperation with efforts to prevent scanning is probably not a record of use issue, but that doesn't mean that we shouldn't have access to data to determine the compliance with the complement. Linda, what have I forgotten?
Covered it all. Okay, thank you. We do have a question that we did want to raise. We don't need to talk about it a long time, but we do need to get some input on it. And it really has to do about records for the use of ephemeral recordings. This is the Section 112 license. And the question is, why must there be records for ephemeral recordings? And the issue of how necessary is it to have, or is it necessary at all, to have information supplies about the timing of destruction of each ephemeral copy? Who wants to go? Bruce? Amy?
Well, I mean, at first I noticed from RIAA's reply comments that I don't think there was a mention of the word ephemeral recordings or any of the requirements relating to ephemeral recordings anywhere in it. So unless I missed it, maybe somebody can point to, but it may be that there's no longer any controversy over this point.
Is that right?
It may be right that it is not mentioned.
Bruce, you're half right. That's better than usual.
The fact that an argument is set out in the initial comments and may not be repeated in the reply comments is designed to save the Copyright Office from having to read redundant pleadings.
If only you'd succeeded.
But I think what this actually highlights, this and the demands that are attempting to be put on people who aren't my clients, the background music services, highlights the trap that you can get into with respect to compliance and reporting for the purpose of compliance. There is no fee difference with respect to ephemeral recordings based on the number or the duration that you keep the ephemeral recording. Just as there is no fee difference with respect to background music services with respect to what they perform and when they perform it. And so the question you all need to ask yourself, and by the way, we've just heard a pronouncement that the complement was particularly important. But now the question is, are you going to take that principle, assuming you buy that principle vis-a-vis the complement, and extend the principle to establish an entirely independent regime of reporting with its own enormous burdens and difficulties in the name of compliance? Because it is absolutely clear with respect to ephemerals, for example, that there is no fee impact, at least with respect to with respect to the non-subscription services CARP that we've just finished. The fee is independent of the number of ephemeral recordings that are made. The contribution to the pool, if you will, is independent of the number of ephemeral recordings made. It would be mind-boggling indeed if we were to be informed that the distribution was therefore to be different on that basis, given that the contribution to the pool was completely unrelated. So why put burdens on services to start reporting for issues that have no fee impact? I believe that is well beyond the scope and well beyond rationality in this context.
Amy, do you want to add?
I'm speaking in terms of context of commercial services. Now it is, okay. Speaking in the context of commercial services and the ephemeral recording requirement for commercial services, the CARP has just, of course, finished on this aspect, and they were working under the assumption that ephemeral recordings include all of the buffer and cache copies, the millions and millions and millions of copies that it takes to render a service. And I think that, Music Choice has made a filing that assumption casts some cloud over who exactly the ephemeral recording requirement applies to in the commercial context, but leaving that aside, from a feasibility standpoint, if that's really what ephemeral recordings are, how in the world can anyone attest to date of creation or date of destruction when it's on the intermediary servers between the service provider and the person that receives the service? I don't think anyone can certify. It would just be factually impossible to do.
Right.
Kind of expanding on Amy's point over there, I've been webcasting. I guess I got started in this industry in about 1995. Actually more like 1992 if you count early experiments on what was known as the M-bone, before the internet was really commercial. Anyways, I've also along the way developed or helped build a very large content distribution network. Basically, the way the network worked was to take a copy of a file or a stream, broadcast it over a satellite to 600 locations around the world, about half of those in North America, about half of those outside North America. To compound that problem with the ephemeral recordings issue, large corporations, some small corporations, and most every internet service provider in the country employs their own private caching devices, which again will take a file, make a copy, nobody knows it's there, and the next time a user connects from that ISP, it sends a request out to the origin server, which is usually a third party because these small and medium-sized webcasters outsource this whole distribution process. And then that request is made, and then that file gets served off of the local machine for better performance. It's basically what makes all this stuff work. So policing, or even counting the number of copies of any given file at any given point really is impossible. And that's it.
Okay, we have Alec, Seth, Joseph, and Barry. And then we'll end up over here, yes.
For Yahoo, I just want to throw in, we essentially use third-party services as well as our own. We are talking about tens and hundreds of thousands, almost millions of individual songs that we have in our library, and then multiply that by the number of copies that are made in an automated fashion. And the copies that are made in an automated fashion for all of the examples that have been given up to this point are there to support scale. And that's really important to keep in mind. We're not making copies for a good time, because it actually costs money to make copies. We're making copies to support the number of streams that we are supplying. And, as was evidenced by our conversation this morning, the goal is to pay for those streams that are delivered. So if these things are tied together in such a lockstep manner, what is the point of this extra blob of information?
Seth?
This follows up on Alex's point, which is that really what's involved here is that there has to be some kind of analysis of the cost involved in maintaining and collecting the information and the benefit that's derived from it. The Copyright Office has noted in its report of August 2001 that essentially there is no value to the ephemeral recording apart from the value of the performance itself. Notwithstanding, certain people have ordered, at least on an interim basis, that there is an economic value that's assigned to it. The cost of collecting this data is huge, because for each and every sound recording you're going to have to actually physically record dates when it was first loaded, dates when it was taken off for each and every single one of the servers that may be used by a service. It's a huge amount of information burden to input into the system, aside from the burden of actually doing the loading and the deletion. And Alex's point is a very important one, which is that, is there information that's already present that basically is a proxy for any benefit that you might get from collecting this data directly? And there is. You get the information on how many times a specific song was performed, and that is very likely to closely correlate with the number of copies that are actually made to support those performances. If you need to make extra copies to make more performances, then logically the more performances you make, it's likely the more copies you have. So you don't need to collect information on how many copies there are. And going back to Jonathan's earlier point with respect to how is it that you approach this problem, do you treat everyone as an infringer and a scofflaw, or do you start from the premise that if you sign something that certifies that I have complied with the requirements imposed by the statute in order to qualify for the statutory license, you should be able to sign there and make your statement under penalty of perjury. That seems to be the appropriate approach here. And certainly the cost of collecting this data is completely disproportionate to the amount that's going to be paid under it, first of all, and second to any value that might be derived from it.
Joseph.
When working with the cache technology, there is no silver bullet here that actually says that you can come to a common log file format from a cache. That doesn't exist. You actually have to work with the vendor who's created that cache in order to create something that will work, that will give you the information. The other thing is, any kind of server log can be manipulated. If you want to show no listeners off a server log, it's easy. All you have to do is take your text editor and just eliminate the references. So what are you going to have? Someone in the data center that's going to actually have to be bonded or certified to send this data?
Barry.
The cache and buffer copies are really ubiquitous to the digital transmission. And in many seconds, those copies reside for a nanosecond, a millisecond, and the requirements ask for this industry to furnish that information. I don't know, and certainly not a technical expert, but would challenge that you could probably not technically be able to do that and be able to register every copy. And also, I just think that it's another, it doesn't change the rate that has been proposed, and it doesn't change the way that the distribution is going to be made by sound exchange. So therefore, I think it's of no value at all.
Okay, we're going to end with sound exchange. Oh, you need...
Once again, I'm afraid I have kind of a laundry list of responses, but I will try to catch many of these points here. I think as initial matter, it's important to recognize that the Section 112E statutory license is a different license from the Section 114 license. And in the case of webcasters, that can be taken advantage of in a way that is derivative, in a sense, of the 114 license. In the case of business music services, it's wholly separate from the 114 license. So that there really does need to be a reporting requirement under Section 112. And in fact, the statute requires that the office create notice and record keeping requirements for Section 112 in addition to those in 114. The statute also requires that ephemeral copies be deleted after 6 months. And I understand that there are maybe folks on the other side of the table who don't like the 6-month retention limit, but it nonetheless is a condition of the statutory license and a condition that we regarded as fundamental.
Can you explain why, Steve, because it might help us in evaluating the importance of reporting it?
Server copies have value, despite Seth's assertion, and with all due respect to the office's report under Section 104 of the DMCA, there are a lot of ways that services take advantage of reproduction of sound recordings on servers to build value in a business. For example, by distributing copies geographically, or by building libraries that can be used over time. And it has always been the case under Section 112 that ephemeral copies are ephemeral. And retention of copies, distribution of copies that are retained throughout a network has value in a business, and builds efficiencies, lets them provide more attractive service offerings to their customers, and copyright owners ought to be able to participate in uses of their music that take advantage of reproduction of copies and long-term retention of copies, because the reproduction right is a separate right from the performance right, and copyright owners are entitled to participate in that value that is created by the use of their recordings.
And how are you participating in it? By making them destroy it and then make another copy every 6 months?
If somebody would like to obtain a retention license, record companies might be happy to talk with them. And
I don't think he needs to.
The fact that Steve reminds me that retention licenses, in fact, are offered in other parts of the world, and that the rate might be zero or might be more, but it would be appropriate for the marketplace to decide that. Because this reproduction
here in the United States.
Because
and I deal with most of the rights organizations throughout the world, just to put that on the record.
But retention has value. Because the reproduction right is a separate right and the Section 112 license a separate license, principles of copyright law might support distribution on a separate basis from performance. And I think some of the folks here assume that distribution should be made on the basis of performance. We certainly have not reached that conclusion, and I don't know that the office has reached that conclusion.
Well, then that does touch upon something very important. I'm sorry to take more time here, but if I'm hearing that there is a view at Sound Exchange that when the Section 112 royalties are distributed, I'm not sure I know what I'm hearing. What am I hearing about the view of how those are going to be distributed?
I don't think we know how they will be distributed.
We know how they said they should be collected.
Yeah.
They said they should be collected as a percentage of the performance royalty. Yeah. So let's hear whether they're actually making an argument to the CARP in terms of value. It's different from how they plan to distribute to their members.
Well, and what I want to hear in particular is whether there is anything in these reporting requirements that Sound Exchange believes will affect the manner in which it distributes those funds, because that's a very crucial question.
I didn't, unfortunately, catch the very important question.
Okay, Steve, the very important question is there anything in the proposed reporting requirements which would affect the manner in which Sound Exchange distributes the royalties under the Section 112 license?
I think unfortunately, that doesn't work.
Separate laws for the ephemerals. You have no option to distribute based on the reproduction of the sound recording. If you only have the performance laws, then that is the only method by which you can distribute the royalties.
Now, who has that option? Who has the option of deciding how to distribute those royalties?
Well, David, I think, number one, Sound Exchange, for its members would decide how to allocate royalties. It would not cover how non-members do not have a role in that decision-making, but no decision has yet been made. But the issue, I think, as Steve pointed out, is that there are two different rights. There's the performance right and the reproduction right. Now, a lot of the comments that were filed in this proceeding attack Sound Exchange, or attack the RIAA and Sound Exchange, saying that the CARP, for the eligible non-subscription services, determined that the ephemeral fee should be paid based upon a proxy, which is the number of performances. But that is very different than saying that the royalties for reproductions have to be paid based upon performances. They're separate rights with separate copyright owners. If the copyright owners who own the sound recordings that are reproduced decide that the royalties, the ephemeral royalties, should be distributed based upon the number of reproductions, separate and apart from the number of performances, then the ephemeral log will be essential for distributing those royalties. If we don't get a log for ephemeral reproductions, then there is no opportunity for the copyright owner of that separate and distinct right to distribute those royalties. They will be left distributing royalties on performances. And Steve pointed out there is a value in a reproduction. If a service such as Yahoo or anyone else makes a reproduction and puts it in their server, but it just so happens that a song is not played or that sound recording is not performed, that does not mean there is not value to having that sound recording available and in a database for which that copyright owner is entitled to compensation. So Sound Exchange has requested that data because those copyright owners may demand that the royalty distribution follow the reproduction and not some other.
All right, I need a little more clarification on this, though, because I want to make sure I know what you're talking about. Are you talking about Sound Exchange's distribution of 112 royalties to all copyright owners, or only the distribution Sound Exchange may make to those members of Sound Exchange who agree to that particular mode of distribution?
Well, that is, I think that there are complex issues regarding the way royalties can be distributed. The CARP, in the terms that were adopted in the current webcaster CARP proceeding, require that royalties be distributed, performance royalties be distributed so that each sound recording is valued equally. I think that those are the words. Now, what that may mean is that, let's say, Sound Exchange has 90% of the people it is distributing to are members, 10% are non-members. You would allocate $100, $90 to members, $10 to non-members. The $90 to the members could then be further allocated based upon however the Sound Exchange membership wants to allocate that money. The remaining 10% will have to get their money in some non-discriminatory way that values all of them accordingly. How 112 royalties may be distributed, I don't think there are regulations yet, or at least I'd have to go back and look at the webcaster CARP decision to see whether or not those terms contemplated how 112 royalties would be distributed. If they did, you still have that same situation where Sound Exchange's members can decide that the reproduction right is separate from the performance right, and therefore, in order to do such a distribution, you need information on the number of reproductions.
All right, then let's assume that the members of Sound Exchange agree among themselves that the 112 royalties are going to be distributed in some method that requires the services to report information you would need in order to actually use that method. And let's assume that's not information that would be required to distribute those royalties to the folks who aren't Sound Exchange members and are simply getting their distribution based upon whatever principles the CARP process ultimately states you have to use. You follow what I'm saying?
Yes, but I don't think the CARP addressed how 112 royalties.
I think it's going to be addressed before there's any final rule, so you needn't worry about that. You may recall another 114 decision a few years ago. We're not going to have a repeat of that. So let's assume that you want information so that your members who agree among themselves to a different means of distribution can use that information to determine how to distribute the funds. Is it appropriate for us to require the users of this compulsory license to submit to you information that is needed only because members of the Sound Exchange group have decided among themselves that they want to depart from the default distribution mode to come up with another mode of their own, which requires this additional information?
David, let me try and answer that. Is this working? I'm not sure that it's really an issue of members versus non-members. I think that the issue is the same for both, and that is whether there is going to be any information that would be made available so that those royalties, which are coming in for a different right, can be distributed based on the copies that are made under a different statutory license. Now, if the Copyright Office decides, and it may well have, based on what you're saying...
We have decided nothing, Steve, I can assure you.
That for non-members, at least, it shouldn't be. I don't think at this point there's really any... This isn't a Sound Exchange member issue. I think it's just an issue generally for all recipients of Section 112 royalties. And that question is there going to be information available to make distributions based on the copies that are made and not based on a proxy, which would be, such as the performances that are made from those copies. So
I don't think it's a membership, non-membership issue. I think it's a broader issue than that.
Yeah. You have the microphone, so why
sorry.
don't you...
All right, well then, since I have the microphone, I will say we do want to have an opportunity for people who were not around the table to comment, but I want to caution you, we do have to end at 5 o'clock. It is 3:30 now. We have a very important panel coming up. We want to take as little time away from that panel as possible. So I implore the members of the audience, unless you have something to say that A, you think is very important, and B, has not already been said, please don't come to the mic. Having said that, if there's anyone who has something to say, you are invited to.
I just wanted to very quickly touch on, there are a lot of new technologies over the last year or two which can read a fingerprint of a stream and know what's played. So as opposed to doing the analogy of forcing everyone to report their speedometer reading as they're driving down the road, it's very easy to monitor from sound exchanges and a stream to find out if they are in compliance or not.
Okay. Kevin.
Very quickly, in terms of reporting ephemeral copies, I, for one, see no difference, and I defy anyone to explain to me any difference between reporting what I have put into my servers and might play from telling you what I have on the shelf on all my CDs that I have, 5,000 of them. I might play any one of those at any given time. They have value. They obviously had value to the record companies because they sent them to me for free so that I would play them. And to suggest that the copies that I'm making just for the opportunity to transmit this over our webcast to we may or may not transmit over our webcast, and to report that, and then in effect be charged a fee for that. We're basically reporting and having to pay for what we haven't even played yet. And that, to me, seems especially onerous.
That's not too different than when you go to a buffet and you pay a premium to have something available to you, but you may not eat everything that's available to you. Well, it's true. I said you're not true.
Okay.
I think you've made my point for how much you understand what we're doing here.
Okay, we gotta go.
I'm not sure about the statutes, but I will say that in the software industry, the precedent for this has been set, and there's no company currently that I know of in the United States that pays Microsoft, Enterprise, or any of the other companies for copies that they maintain on servers to be installed on users' desktops. And that's paid for by a per-seat license that is invoked that allows you the opportunity to use that software for an end user. But companies are free to make as many copies as they wish to store on servers wherever they would like to be able to distribute to their companies.
And last?
I just wanted to say, and in a buffet, you don't pay by the bite, by the way. But, this idea of these 6-month copies is the most ludicrous thing I've ever heard of. I've been in radio since 1973. And I know that's terrestrial radio, but I know we always had songs on tape cartridges and played them in the studio. The idea of me having a song in my computer and penalizing the artist for having a song that is good enough and popular enough to want to play it after 6 months and penalize that artist so that they are not going to be paid, I just can't believe it. That this is just, I'm sorry.
Yeah. Okay, that's it. I want to thank this panel, and we're going to call the third panel. Hey, everybody. Is everybody at the table?
We're not waiting.
We're not waiting. All right. We'll start over here. We're going to go around the table once more to identify for the record the people who are on panel 3. So could we start with you? Yes.
Hi, I'm Marty. Is this on? Yeah. Okay. Marty Gelfand with Congressman Krupinich's office. It wasn't on.
Hello, I'm Peggy Miles, International Webcasting Association.
Hi,
I'm Patricia Pollack, representing the American Federation of Musicians, the American Federation of Television and Radio Artists, and the AFM and AFTRA Intellectual Property Rights Distribution Fund that distributes to non-featured artists.
I'm Deborah Proctor with WCPE Radio. We're the party that tried to get the amicus pleading filed, and we're a party that evidently had our copyright violated yesterday.
I'm Gary Himmelfarb. I'm the president of Ross Records. We're a record label, and I am also on the board of AFIM, Association for Independent Music, and also on the Sound Exchange board as the independent label rep.
Hi, I'm Will Rovedy from KTRU at Rice University. I'm representing Collegiate Broadcasters Incorporated, or CBI.
I'm Joel Willer. Faculty supervisor of KXUL Radio at the University of Louisiana at Monroe, and one of the 13 college and university broadcasters filing comments.
Gary Dobek with Digitally Imported Radio, Vice President.
Hi, I'm Mike Rowe, owner and operator of Radio IO in Jacksonville, Florida, and here representing several small commercial independent webcasters.
Michael Monahan, representing Spatial Audio.
Brian Zisk, Technologies Director of the Future of Music Coalition. I was also a founder of the legendary Greenwich Internet Radio, which was bought, merged, and then closed down. We got the rights back, and we will stream again as soon as this is all straightened out to where we think we can do it legitimately.
My name is Dave Eshelman. I'm president and owner of Massanutten Broadcasting, small market radio broadcaster in the Shenandoah Valley.
I'm Kurt Hansen from RAIN Radio and Internet Newsletter. We also have on the side 14 channels of music called RAIN Radio.
I'm John Simpson, Executive Director of Sound Exchange, former recording artist and artist manager. Recovering.
Gary Greenstein, Recording Industry Association.
Now we're going back to you, James. Introduce yourself.
I'd like to thank Mr. Carson for allowing me and yourself and the panel, the moderators for having me on the panel. I thank you very much. My name is James Cannons, okay. And I'm from our own performance society, which is, the acronym is OPS.
Thank you. Focus here is on the rulemaking and how it applies to small businesses and what particular problems there are and how they might be ameliorated. And I could ask a bunch of questions, but maybe the best thing to do is just to let you tell us what you think the issues are. And as always, we always come over to this corner and say, respond.
I could move over where Gary is and we could sit together if you'd like.
No,
okay.
I'm teasing.
I'm happy
so
to
does anyone want to start? Yeah.
I'm not sure if this mic is working.
I think it is.
Test? Yeah. Okay, it wasn't working when I first introduced myself. I'm Marty Gelfand. I'm staff counsel for Congressman Dennis Kucinich. And in the other panels, I want to represent a perspective that really hasn't been addressed. And of course, this panel is doing that for small businesses. Congressman Kucinich represents about 600,000 constituents in the Cleveland area. And in that constituency, we're served by 4 college radio stations in our broadcast area. We've got Baldwin Wallace College in Berea, Ohio, Cleveland State University in Cleveland, and then in our broadcast area is Case Western Reserve's WRUW, and we also have John Carroll University, all of whom stream. And we also have some small internet. We have Radio Crow based in our district, and there may be others. We don't know unless they contact us for the most part, but and we're real concerned about this because this affects our constituents. I'm not here representing any committee or subcommittee in Congress. I'm representing one member of Congress who represents about 600,000 constituents, but our district is not unique. I mean, I think we have the best college radio, but other than that, we're not really unique. There's great college radio everywhere. There are small internet stations everywhere, and those are the people that are building the internet, and these are the people that are putting out music that the commercial stations just aren't putting out. We have like 6 or 7 or 8 or 10 Clear Channel stations, not to offend anybody from Clear Channel, but you hear Sting, and you hear Puff Daddy or Puff Diddy, or you hear all these other people that we were talking about today, but you don't hear Blue Lunch. Blue Lunch is a local band that plays blues and swing.
Yeah.
You got the microphone, so why
sorry.
don't you...
All right, well then, why don't I... All right, since I have the microphone, I will say we do want to have an opportunity for people who were not around the table to comment, but I want to caution you, we do have to end at 5 o'clock. It is 3:30 now. We have a very important panel coming up. We want to take as little time away from that panel as possible. So I implore the members of the audience, unless you have something to say that A, you think is very important, and B, has not already been said, please don't come to the mic. Having said that, if there's anyone who has something to say, you are invited to.
We're not sharing this mic.
I just wanted to very quickly touch on, there are a lot of new technologies over the last year or two which can read a fingerprint of a stream and know what's played. So as opposed to doing the analogy of forcing everyone to report their speedometer reading as they're driving down the road, it's very easy to monitor from sound exchanges and a stream to find out if they are in compliance or not.
Okay. Kevin.
Very quickly, in terms of reporting ephemeral copies, I, for one, see no difference, and I defy anyone to explain to me any difference between reporting what I have put into my servers and might play from telling you what I have on the shelf on all my CDs that I have, 5,000 of them. I might play any one of those at any given time. They have value. They obviously had value to the record companies because they sent them to me for free so that I would play them. And to suggest that the copies that I'm making just for the opportunity to transmit this over our webcast to we may or may not transmit over our webcast, and to report that, and then in effect be charged a fee for that. We're basically reporting and having to pay for what we haven't even played yet. And that, to me, seems especially onerous.
It's actually different than when you go to a buffet and you pay a premium to have something available to you, but you may not eat everything that's available to you. Well, it's true. I said you're not out. It's true.
Okay.
I think you've made my point for how much you understand what we're doing here.
Okay, we gotta go.
I'm not sure about the statutes, but I will say that in the software industry, the precedent for this has been set, and there's no company currently that I know of in the United States that pays Microsoft, Enterprise, or any of the other companies for copies that they maintain on servers to be installed on users' desktops. And that's paid for by a per-seat license that is invoked that allows you the opportunity to use that software for an end user. But companies are free to make as many copies as they wish to store on servers wherever they would like to be able to distribute to their companies.
And last?
I just wanted to say, and in a buffet, you don't pay by the bite, by the way. But, you know, this idea of these 6-month copies is the most ludicrous thing I've ever heard of. I've been in radio since 1973. You know, and I know that's terrestrial radio, but I know we always had songs on tape cartridges and played them in the studio. The idea of me having a song in my computer and penalizing the artist for having a song that is good enough and popular enough to want to play it after 6 months and penalize that artist so that they are not going to be paid, I just can't believe it. That this is just, I'm sorry.
Yeah. Okay, that's it. I want to thank this panel, and we're going to call the third panel. Hey, everybody. Is everybody at the table?
We're not waiting.
We're not waiting. All right. We'll start over here. We're going to go around the table once more to identify for the record the people who are on panel 3. So could we start with you? Yeah.
Hi, I'm Marty. Is this on? Okay, Marty Gelfand with Congressman Krupinich's office. It wasn't on.
Hello, I'm Peggy Miles, International Webcasting Association.
I'm Patricia Pollack, representing the American Federation of Musicians, the American Federation of Television and Radio Artists, and the AFM and AFTRA Intellectual Property Rights Distribution Fund that distributes to non-featured artists.
I'm Deborah Proctor with WCPE Radio. We're the party that tried to get the amicus pleading filed, and we're a party that evidently had our copyright violated yesterday.
I'm Gary Himmelfarb. I'm the president of Ross Records. We're a record label, and I am also on the board of AFIM, Association for Independent Music, and also on the Sound Exchange board as the independent label rep.
Hi, I'm Will Roberty from KTRU at Rice University. I'm representing Collegiate Broadcasters Incorporated, or CBI.
I'm Joel Willer. I'm faculty supervisor of KXUL Radio at the University of Louisiana at Monroe, and one of the 13 college and university broadcasters filing comments.
Gary Dobeck with Digitally Imported Radio, Vice President.
Hi, I'm Mike Rowe, owner and operator of Radio IO in Jacksonville, Florida, and here representing several small commercial independent webcasters.
Michael Monahan, representing Spatial Audio.
Brian Zisk, Technologies Director of the Future of Music Coalition. I was also a founder of the legendary Greenwich Internet Radio, which was bought, merged, and then closed down. We got the rights back, and we will stream again as soon as this is all straightened out to where we think we can do it legitimately.
My name is Dave Eshelman. I'm president and owner of Massanutten Broadcasting, small market radio broadcaster in the Shenandoah Valley.
I'm Kurt Hansen from Rain Radio and Internet Newsletter. We also have on the side 14 channels of music called Rain Radio.
I'm John Simpson, Executive Director of Sound Exchange, former recording artist and artist manager. Recovering.
Gary Greenstein, Recording Industry Association.
Now we're going back to you, James. Introduce yourself.
I'd like to thank Mr. Carson for allowing me and yourself and the panel, the moderators for having me on the panel. I thank you very much. My name is James Cannons, okay. And I'm from our own performance society, which is, the acronym is OOPS.
Thank you. Focus here is on the rulemaking and how it applies to small businesses and what particular problems there are and how they might be ameliorated. And I could ask a bunch of questions, but maybe the best thing to do is just to let you tell us what you think the issues are. And as always, we always come over to this corner and say, respond.
I could move over where Gary is and we could sit together if you'd like.
No,
okay.
I'm teasing.
I'm happy to
So
move
does
around.
anyone want to start?
I'm not sure if this mic is working.
I think it is.
Test? Okay, it wasn't working when I first introduced myself. I'm Marty Gelfand. I'm staff counsel for Congressman Dennis Kucinich. And in the other panels, I want to represent a perspective that really hasn't been addressed. And of course, this panel is doing that for small businesses. Congressman Kucinich represents about 600,000 constituents in the Cleveland area. And in that constituency, we're served by 4 college radio stations in our broadcast area. We've got Baldwin Wallace College in Berea, Ohio, Cleveland State University in Cleveland, and then in our broadcast area is Case Western Reserve's WRUW, and we also have John Carroll University, all of whom stream. And we also have some small internet. We have Radio Crow based in our district, and there may be others. We don't know unless they contact us for the most part, but and we're real concerned about this because this affects our constituents. I'm not here representing any committee or subcommittee in Congress. I'm representing one member of Congress who represents about 600,000 constituents, but our district is not unique. I mean, I think we have the best college radio, but other than that, we're not really unique. There's great college radio everywhere. There are small internet stations everywhere, and those are the people that are building the internet, and these are the people that are putting out music that the commercial stations just aren't putting out. we have like 6 or 7 or 8 or 10 Clear Channel stations, not to offend anybody from Clear Channel, but, you hear Sting and you hear Puff Daddy or Puff Diddy, or you hear all these other people that we were talking about today, but you don't hear Blue Lunch. Blue Lunch is a local band that plays blues and swing. And, you don't hear the Mercury. Call my show and say, hey, Marty, we're doing a CD release party. Can you tell the folks about it? And I say, sure, and I'll play something by them. And then, this is so typical of every congressional district in the country. You have small webcasters who want to put out some good music. And they don't want to be subjected to onerous terms that were worked out wherever they were worked out. And I know that Deborah here is from a small station, and she wanted to be on the CARP panel. I know we're not here to talk about royalties, and I'm not going to talk about royalties, but I am going to talk about the process that the Copyright Office goes through in coming up with these. Now, I think that this is a great process that we're going through right now, and I hope that the things that people are saying get through. But I know that the Copyright Office doesn't always do things that way. The CARP, for instance, was one example. Another example is, this is the April 26, 2002 Washington Internet Daily. The Eldridge decision came out, which, well, it wasn't a decision, it was just a certiorari decision by the Supreme Court to look at whether or not the Sonny Bono Copyright Act, the copyright extension were existing, when the copyright comes to its full term, whether you can extend it or not. And the Supreme Court decided to look at it. And we have both you, Mr. Carson, and you, Ms. Peters, on the record as saying that this is a wrong decision by the Supreme Court to even look at this. Decision.
No, we said we were surprised that they took the case since there is no conflict in the circuits.
Okay.
Mr. Gelfand,
yeah.
we have a very short amount of time. We
yes,
have
I know.
Small webcasters whose concerns we want to hear, and I'd like you to stick to the point.
Okay, well, the point, yeah, and I'm sorry if I offended you, but, we just have to...
You're wasting time.
Well, I'm not really wasting time, but I'm almost done here. I know everyone wants to talk, but, the Copyright Office needs to really listen to what the people are saying here today. And I really don't mean to be offending anyone. I'm just, these are our constituents that we represent, and the Copyright Office, and here's my final point, is that we have, what's going to happen here with these record keeping, if we can't get something that's less onerous to the small broadcasters, webcasters, and college radio, what's going to happen is they're going to be forced off the internet. And you're not going to get, you're going to limit free speech. You're not going to get people like Jello Biafra, for instance. Commercial stations are not going to broadcast Jello Biafra, and the kinds of music that he does and the kind of thoughts that he disseminates are not going to get out there in the world because the commercial stations just aren't going to play him, and others just like him. And it's so important that we, that there be some kind of exemption, at least temporarily, that for the onerous record-keeping requirements in this rule.
Okay, I have Mike and then I have Will. And I guess there were two mics.
Wrong mic, which one do you want?
No, okay, we'll do you, Michael, and then you, Michael. Okay.
All right. Well, I can actually kind of speak in agreement with a couple of things that Martin says, that in that spatial audio represents an aggregate of about 190 broadcasters. They're all hobbyists. What is about to be required of us as hobbyists, and I won't repeat it again, but if the rates don't force most of us out, the record keeping probably will, because you're looking at people who are trying to build a business out of a hobby, and they're doing it as a one-man team, putting together all the music, all the commercials, all the promotions, and record keeping to an extent, but the kind that's being required by this legislation will make it incredibly difficult for any of us to continue in this hobby.
Okay.
His comments are a great kind of segue into my comments, and I really appreciate the fact that that this roundtable wanted to take a look at the specific interests of small webcasters, and before making my comments, just very briefly help you understand Radio I.O. and my project. My business, Radio I.O., operates in the space that's somewhere half between hobbyist and serious commercial entity. I started my project 2 years ago as a hobby, and over the past 2 years it's grown into what I believe is a viable business. And certainly part of creating a viable business is creating an audience, creating my programming. And like many of my fellow webcasters, I've spent the majority of these past 2 years focusing on developing the infrastructure of my business, developing my audience and my programming. And I've done so as the sole proprietor of my business. I am webmaster, I am network engineer, I am program director, I am music director, I am Mike, the Radio I.O. guy. And so in considering those particular or special interests of small commercial webcasters, I think it's very, very important that everyone truly understand who we are and what our businesses are. I know that I've noticed both in the press and just if even physical reactions of many who, when the comments are made that, should these rates be imposed upon us, and I know this is not about the rates, I'm not going to go there, but should these record-keeping measures be imposed upon us that we will go out of business? And I see skeptical reactions. And so I would simply say to any of you who might be skeptical about that if you took a real look at what my resources are, both in terms of my financial resources and my personal resources, as I've committed to my business, come spend a day with me at Radio I.O. and look at what I have to work with as a small business. I certainly don't apologize for that. I'm very proud of what I've been able to build with retirement savings. I'm unlike many others that have been part of this proceeding and many others, I'm not a radio guy. I don't have a background in radio. I'm not a technical guy. When I started this business, the most, all that I'd ever done with the computer really was to generate an Excel spreadsheet or a Word document. But I've applied myself and I've built this business. But anyway, to my point is, and that is, I would simply encourage this roundtable and in particular members of the Copyright Office to understand who we are and to truly understand who we are. For every one Yahoo Radio, for every one large commercial entity, there are 999 of us. And what I believe, the largest single group, I mean, if you look at webcasters as a whole, as a universe, businesses like mine, we make up the largest single percentage of that universe. And if we are gone, then and when I say we are gone, both as a function of the rate, but even as a function of the record keeping itself and the fact that I would be expected as a small one-man business to keep records that I just wouldn't be able to keep. The fact that I would be gone, I fail to see how the artists and the labels that you purport to represent and that you allege to, whose interest that you allege to want to protect, I fail to see how you've done that.
Okay, we have Will and then James.
First, I'd like to have my microphone turned on. Thank you. First, I'd like to thank you for the opportunity to be here today. It's an honor and a privilege. I want to talk a little bit about who we represent and the impact that the record keeping has on our organizations. First, we are not a business. These are, in most instances, a volunteer student organization. Sometimes they have to be part of an academic program, but these stations are based at colleges, universities, and other nonprofit institutions of learning. In the past, through precedent, the models that have worked have been sample reporting. And under the statute 253.5, it has been allowed for the PROs to sample up to 10 stations for 1 week a year. In reality, that's not what happens. In reality, it's 72 hours once a year, all stations. It works. Going to a new model, such as the one that is proposed, won't work. Plain and simple, it can't be done without putting all these stations off the internet. Part of the reason why is because these stations have a prior history, a prior working model that they work within. In order to implement what has been requested will change the nature of the operation. You change the nature of the operation, I can't see that, excuse me, meeting the congressional intent of being reasonable. How can you change the nature of a student volunteer operation and be reasonable? There are, again, historical precedent for sampling within these organizations. Congress understands that public radio is different. That's why it's set up Section 253, because they understand that these stations have limited resources, that they program differently, and also looking at some of the possible going ahead. And John Potter brought up before that there was at least some public knowledge of the CPB, NPR, RIAA agreement. Whether we don't know the exact details, but we know, at least in reporting, that there was an exemption for less than 10 full-time employees, and for above 10, it's sample reporting, if reasonably possible. How can CPB stations who have hundreds of thousands of dollars in their budget, and all the details are in our reply comments, be exempted for 10 or less, under 10, or 10 and more get sample only, yet the students will be shut down because they want census-style reporting. One of the comments in the RIAA reply comments talked about 30,000 hours at a station to input the data for 25,000 CDs. And they said, well, we only want the data for the songs that you actually play. Well, the problem is at any given moment, any one of those songs from those 30,000 CDs averaging about 10 songs apiece can be pulled off the shelf. If all that data is not into a computer somewhere, in a software database yet to be created, how can they play the song? So one of the things you had also asked about in one of the earlier proceedings was, a time to implement. And one of the things that we anticipated in our reply comments is, at a typical college station, the funding for the next academic year has already been allocated. They can't go out and buy a system, they can't go out and buy software when they don't know what the needs are. So they can't ask for that money until next year. But they don't get the money until the following year. So we do need to move ahead. There has to be some sort of reporting if there is not an exemption, obviously. And if that has to happen, there has to be a reasonable time frame to implement a system that will work. The most important part about this is that we are looking, I think everybody here at the table will agree, at an emerging technology, and for the people that are not involved with college and educational broadcasting and webcasting, we are looking at an emerging business. We want to train the students to enter that world. Without the opportunity to webcast, they won't have that education. Thank you.
Thank you. James?
I'd like to say that I'm also an artist. I heard a gentleman, what's your name, sir? Mike, right? Yes. I heard you say the amount of things that you have to do. I, as an artist and a businessman, I have just as much to do in order to bring a product to you so that you could be on the air. And you have to also look at that. I mean, there's a complement here. I mean, we need you and you need us. Okay? So if there's a requirement that to satisfy us, we have to meet half and half. Okay? And I'm just asking that all the webcasters look at it from that perspective, because there is a responsibility that I have within myself in order to give you the material that you need, and then there's a certain responsibility that you have in order to do what you have to do in order to fulfill my needs. So I'd like to just go down a few points here that I kind of summed up the whole meeting as I was sitting down in the back. I took some notes down, and I thought that there could be a marriage here, because I see that there's a leaning on this side and there's a leaning on that side, and I think it's the wisdom of Solomon here that has to come down in the middle, and I hope that I could hit that barometer. And I wrote these points down because I felt that I could try to suggest the marriage. First of all, as an artist, I'm not in favor of sampling. I've heard that mentioned here, because sampling, in essence, for artists that are not paid, ends up abridging the act of infringement. Okay? Because sampling is, as this gentleman has pointed out, it goes for a certain very short period of time. It cannot really account for everybody. But people are played and not paid. And that's not fair also. So I think that the intent of this particular act says reasonable notice to copyright owners. And I think that that's a very, very good standard to set. Everybody should meet that, because as an artist, whenever no one meets that standard, the artist isn't paid. Okay? There are only a certain group of artists that would get paid. Okay? That's number one. So I feel that the sampling, we should start to step away from that particular barometer as a way of determining how royalties are paid to artists.
When it's reasonable, I agree with you.
Well, I'm getting to that, okay? So the other part of it is that okay, record companies are asked, in essence, what I heard here is that some people felt that the record companies do have information that they could complement the requirement. And I think it's a little reasonable from one perspective. I think the record companies have information. I mean, I as a record company, I do have information. I know what records I'm putting out. I know what songs are in that record. I know what catalog number is there. I know everything about it. So if I could furnish that to Song Exchange as a representative of mine, that's meeting the half of the burden. Okay? Your half of the burden is what you played and trying to match that. In other words, whatever requirements they need in order to fill the gap. I think that that's a reasonable approach. That's, in my opinion, hitting it down center. Everyone contributing to the end result, which is to the artist. And the record companies, of course. Then someone raised the point of view that, for instance, a live record being a live performance of the same song, different background artists. I think the person who is responsible for hiring the performers would know the names of the performers and what part of the performance what their performance was. In other words, if they were singers, if they were musicians, they could furnish that information to the record company, who are also usually involved in the promotion of such concerts and are active in those particular events. So the record companies could furnish Song Exchange again, being responsible for collecting their royalties. And I think that that is another part of the equation that could bring this problem to a solution. Then records, I would ask this. This is my asking, because I think that the records that the gentlemen who are some webcasters present to Song Exchange, for instance, or a record company, I think that having a record in the office would be also central. Because in essence, I think that if there is no record in the office, then there's no public information. And I think there should be public access. Then I suggest also interim regulations so that you try this equation out, whichever way you decide to go, so that you see how it works. And then persons could come back with the saying, well, this is terribly burdensome on me, and you could make adjustments before doing a final decision and then having to make amendments, because that's a harder thing to unwind or unravel. I have a final regulations, I think, to amend. I think that an interim regulation is best. Secondly, most important, I find that while we are discussing these things, without an interim regulation, we are not being paid. And I think with that, an interim regulation, while this discussion is going on, at least there's some offering to the table, and however it's divided up after that, or during that time, it at least says to us that there's no money going through the window like happened with Napster. Everybody lost. And they're out of business, but nobody got paid. So I think that having interim regulations is very important to any issue that's before anybody in terms of copyright. Then the last thing, the last thing is the scrambling of data. I think that a lady raised a very good point. She says that, well, we don't want our format to be known because this is our competitive edge. They could scramble the data. and present it. I mean, you know, you can. You could go into a program and just scramble it. So I'm just suggesting that these things could probably be alleviated by minds coming together and being willing to work with each other and make this a positive result for the copyright owners.
Thank you. Joel?
I've got 4 points to make. Hopefully I'll remember all 4 by the time I get to them. I'll try to make it fast. You're fortunate that you're through with most of the lawyers by now. One of the aspects that I think is important for you to understand, and I've been encouraged today to hear from the number of people who have broadcast experience at the college station, and so I've experienced a great deal of empathy, including from some of the people on the RIA side of the table. And that's why I'm somewhat surprised by their continuing lack of understanding. I think it's important, particularly, though, for the Copyright Office to understand who we are and what we are. And part of what has been expressed about who we are has to deal with some of the more recreational aspects of college broadcasting. But one of the points Will touched on, but I really need to emphasize more importantly, is the educational. First and foremost, we are educational both for our student volunteers and for our audiences. There are a great variety of webcasters in general, specifically in terms of college broadcasters, and there indeed is another great variety of college broadcasters. In my case, and I don't want to necessarily set myself out as the standard, but to express a different aspect, my particular station is associated with an academic program. It's very important to our academic program that our students understand broadcasting, but also the emerging technologies. So it's very important for us to be able to expose them to that. We can't have the full burden of the commercial broadcasters because, of course, we don't have the resources. So we have to have an introductory way of dealing with that. In our case, we are part of an academic program. Our academic program is individually accredited at the departmental level. For those of you who aren't familiar with academe, it's very common for a university to be accredited. It's less common, and so it's a subset. We are accredited by the Accrediting Council of Education in Journalism and Mass Communications. In our last site report, one of the very strong points that they cited our department was an excellent radio station, including what we do over the air and including what we do over the web. So it's a very important aspect for our students to have that access. It's not just fun and games. It is that in many cases, even for the students who are doing it as part of their education. But we don't want to lose out on the educational value because of this process. Okay. We've talked a lot about the economics, and I understand that the artists need to be paid and deserve to be paid. But I think there's some misunderstanding. We've been talking in a very general sense about what some of the economics are. And one of the things that we're a little bit unusual about in our case, that from a college radio station, we do use some computer music scheduling software. We previously used RCS's selector when they sat right here. And by the way, from comparison's sake, I will tell you that they gave that program to us for free for the educational value for our students. We continue to use that. To use a scheduling, we still continue to use the scheduling software, but one of the advantages that it gives me is I can report some very real data. In fact, we use AWare's Music Master, which was revealed in some of the commercial broadcasters' comments. We're also the only station that uses, the only station in the country that uses in our particular application their real-time and Nexus software, so that not only do we anticipate, but we have some real-time feedback in terms of last-minute changes, even in the control room. But even at that, we still can't provide the sorts of information that you're requesting. We can't do it. Just can't be done. But I can go through and I can analyze in fairly certain situations. I can tell what we do in terms of performance. So as an exercise, I went through and I looked at what we played last week to get an analysis and apply on an annual basis. What would this mean to our average song in our database? Okay. The average song in our database, applying the rates that were proposed under the CARP proceeding, would mean that a featured artist would receive on an annual basis for our average song 36 cents. A non-featured artist would receive 4. We tie that back to the last panel where we're talking about ephemeral copies, and let's move the decimal point over a point. because here we talk about 9% of that for the ephemeral copies. What kind of reporting can we do for 9% of 4 cents? When we're looking at a cost-benefit analysis, it just doesn't make sense. In our case, we have, from a college station standpoint, a very limited playlist. We run at any particular time about 1,000 titles. When I turn around and look at one of our other participating stations, for an example, at KLAX, they're running 80,000. Many of those, because of the nature of that station, don't get repeated. That's one of the things they pride themselves on. So when we look at the numbers, in my case, when you look at the other cases in college broadcasters, the numbers are tiny. So yes, artists deserve some compensation. But even when you add all of us together, we're talking the price of a Big Mac. And it just doesn't make sense from that perspective. Okay, we're talking also about the issue of the eclectic. I think we've already established that from the economic standpoint, we're not really talking about big dollars that, geez, we've got to have census reporting so that we get all these outlying artists. Well, we're talking about fractions of a penny in the course of a year. It, again, just plain doesn't make sense. Okay, we have also, from the eclectic standpoint, ruled out sampling, and I will again point out, when you look at Section 353.5, that we have had sampling has already been established as reasonable in the specific context of non-commercial college broadcasters. There's no difference here. It was reasonable then, and it still is. And I got through all 4 of my points.
Thank you. Thank you. I also started off as college radio general manager too many years ago than you can remember, and have been in radio and television, flipped over to internet broadcasting in 95, 96, with the first demos at the NAB for audio using Zing technology, and put on some of the first radio broadcasters. So I am delighted to be here. I am part of an association, the IWA, International Webcasting Association, and we only formed officially in 98, been around since 96, but we have as on our board Real Networks, Microsoft, and Apple, and they don't agree a lot of the time on our board, but they're still there. We also have about 5 of the webcasters that have been testifying today, and Ken, Dave, Mike, Wanda, Jim. Why we're here today is we don't think that one size perhaps fits everybody. There are some wonderful opportunities and diversity within the universe of internet broadcasters, from 13-year-old with a mic and a modem to this woman that's broadcasting a language out of her house with the same music. It might go to 10 people, it might go to 100 people. They might be lucky, and it might go to 5,000 people, and they might get some sponsorship. So if you're looking at the record-keeping requirements, perhaps a sophisticated webcaster may be able to afford to do so today, and perhaps, I don't know, it's very complicated, and there are some things that can't be done today. I could go on and on about the panel before, about the technologies that you can't monitor today, but perhaps some of these smaller webcasters just aren't in a position to be able to afford this. And we found in the last year we've lost about 1,000 webcasters from a report on BRS Media. In 2002, and most of these are terrestrial tracking, but if you want to check at brsmedia.com, we had in 2001 5,500 terrestrial radio stations. We're now down to 4,600 radio stations. It's very hard to count those guys with a mic and a modem, those shoutcast and those live 365 guys, and that might be broadcasting to 5 to 7 people. But the point is, we were all talking about dogs earlier. There are lots of breeds of dogs. We don't want to lose any. We don't mind if they mutate. We don't mind if they go into all sorts of different breeds. We don't, we'll pay more for one, we'll pay less for another. But the point is, we'd like to keep these webcasters in business because we don't know what they're going to evolve into and what they're going to become if they're going to merge with another company. And each one of these represents 1 or 2 staff members themselves. Maybe they're paying their own way. Maybe they're buying, they're paying the vendors in our business. I don't want to go. I'm a consultant. These guys go out of business. I go out of business. So one of the issues that we would like to consider is that one size does not fit all. And please consider the college broadcasters, the educational, the small webcasters, and the big guys. And one other point that I'd like to make. I am sort of in agreement with Alex. I'm not in agreement that he isn't a visionary. I think he's just a business person. If we don't share some of the data on some of the records between all of us, we're going to have to create this over and over and over again, and the administrative costs are going to be so prohibitive. So if there's some way we can work together to share this data, not put any of the data companies or collection companies out of business, but to work together from both sides, I am so for that, and anything we can do, we'll do it.
Thank you very much. Brian?
Hello. I thought I'd go over a few things. When we were the Greenwich Internet Radio, we were a large webcaster. We were not a hobbyist, we were not non-commercial, we were not small entrepreneur. Maybe we were, but I would call us corporate. We had 8 people full-time entering data about the CDs we were going to play. We were buying about 1,000 CDs a month, adding well over $10,000 every month into the record industry. We were getting probably an equivalent number of CDs for free. There was no centralized database we could sync up to. We had to put all the data in, and we don't even know if that data synced up with the data that Sound Exchange has. So that's the sort of scale. I mean, it was just absurd. Another side issue is the whole thing about reporting under penalty of perjury. It's like the record companies, in exchange for taking the artist's copyrights, are supposed to issue royalty statements that are fair. They're generally underpaying. I think we should issue our statements under penalty of perjury when they start issuing their royalty statements under penalty of perjury. Okay? Now, in addition, I think we have a real basic problem here because webcasters became webcasters because they love music. They should be the best friends of the record labels. I mean, the labels give everyone CDs, we broadcast them, we promote the bands, we spend, well over $100,000 on CDs. Yet, when they come and are putting these reporting requirements on, which are actually impossible to do, you can't track ephemeral copies. There's no way. We used a company, Adero, and we, talk about, oh, well, your bandwidth costs are so high. We were paying $1,000 a month for unlimited streams. They don't offer that anymore. Don't all run and call them. But it's impossible to track ephemeral copies like that. Similarly, the listener logs, where you were supposed to, in the initial proposal, report the time zone of where the people were listening from. That's absolutely impossible. And that was so clearly impossible to everyone, including the RIAA, that they had to back off a little. Now, only because they would have been run out of town on a rail if they had insisted on it continuing. And there really has to be a bit more of a, it can't just be take. It's got to be, these are the people who are out there promoting the music and driving sales for the record industry, and you shouldn't be trying to put them out of business.
Sorry. Back to you, Micro. You passed? Okay.
I just want to pick up on a couple of points. I wanted to point out that what Joel is doing at KULX is not close. I always get it wrong. Dyslexic. But what he's doing there is wonderful. He's in an academic program where he's teaching students about industry practices using industry software, but that doesn't cover, that is not typical of the type of stations that we represent.
He's
along
lucky,
the lines
right?
of the comments that were made before, too. Some of our stations out there are small stations that are student volunteer organizations that are funded with student activity fees. Not all of them are licensed. We have a member, KAMP, that is webcast only. These reporting requirements go through the organization's history. It's not just a matter of losing their extension of their service, which most of these people think they're doing with webcasting is they're extending their service through webcasting. They're gone. Their history, the program's gone. So I just want to make sure that we cover that we're not just talking about in college broadcasting people that have a license. Not all of them do. And then we also have 2 instances in our membership. We have WFNP out of the State University of New York and KVRX out of Austin, which are shared time stations, which means they're in a market, but there aren't any more frequencies left. So 2 people applied for a frequency. Well, you get half of it, and I get half of it. But they want to still be able to offer a resource 24 hours a day, 7 days a week to the students and to the community. How do they do that? Webcasting. So 50%, or in the cases of WFNP, 80% of their time will be gone. So I wanted to just cover a little bit more about some of the membership that we represent. And also, Joel is very fortunate in the situation to be able to work with some of the resources that he has. If you look at the IBS report, $9,000 annual operating budgets for an educational student volunteer station. If you're looking at what the cost is to implement the reporting requirements that are being proposed, that's why I need to highlight that these stations are history, because they don't have the resources. Even if they took all $9,000 to go out and buy the equipment, hire people to put the data in, and whatever it took to get that done, the fact is they couldn't sustain it. And you're talking about a volunteer staff again. So, and to give an example, this is a playlist for a college radio station. The computers don't exist in most of them. Again, Joel is very fortunate to be working with the resources to do that, but piece of paper, pen, song title, artist, album.
Why can't that be input at another time into a computer?
They don't have a computer.
You don't have a computer?
Actually, these are playlists of a lot of your member stations that are typed
A playlist that is compiled weekly.
Well, I mean, someone's obviously typing in the information, so there are some playlists.
Yeah, but that's not a census report.
But what information are they reporting in those?
It's not a playlist, it's a top 20.
And that's why I asked, what,
Totally different than
you use that as an example. What is the information that's being reported there?
And again, those are only, you go out and pick a couple of these examples, but that is not representative of the universe.
That's true.
A couple of things, if I may. First of all, as you know, we recognize that non-commercial stations are different, and we engaged in negotiations with you about record keeping, and of course you wanted to tie it to a rate deal, but we did reach out and try to say, hey, look, we recognize you're different in the non-commercial side of things. Let's do something on these notices.
No, first I'd like to correct you. We were never in negotiations.
Fine.
We only accidentally heard about it. And when we tried to get in, and
Well,
you know the history.
I had a meeting with the head of the National Association of Community Broadcasters, and we have reached out to a number of people in the non-commercial world to try to do those kinds of voluntary negotiations.
There's still time, but not much.
I've got a list that says Tricia, David, James, Martin, Deborah, and Gary. So we go to
The small webcasters really are incredibly important, and the hobbyist webcasters are incredibly important, and the college webcasters are incredibly important, and they're increasingly important now in a time when the over-the-air radio ownership is increasingly consolidated and the variety of music played and offered is increasingly shrunk. And I think that's got to be recognized, and John has said that there are efforts to recognize and a willingness to recognize that. I have two concerns about it. One is that this is the panel of the special people, and so that's a great panel, but we don't want the special people's issues and concerns to end up being bootstrapped upon. That's terribly inelegant. But there are also a lot of services out there that can't afford to do a fair amount of record keeping and would be eager to take advantage of any special arrangements made for the special people, and that's a real concern. So if all dogs aren't the same, and there are a lot of different breeds of dogs, let's remember that going in all directions, I guess, is what I'm saying. The other concern I have is that and point I want to make is that I want people to realize that sort of at the very end, at the total end of the line of all the reporting and the money and where it all goes, there's an entity at the very end of the line that is the AFM and AFTRA distribution fund that distributes to the non-featured musicians and the non-featured vocalists. We're the last people to get anything. We are at the bitter end. We're the last people to get anything. We get the least amount. It's the 5%. We have the largest number of people to try to find and to distribute to. So when we're talking about the special people and we're talking about the small people, we're right in there in that category of the special people and the small people. And I don't want to be a broken record here today, but a couple of things I think result from that from our point of view. One is that if there's only the most minimal data reported by anyone, I mean, we're talking the really minimal data reported, and there's not sufficient to identify the sound recordings, the result is going to be that there's going to be so much money spent at the collective to identify the sound recordings that the amount of money is going to shrink and shrink and shrink, and our little 5% is going to get so teeny that it's going to become increasingly impossible for us to really distribute. And again, if more and more and more costs are shifted to the collective and to the artist to bear, once again, that's going to shrink the pot, and our little 5% of it is going to get increasingly small. If there's only sampling and no attempt to really reach out to the deeper catalog and to pay money to the artists that don't get played a lot and aren't the hugest commercial successes, then that's not going to promote the diversity that the webcasting business is offering to us, and that the college and educational radio and hobbyist folks are offering to us. And I do want to say that musicians and vocalists are masters at making little amounts of money go a long way. I know an incredible number of musicians and singers who make their whole livings, they spend all their energy putting together a living out of getting a little stream of income from here, and a little stream of income from there, and a stream of income from there. And the fact that any one stream is small does not mean that we would spurn it.
If the stream isn't there's nothing to... We agreed that you need to be compensated, and where possible, you need to be identified as... I mean, there's the magic key, the golden data symbol that was talked about earlier today. Wonderful. We give it to you as much as we could, but with what is proposed, there will be no stream to put on the web and no stream to go to you. So we want to give what needs to be done so that you can get compensated.
I guess the Copyright Office gets to be the great alchemist here.
We won't go there. David.
In all the is this on? Okay. In all the testimony that I've heard here today, I've heard almost nothing representing small market radio stations across the country. Commercial radio stations, many that are struggling to survive financially, serving in small communities where they do not have the resources that many of the large networks have. I'd like to speak just very briefly for that large group of broadcasters across the country. I have 2 stations, an AM and an FM station, serving communities of less than 5,000. I do serve a larger city, but as far as license is concerned, those are small communities. I've been in broadcasting for 30 years, and I look at this technology as a new way in which I can expand my ministry and my area of service to the communities that I serve and way beyond. However, I do not have the resources, I do not have the manpower, I do not have the technology to be able to even begin to report what is being asked for. I have a staff of 5 full-time people, 4 part-time people, and the FM station, which is a music station, is the one that I would plan to stream if I was to stream, but I'm not even going to consider it until there is some sort of reasonable reporting and reasonable fee structure. I cannot afford it. It's not going to generate income for me. I'm doing it as a service to my community, and I have to look at my bottom line. If it doesn't make sense financially, I can't even consider it. We have no music software. Everything is manually presented. I have representatives of cards here that my operators use. We do a lot of music research with our listeners, and we have a very tightly formatted music format. However, it is all done manually. So I have no way of telling you what I played last week. I have no way of telling you what is played. I mean, I have the basic cards. Yes, I could tell you that. But as far as rotation, how often they got played, I cannot tell you that. I have no way of doing it. I would have to do it all manually. And I would propose that if we can satisfy the requirements of BMI with a 3-day annual logging, which is done manually as far as we're concerned, why can't something like this also be done for small market radio stations? I would also like to see the exemption as far as 10 or less as far as employees are concerned, if that's a possibility. If NPR can do that, why can't small market commercial radio stations? These are people who are, in many cases, are losing money, believe in the service to the community, and are struggling financially to stay afloat. And they want to be able to use the new technology to reach out to their communities and beyond. And so there has to be a way that these hundreds of commercial broadcasters in small communities across the country can reasonably do this service and yet still give to the performers what is rightly theirs.
Thank you, David. We're back to you, James.
I do agree with everyone what they're saying, and I would like to say that from the artistic point of view, you have to remember that we experience the same thing. And I, as a person, an individual, have a record company, okay, I have a website that I sell CDs on, okay, I have a performing rights organization, I perform, and I have a publishing company. I have to do all my record keeping. Okay? Plus, I have to go into the studio to produce a record that you would need to be in business. Okay? And I have to be detailed there too, because I can't make a half step on that. Okay? And that takes a lot of work. It takes a lot of time to polish this product up. It takes sometimes years before you could say to yourself, okay, this is done. Let me put this aside and send it out to the market. It's a lot of dedication. Plus, educating yourself, studying to be a better musician than you are, or a better singer than you are, going to music lessons. This is not a game, you see it on television. It's like, everybody stands up on stage, and it's a lot of hard work behind it. Practicing before you go on stage, knowing everything that's done on stage, people practice. Okay? It's a lot of dedication. It takes commitment. And if you're in the radio business, then you should make the commitment to do what it takes to be there. I think that that's a fair thing.
Okay, thank you, James. Martin?
Thank you. I think we have the means to solve this whole problem. I think that there's a lot of agreement in this room based on the three panels, what we've heard. I think we're in agreement that musicians should receive royalties for their work. It's theirs. I think we also agreed that we don't want to put people off the internet. I think we've agreed on that. I hope we've agreed on that. So I think what we need to do is find a way that small internet users, small webcasters, college radio stations who stream their broadcasts can meet the requirements of information, identification, but without some of these onerous penalizing rules in the draft. And I don't think that's very difficult. I think that should be simple. Now, earlier today, the folks from the RIAA and some of the webcasters were talking about sharing data, sharing software or whatever, and they didn't want to do that or whatever. It doesn't really matter. Maybe their software isn't appropriate anyway, because the software they're talking about, it has to be an ASCII, and it has to give all kinds of information that isn't necessary to what the musicians need. All the musicians need is to know that their music has been webcast a certain number of times at various radio stations. That's all you need. And I think someone pretty much narrowed it down to they need to know the song, they need to know the artist, and they need to know the album, and maybe the label. Maybe, because most labels know who their artists are, so that probably wouldn't, most, not all, not the really small ones, but then again, you know who the artist is, you know who the album is, you can identify. So that's really all you need. I think that the Library of Congress and the Copyright Office could easily develop some kind of a software, whether the RIAA wants to participate or not, easily. I think, because all you really need are 3, maybe 4 data fields. And that could be given away, kind of like Adobe Acrobat is given away to people who want to receive things that are transmitted in Adobe. I mean, you could give this away. It's not rocket science. What the musicians need is not anything terribly complicated, and what the small webcasters need is not to be penalized or put out of business. They just need to report what they're playing in a way that's simple, and they're doing it anyway. We just saw the list that Will showed us. It shows the artist, the song, and the album. Isn't that right? Yes. Yeah, I mean, they're doing it anyway. They're reporting to CJM, CMJ, sorry. They're, you know, there's nothing difficult about this.
Before I go to the next person, over here, do you want to respond at all?
Sure. I thought Gary was on your list. I thought I'd let him talk first.
He is on my list, but he follows Deborah.
Okay.
So we could do Deborah, Gary.
And then I'll...
Okay.
Thank you.
Let me start out by saying we, a long time ago, started out as a 2-watt radio station. So I understand where you're coming from, because I was there. I understand where these webcasters are coming from, because I was there too. They do just as much work as you do, just as much work as I did starting up our operation. So we all should understand what the other guy's doing. The thing is, when you are a small, beginning, nascent business, any little bump in the road can throw you into the gutter. You need to consider some phase-in periods so that you can learn what is necessary to distribute these funds properly, learn how to do them, learn what works and what doesn't work. Does sampling work? Does it not work? When does it work? When does it not work? How do you do that? And you don't have to invent this wheel tomorrow. You can say over the next period of years, we're going to have the target by the next time these negotiations come up, we'll know what to do. The thing you've got to understand is with the webcasting being such a new business, it is very much akin to what's happening in what is going on in college radio and community broadcasting. At this NFCB conference, or the National Federation of Community Broadcasters thing that you talked about, our radio station sponsored 2 seminars. One of them was how to do effective fundraising so your radio station can break even and cover its costs. And the average NCFB radio station, they're making on the vicinity of maybe $30,000 or $100,000 a year total. They're hiring just their first couple of people. Another seminar we conducted for them was how to begin webcasting. And there are a number of community radio stations who need to webcast because they only have 10 watts or 100 watts. The big station that we had at the University of Virginia, they run 600 watts. They're trying to get their signal into Richmond. They can't do it yet. They're hoping that using the internet, their little 100 or 500 watt transmitters can get in through the first steel wall or get into the basement. They're afraid to start because they don't know what their fees are going to be. Now, yes, NFCB and RIAA have talked, but those are still proposals. They're still maybes. And for a small public broadcaster, and let's talk about Mr. Eshelman here, my public radio station is larger than his, and my long-term security is better than his, and I'm a nonprofit. But I remember where he was when he was worrying how to pay the rent. Let's gradually, logically, and reasonably learn how to do this so that we don't have to go back and reinvent the wheel. Let's do it right so we don't put somebody out of business, because if anything happened to our 2-watt station back in 1978, we wouldn't have been here. But we got lucky. And now we're doing a national service that literally close to 250,000 people a week are listening to, enjoying, and getting for free. Let's not destroy webcasting 5 years from now Let's do it right so that all of us can get together and say, you know what? We did pretty well.
Thank you. Gary?
Now, as a small label, too, I want to see a variety of different webcasters on the air, and I think we need to have slightly different rules and rates for the different types of webcasters. You know, I started my business, a record label, in about 1980, and I had a very profitable seafood business at the time, and I decided to follow my passion, which was music, reggae music. So in the basement of my house, my family, friends, everyone said, "You're crazy, you shouldn't be starting this business." I started a business and followed my passion. As I think some, you know, when I hear people say, well, I've started a commercial webcaster and I'm not making money, or I work my ass off from 8 in the morning till 10 at night. You know, I've been there, okay? And I mean, nobody makes you start a business. You decide to. You can go into plumbing supplies or whatever you want to do. No one says you got to get into the music business. So although I like the idea that there should be lots of webcasters, because as an independent label we don't get our music played on major stations, I don't have lots of sympathy for the guy who's trying to have a commercial venture and say, I cannot comply with these different payments and the different reporting that the Copyright Office and Sound Exchange is requiring. I put out a record and had a song by Jose Feliciano, Feliz Navidad. 11 years later, I had not paid for it and was told by Harry Fox I owed them $11,000. You know, I couldn't go to Harry Fox and say, you know, I'm just a little guy. I'm not making any money. I'm in the basement of my house. I'm a two-man operation. I work hard all day. Instead of paying, you know, the 4.5 cents per song mechanical, let me pay 2 cents. I couldn't do that. I had to pay it because it was determined that the guy who wrote that song deserved to get that much money. And as an independent label now, where I'm seeing amongst my company and many of my other independent labels who I've known over the 20 years, where we've had to lay off employees, you know, we're feeling the pinch of the record industry. And if you can get me a cheeseburger and you can get me some French fries, you know, and I can supersize because of you, you know, we'll take that money. You know, just like she said, you know, any stream, we need this right now to survive. So I'm in favor of seeing the college radio stations get a lot of levity in their reporting and in what they pay, even if it's an annual amount. But I would like them to report. I was a DJ before I started my label on WHFS, and I had to fill out a log. And if it means that the guy has to write a log and somebody who does accounting, or you say to the DJ, you got to go into a database, into a WordPerfect file, and enter it in a computer, the 4 categories or the 5 that Sound Exchange needs, then part of his job, as well as, because when the record was spinning, I wrote it in a log. So maybe there's a way to have a computer at the station where this stuff gets entered to the best of their ability. I think a lot of the startup guys like Ultimate 80s or whatever, you know, maybe they're thinking like the dot-commers. You know, maybe I can operate at a loss for 3 or 4 years, and Yahoo's going to think what I do is really cool, and they're going to come in and give me $5 million.
Well,
you know?
They're past that point.
I think we're all kind of past that point, if I may, since
Yeah.
some of your comments addressed my comments specifically. I'd like to say that if you indeed did start a business in your basement, as you suggest, you operated at a loss for a while too. I mean, we all do, but really, I think the thing that's really important here to note is that none of us, and when I say us, I speak of the group of small commercial webcasters that I came here with and that I feel I represent in saying, none of us are in any way suggesting that we should not keep information. We're also, we're small business people, we're very passionate about what we do, but we're also realists. We do understand that the RIAA and that the artists and label do require a certain amount of information in order to ensure that both the labels, the artists, and the copyright holders in general are properly compensated. And we certainly are very sympathetic to folks at the very end of the chain, as she suggested, and would like to make sure that they are compensated as well. But I'd like to correct you on one point, that we're not objecting to what you described as being the 4 or 5 pieces of information that the RIAA or Sound Exchange wants us to collect. We're objecting to the 20-plus pieces of information that we are being asked to collect for Sound Exchange and the RIAA, or indirectly the RIAA. Anyway, I would like to suggest that really is at the heart of the matter of why I felt a need to be here to speak with this panel today, and that was to say, in addition to making my rather impassioned plea that you understand who we are, understand what we can do. We are more than happy to provide this information, and there's several of us that have made proposals, although I will say it's important to note that none of us have been in any form of negotiation with the RIAA or with Sound Exchange, and that really is another concern of mine, that while many conversations have centered in outside of this room, but there have been a number of conversations recently that college stations, that there rumblings that there's a deal in the wind, or religious stations rumblings of a deal in the wind, or college stations, a deal. I want to make sure, and I would like to ask the Copyright Office to do its part, and I've certainly been doing my part the past 2 months to make sure that the representatives both in the House and Senate will make every effort to ensure that the small commercial webcaster does not get lost in this, that we're not pushed out of the marketplace in such a way that would make room for the domination of the larger commercial players.
Okay, thank you. I'm going to call on Kurt because he hasn't had a chance to speak.
What he said. I'll expand a little bit. It may seem as if that webcasting is in most of what we think of, it's the big guys like the Spinners and the Yahoos and the MSNs, and then it's there's obviously thousands of non-commercial and college stations that are certainly worthy of attention. But the in-between category, you might be surprised to notice where all the action is in this field. When you look at ratings in Arbitron and MeasureCast, those are only of the firms that choose to participate. And in fact, the vast majority of audience to Internet radio doesn't participate in either service. And the listening of stations like 3WK and Radio I.O. and Digitally Imported and Ultimate 80s and Beethoven, and people who couldn't afford to come here like Radio Paradise, and I don't know if it was couldn't afford actually, but Radio Margaritaville, that's where the bulk of the hours are right now. It's smaller entrepreneurs who are not in this as a hobby. It's a business they got into because they love music. And typically it's because they love a certain genre of music and that they felt wasn't getting airplay on AM and FM, and they thought they could serve two purposes. They could be involved in the music they love, support the music they love, give airplay for the first time in years to the music they love, and at the same time make a business out of it. Martin pointed out that Jello Biafra doesn't get FM airplay. Frank Sinatra doesn't get FM airplay. There's a wide variety of the Oh Brother Where Art Thou soundtrack doesn't get FM airplay. So it's not just fringe stuff. There's loads of extremely popular music that these mid-size commercial entities are promoting, and it's good for the record industry, and it's good for those artists, and it's good for those genres of music, and everybody can win. But it's a very tough time. It's not 1999 when the Yahoo RIAA deal was cut. Right now, there's maybe, if you really are good at it, there's maybe a penny an hour per listener hour in revenues available. That if you go to the rep firms and you try to find a deal where they can tell you how much they can get you, no one can guarantee you a penny an hour per listener hour. So you've got to find a way, if you're a small commercial webcaster and you're not part of a huge conglomerate, you've got to find a way to live within that penny an hour or go out of business. Or, you know, assuming you've been doing it for a while, you've probably maxed out your credit cards and your family debt and things like that. So the issue becomes, you know, cost benefit. What, as you make your decisions, what do you need to give each side that has a reasonable cost-benefit relationship? I hope, you know, I'm not familiar with your mandate to know if that's part of it. But if reasonable is, you know, I know reasonable is, so hopefully that is.
Always reasonable.
Some of the stuff like census versus the census of versus a sample.
Sampling.
You know, I think if we can remember back to our college days, a good sample is better than a census, typically speaking. If a college station can spend a few days a year, or a broadcast radio station doing the BMI log, they pay close attention to it for 3 days a year, and everybody does that, and it spans across the, you know, so that the whole year is covered across the ground, you get better data. And all of the, yes?
I'm telling you from an artist who's been in this business for 27 years, people drop out in the bottom.
Mathematically, that's not true.
I'm sorry to interrupt, but the 3 days does not equate being played on the radio.
Well, if it's 3 days here, 3 days there.
Telling you from an artist who's been in this business for 27 years, people drop out in the bottom.
Mathematically, that's not true.
I'm sorry to interrupt, but 3 days does not equate being played on the radios.
You cover everybody.
The point is that people are not paid, and their music is played. So the point is, how do we make that bottom come up to the top, or be equalized? This has been happening in this industry for as long as it's been happening. People are paid millions of dollars in royalties, and other people don't get anything.
Let's say.
Let me start by saying that it is now 10 minutes of 5. We have 10 minutes left. We need to turn to the record industry and let Kurt finish.
Okay, thanks. It could be we're just having a semantic difference of understanding of the semantics here, but at any rate, the same thing applies on compliance. You can have people spend to do what the reporting for compliance that's being asked for would be billions of records of information per year. And you've got to think, well, what's the balance? How much better is that than if somebody does an all-Metallica radio station, the copyright holder notices, informs the RIAA, they listen, they find it, they take it off the air. It's not that hard, and it doesn't require delivering the billions of pieces of data. I'll cut it short. The main point is that the CARP process covered the really big guys. That was the billion-dollar corporations were involved in that. The college radio stations, I think, are pretty clear in the non-commercials. There's something, they deserve some special treatment. The in-between ground, on the other hand, and the small market broadcasters, that's the vibrancy of the industry and the majority of listening in the industry, and what you can do to keep them alive would be something that would be very helpful to Internet radio.
Okay, thank you. You haven't spoken either.
I wanted to just ask Kurt, you touched on a couple of points without really zeroing in on them. Was your point that it would be better to simplify the reporting requirements or to adopt graded or tiered levels of reporting requirements, or both?
I think simplify is what I'd recommend, that artist, title, and album will cover so much of the vast majority of music. The costs, the cost involved in adding extra pieces of data and new software for everybody and the transmission of all that stuff will be, plus or minus dollar checks to some people. And simplification in every area would, at least for a first go-around, seem like would be a good thing to try for a year.
See, the reason...
Brian, I know you want to jump in.
The reason that I asked this question is that I heard an awful lot of argument directly and indirectly in the statements and testimony today about exemptions, graded, tiered. And my concern in the fact that digitally imported is structured as a as a business. And we really need digitally imported to continue to grow and just to be able to serve the listenership that it has. We need to make it work as a business. I'm concerned that the graded and the tiered requirement, adoption of requirements, could actually incentivize an industry where those who are fortunate enough to get the exemption will be favored, in which case it would actually encourage the small business operation to either get out, one, be acquired by somebody really big, or third, fall back to, let's say, a nonprofit organization. So if we're looking at this from a commercial enterprise, which says they're going to have money coming in the pipe, and we want to direct the fair cut of that money back to the creators of the musical works, as well as the composers, the performers. I think that we need to be very careful once we go down the tiered road, especially if the steps are set too high, because it may actually be, at least at this point in time, it may actually be, we may actually be encouraging people to step down. And I'm not sure if that, in the long run, is really going to serve anybody's interest.
Are you recommending a uniform handling of it, but back where Kurt is, but with reduced data?
I would think if the concern is that, I think the answer to your question is yes. I think that simplification is probably better than tiered. Now, my guess is that there are probably strong arguments for the tiering, but I just think they need to be treated carefully.
Okay, thank you. We got to go over here.
I'm going to address a few quick points, and then John is going to address sort of the general comments. As for the CARP process not covering smaller players, and it was only the billion-dollar corporations, I'm not addressing the value, but I want to correct a misperception, because companies such as Everstream, Encanta, Music Match, Univision, you have companies such as BET.com,
Music
Comedy
Match is a
Central,
half-billion-dollar company.
Echo Networks, MyPlay, Radioactive Media Partners. These are not the MTVs and Yahoos of the world. So
They're also not small commercial entities that are employed by one person and started on small budgets.
Folks, it's 7 minutes to 5. Let's talk about notice and record keeping rather than CARP, okay?
And the point that I want to make, though, is that there is a difference between someone who is a non-commercial broadcaster and someone who is operating a business, and people have talked about hobbyists. If you are a photographer and that is your hobby, you spend money, you buy your film at fair market value, you pay the film processing lab fair market value. If people are doing this as a business, as Gary pointed out, the artists and the labels deserve to get paid, and that is what Congress established. If you are asking for something that does not have the money flow to those people, in effect, what you're asking for is for artists and copyright owners to subsidize your business.
No, but I have a choice about which camera I buy, about which film I buy. I have a choice in that marketplace and other similar marketplaces. And in this particular one, I have one choice. And
no, you have a choice that you can direct license with any copyright owner that you want. Well,
now, you
but
have a
you have that
of
choice.
Which music you play.
Yeah.
You have a choice of what music to play.
You know what? We sure do.
Yeah, no,
we do.
Look, I think one of the things, we represent 400 independent labels as well as the 5 majors. We found over 20,000 artists in our first distribution. Most of these are small businesses too. And I think one of the things that we have to look at is we are moving into a world, and record companies, especially small labels like Gary's, are looking at a universe where record sales may not be the future. It may be licensing little bits of pieces of information, revenue streams from streaming, from your cell phone tones, whatever it might be. They're looking at the world like music publishers have looked at the world forever, looking at revenue streams from licensing. If people can tune to any station or lots of different stations, thousands of stations that stream lots of very specific music all of the time, people may have less need to buy it. So I think the whole notion of promotion... No, look...
This is right, not record keeping we're talking about.
Well, I'm just talking in general. You know, that this is an important issue for
How does the fact that webcasting would exist, how does that dilute, or how could that possibly cannibalize record sales any more than terrestrial radio is cannibalized?
I guess where I was going with this is, I know that on the small side, especially college, you guys play a very specific niche of music. And those independent labels and artists, I'd like to make sure that I can get the money to them. We've found a lot of niche artists in our first distribution from the satellite services. So, if I don't get data from you, then I'm sort of at a loss. I'm having to try to find a proxy to do it.
We want to provide you with data.
If I get the data from you, obviously it'll help me to make sure that the right artists get paid.
We want to provide you with data, but we want to provide you with an amount of data that has some relationship to our abilities and our resources as small businesses. We want to provide you, and many of us have expressed repeatedly our willingness, our agreement in providing artist, label, the artist, the title, the label,
and the album.
And the album.
And let me just say that under the interim regs that we were working with, that kind of data wasn't sufficient to find about 20% of the titles. So it's...
Right, because we didn't have a database to sync up against.
What more information from us, there's going to be more chance to enter it incorrectly.
Which then goes into your database, which you sell to other people based on the data these folks give you.
The less data you give us, and the more inaccurate those fewer data elements are, the harder it is for us to find the copyright owners and the artists that we want to pay.
I think it's...
So you are asking small businesses of rights owners and artists to subsidize your small businesses' inability to provide us with data for us to distribute.
We're more than willing. We're more than willing. Listen, it's very unlikely that any of us would get the artist, the title of the track that we played, the label. I mean, how could we possibly get that information wrong? We announce it. I mean, many
has 85 million performances in our first distribution. There were many cases where the artist was reported as various,
I'm sure
the artist was reported as a composer. I am not saying your particular business would do that, but you're not the only one that will be supplying us with the data. We need regulations that will cover all of you.
Is there any reason a model like CDDB wouldn't work? I haven't heard that mentioned all day.
I mean, why isn't this an enormous issue for the performance rights organizations? I mean, this is information that this is information that we've provided that industry with for...
I'm not going to really get involved, but there is a huge difference between a membership organization where part of the membership, part of it, is to give the data with regard to their songs. So remember, they've been around for a very long time.
That's correct.
And this is a new venture. So there's some bumps in the road in getting this started.
Yeah, I made that point earlier, that we have to pay non-members as well as members. You know, it would be a lot simpler if all I had to do was, as they do in the UK, they only pay their members for the royalties they collect.
If I am, this is a matter of point of clarification for me, it'd be helpful. If I'm a non-member and you've collected monies for my performances, sure, how do I collect that money from you?
We do a lot of research to try to find out who you are and where you are. Obviously, we look at websites. We try to, and again, you can imagine how hard it is to find small artists and little niches.
So would it be required, though, that I become a member prior to those funds being dispersed to me?
No.
Can I make a suggestion? It's 5 o'clock. We need to end.
I'm sorry.
Really promptly at 5. But I'd like to make sure we hear from Sound Exchange what Sound Exchange has to say on the subject of this panel. And just because of time, I'd like to make sure that John has said everything he wants to say uninterrupted from this point on, please.
Thank you. Yeah. Again, you know, we've reached out to non-commercial entities. We're hopeful we can reach an agreement with them. We recognize their differences. You know, in the perfect world, we'd like to get a census from everybody because obviously it's going to make our job of distributing that much easier. We know if it's impractical based on also the royalties you're paying. There is a cost benefit if you're paying much lower royalty rates. We'll work with you. But again, my caveat, I want to make sure it gets to the right people. So whether it's playlists, whether it's some other proxy that we're going to have to come up with, we have to recognize that there's a trade-off here. Again, we've looked at the non-commercial world differently than we've looked at the commercial world. Again, I think we've been trying to figure out what's a hobbyist, what's a small business. Is there really a difference? Is someone doing this, should someone doing this as a hobby who wants to be in business but isn't making any money, should they be treated differently? I know when I was a lawyer practicing law, I did a lot of pro bono work for people who never paid me. Unintentionally, of course. But in any event, I think that what we have to look at is, can we make distinctions that actually have a difference? And I think Gary was sort of making that point too. Is there a distinction between a hobbyist and a small webcaster? What are those differences? Come to us and tell us what the distinctions are. I haven't had anybody come to us with a proposal from a group of people saying, okay, here's what defines us from the big players. Here's what defines us from the commercial world. It's a two-way street. I haven't gotten a lot of phone calls from any of you. So
actually, many of us have received calls from you guys.
Well, I'm pleased. Anyway, so I think that it's a two-way street. Let's see if we can't find solutions. I think that's what we ought to be trying to find.
I would just like to say real briefly, and that in the spirit of compromise, that for these smaller stations who've obviously expressed a difficulty in the large amounts of information you may be requiring, and I haven't read the 20 or 21 items, that maybe we could curtail it and make it much less for them so they can do their job, because it seems, and as a small label, we want webcasters of all sizes, and let's not put them out of business, and maybe in the spirit of compromise, try to come up with a smaller number of items. I mean, again, I don't understand why, artist, title, album, catalog number can't work. Maybe there's a way to make it work, and I understand that it might mean more work on Sound Exchange and initially, but maybe there's a way to make it work, and if that helps, I think we should at least give that some consideration.
Okay.
And/or a transition time frame for providing the data as an alternative to an interim regulation. My concern with an interim regulation is that we're in this boat right now where the manual procedures and the software updates that are necessary to collect and report this data can't begin, for the reason that we can't agree on what data is essential to collect. So I think another set of interim regulations is going to cause a lot of revisiting of these same issues and the effort required further downstream. So perhaps what's really needed is not a 3-month phase-in period, but a significant phase-in period during which available data can be provided, and some time frame for saying, okay, after this point, this is the essential data that's needed as we see it from here on out, and from that point on, this is what you provide. I don't know if I expressed that clearly.
Actually,
it's been a long day.
I understand what you're saying very well.
Yes.
One sentence.
I just think it's important for people to remember that at the end of the day, there are thousands of artists who are really in groups that are the smallest businesses.
I think you made that point, but you have emphasized it again. We really do need to wrap it up. We do want to offer the people in the audience an opportunity to be heard. I'm going to urge you to only speak if you believe that your point has not been made, and if you do speak, to keep it as concise as you possibly can. So anyone who wants to speak, now is your chance. Tell us who you are and who you represent.
Hi, my name is Sandra Wasson. I'm with KALX, the UC Berkeley campus radio station. And I just wanted to note that I know that you've said that you've spoken to some people with regards to an agreement, but there are 1,394, I believe, college radio stations, and there is no one organization like CPB or IRAA that, there aren't two organizations that get together to create an agreement. You may create an agreement with Will. He represents, in a sense, I don't know that he can sign a contract for 23 member stations. We have IBS, which has a large number of stations. How many are actually current active members, you can't say. So I think that that's why we rely on the Copyright Office to promulgate regulations that won't affect us onerously with regards to how we do our business. The other thing is that playlist that you were talking about, and you showed a sample of a top 35. That playlist is a paper playlist. We hand tabulate to get a weekly top 35 so that people know, what our most played songs are. But we play thousands of songs a week. I think if you took 12 times the number of hours, you'd get, 1,600, 1,700 songs in a week that are played on the station. And if your top 35 is a couple hundred of those plays, that means there are a lot of individual songs that are being played, and we just could not do the record keeping that's required.
Thank you. Anyone else? If not, I want to thank this panel. You made very important contributions, as did all of the panels of all of the people here today, and those in the audience who came forward and spoke. At this point, I think we have a lot to digest.
I have indigestion.
I still have to pay tuition for 3 kids.
We heard a lot, and I think for the people who work in the copyright office, we really need to coalesce amongst ourselves and kind of take track of where we are. Obviously, we have a regulation that we have to get out, and it's kind of taking a winding road. But for those of you who participated, we'll get, if we're able to, or if we believe that there's any further coalescing of groups or meetings to try to come to grips with some issues, we'll be in touch with everybody. But we really do thank you and appreciate your efforts.
Thank you so much.